Please also have your mobile phones in the silent or the meeting mode, please.
Welcoming our chief guest of the day, Srimati Nirmala Sitharaman ma'am, the Honorable Union Minister and Corporate Affairs Minister, our distinguished guest of honor, Shri Inderjit Singh ji, the Union Minister of State with independent charge of the Ministry of Statistics and Program Implementation, and also the Union Minister of State independent charge with the Ministry of Planning and the Minister of State Corporate Affairs. Also gracing the days are Shri Rajesh Verma, respected Secretary, Ministry of Corporate Affairs, Shri Sanjay Kumar, Additional Secretary and Financial Advisor, Ministry of Corporate Affairs, and Shri Ashok Kumar, Postmaster General, Operations. And also, ladies and gentlemen, welcome to all present here in the August gathering, and also those joining us virtually across 75 locations pan-India. Welcome to all of you to the iconic day celebrations of the Ministry of Corporate Affairs, which are part of the iconic week celebrations, the Azadi Ka Amrit Mahotsav, being celebrated by the Ministry of Corporate Affairs and the Ministry of Finance from the 6th of June to the 12th of June. And ladies and gentlemen, as we celebrate today, it's definitely an occasion and a platform to showcase the immense strides which the Ministry of Corporate Affairs, along with its various institutions and organizations, has been able to make towards empowering businesses and towards protecting the investors, being a very able and an efficient facilitator, integrator, regulator, and educator. And that we have seen that in the past 8 years, there has been a lot of speed, scale, service, and a seva bhav, which has been inculcated in this entire movement under the leadership of our Honorable Prime Minister. So it's definitely a moment to celebrate our achievements and accomplishments. But then it is also a platform towards introspecting and reflecting. And then with our eyes into the future, planning our way forward, our pathways, our targets and milestones, as we all come together towards becoming global leaders and more responsive and responsible global leaders in corporate governance and driving a more inclusive growth for our country with the bhagidari and the involvement and partnership of all. As they say, अतीत से संवाद करते हुए प्रगति के संकल्प के साथ हम अपने भविष्य का निर्माण करें. So this event today, ladies and gentlemen, is towards planning out a blueprint for the next 25 years, the Amrit Kal, leading us to the India at 100 vision, the 2047, when we are going to be celebrating our 100 years of independence. So we would like to sincerely thank our Honorable Minister, Srimati Nirmala Sitharaman ma'am, for joining us today, for leading us today. And as we all know, she has already presented a parallel track to the blueprint for the Amrit Kal in the form of the Union Budget 2022, which is both inclusive and futuristic. And as we now plan our way forward, we seek her guidance and we seek her leadership. So many thanks and gratitude to her from all present here and also joining virtually. And I would like to request our respected Secretary, Corporate Affairs, Shri Rajesh Verma ji, to please accord her a floral welcome, good greetings to her, and our expression of thanks and deep regards to her as we once again welcome her today in this iconic day celebrations of the ministry. Also welcoming Shri Inderjit Singh ji, once again requesting respected Secretary Sir to kindly present the bouquet. The Honorable Minister of State with the independent charge of Ministry of Statistics, Program Implementation, Ministry of Planning, and our Honorable Minister of State for Corporate Affairs. May I now request Shri Sanjay Kumar, Additional Secretary and Financial Advisor, Corporate Affairs, to please welcome Shri Ashok Kumar, Postmaster General, Operations. And ladies and gentlemen, as we draw this future-oriented roadmap for the ministry with all the institutions, it's definitely a beginning of many new beginnings for us and for the nation. So let's mark, as per our Indian traditions and customs, by lighting the ceremonial lamp. And may I request our Honorable Minister, Srimati Nirmala Sitharaman ma'am, along with
our Honorable Minister of State, Shri Inderjit Singh ji, and all present here on the dais to please light the ceremonial lamp. माँ सरस्वती की स्तुति और वंदना के साथ आज के हमारे इस कार्यक्रम का मंगलमय शुभारंभ. And may I now request, as we open the doors to the discussions and deliberations, requesting respected Secretary, Corporate Affairs, Shri Rajesh Verma ji, for his words of welcome for everyone.
Chief Guest of the Day, Honorable Union Minister of Finance and Corporate Affairs, Srimati Nirmala Sitharaman ji. Guest of Honor, Rao Inderjit Singh ji, Honorable Minister of State for Corporate Affairs. Dignitaries on the dais and off the dais, senior officials of the Ministry of Corporate Affairs, other ministries, regulatory bodies, heads of professional institutions, professionals, students, ladies and gentlemen. I extend my warm welcome and greetings to Honorable Union Minister for Finance and Corporate Affairs and Honorable Minister of State for Corporate Affairs for their gracious presence on this momentous day for celebrating Azadi Ka Amrit Mahotsav. It is also my privilege to welcome you all to this iconic event organized by the Ministry of Corporate Affairs to celebrate the Azadi Ka Amrit Mahotsav, a flagship initiative of the Government of India to commemorate 75 years of progressive India and the glorious history of its people and culture and achievements. I am happy to share that this iconic event is the culmination of joint efforts of MCA and various organizations like IEPFA, CCI, IBBI, NAFRA, IICA, ICI, ICSI, Cost Accountant Institute, and many others. Since August 2021, more than 360 events have been conducted by various organizations of MCA under Azadi Ka Amrit Mahotsav. And this week-long program, which started yesterday, we are having programs on every day till the 12th of June, and all the organizations, and we are organizing these programs with Jan Bhagidari across the country. During the iconic week, achievements and new initiatives of the ministry will be showcased. Various organizations of MCA are organizing these events. Corporates and entrepreneurs are also involved in organizing these events. They are the supporting pillars of the economy, and government has taken many measures towards ease of doing business for law-abiding corporates. During last 8 years, MCA has taken a number of measures to ease the compliance requirement on citizens and corporates and has taken several initiatives. While the IBC code was enacted during this period, CSR provisions also enabled corporates to act as a social responsible citizens and contributing to more than 1.2 lakh crore in these years. Various institutions have been established over the last 8 years like NFRA, NCLT, NCLAT, IEPFA and IPPI. IPF Authority has organized more than 65,000 investor awareness programs in collaboration with various institutions. It has also entered an MOU with even IGNU for telecast of 75 programs as part of the year-long activity to commemorate the Azadi Ka Amrit Mahotsav. Ministry was proactive to provide much-needed relief to the corporates and help revive the economy during COVID-19. I'm happy to share that MCA registered 8% more number of corporate entities during last year compared to the previous year. The increase in the number of incorporations in companies, even during the pandemic period, was a result of various initiatives like introduction of integrated form Spice Plus and Agile Pro for incorporation of companies, which has provided one-stop solution to promoters desirous of setting up a business entity in the country. We have taken various measures to decriminalize various provisions of the Companies Act as well as the LLP Act. MCA has been proactively taking legislative measures, keeping in view the needs and requirements of the Indian economy. The professionals and various institutions, as extended arm of the MCA, have a leading role in advising and helping businesses and making India a global leader in various sectors of the economy. We are in the process of launching various tools for compliance management, for e-adjudication, and we are looking forward to technology-driven platforms to facilitate the stakeholders. MCA, in its vision to facilitate greater ease of doing business, will continue to upgrade its process, workflow, and technology to address the needs of the stakeholders. The Amrit Kaal is going to be significant for the journey of corporate governance in India, and MCA, along with its various organizations, shall take all steps necessary to provide enabling framework to the corporates and other stakeholders to make India truly a global power. Once again, I extend my warm welcome to all of you and wish you a very happy Azadi Ka Amrit Mahotsav. Thank you.
Thank you, sir, for further adding the tone and context to our celebrations today. And as we now seek the guidance and advice of our distinguished guest of honor, our Honorable Minister of State for Corporate Affairs, I request Shri Inderjit Singh ji for his address.
Honorable colleague and Senior Minister, Srimati Nirmala Sitharaman ji, Secretary Corporate Affairs, Shri Rajesh Verma ji, officers of the Corporate Affairs Ministry and other ministries, regulatory bodies, professional institutions, ladies and gentlemen. Mr. Rajesh Verma has just given a lowdown on the ministry as a whole and its regulatory bodies and the functions that they have undertaken over the last few years. With the permission of the chair, I would like to digress a little. We are celebrating the 75th year of our independence. In the lives of individuals, 75 years is a lifetime. Some may not even make it. And the fortunate few who do are on the decline. Whereas when you compare an individual's life with the life of a nation, 75 years is of little significance, especially for a country like ours. Long history, long tradition, respect globally over hundreds and hundreds of years. And they say history repeats itself. And if history was to repeat itself, can we, in the coming years, recapture what glory we once had? Let us say at the beginning of the Indus Valley civilization, 2000 years plus. India was a great nation. India continued to be a great nation for the following 1500 years. And if world economists, either from the World Bank or from universities across the globe, were to be believed, there was a time when India constituted 1/4 to 1/3 of the global economy. Till the 1500s. In the 1600s, when Aurangzeb was in India's Delhi throne, the yearly taxes into this gentleman's coffers was 100 million pounds. A sum which the so-called British Empire, on which the sun never set, could not achieve even 200 years afterwards, till the 18th century. And what happened in the 18th century? They found a foothold in India. And a small island nation exploited the resources of this vast country, which had all the natural phenomena that one would require for development. We had the Himalayas, which acted as a barrier, we had rainfall, we had agriculture, we had peace. And because of that, India not only survived, proliferated, and became a world economic power. Now, like I was saying earlier, 100 years in a nation's life is a very small amount of years. But because of technology, 100 years, say in 2022, cannot be compared with the 100 years in 1000 BC. Development is now going on at a geometrical space. And what we hope to achieve under the guidance of a Prime Minister and of course the Finance Minister under Mrs. Nirmala Sitharaman and all the able officers represented here, is to multiply that geometrical progression further, leapfrog those development years. We missed the Industrial Revolution, but can we leapfrog that Industrial Revolution and find our rightful place in the Committee of Nations in the next 25 years? The possibility is there. The statistics are there. The question is, are we willing to put our shoulder to the plow? For the next 25 years, can we dream and can we fulfill that dream is what the 75th year of our independence celebrations is all about. As capsulized today by this iconic week with the Government of India, not only the Ministry of Corporate Affairs, but all Government of India ministries and departments are celebrating. And just to buttress my point, I would like to put forth a few statistics. In the year 1314, when Prime Minister Narendra Bhai Modi became the Prime Minister, India growth was at 6.4%. In the year 21-22, as the latest report says, our growth, the growth of our GDP is 8.7%. The intervening 2 years, 3 years of COVID, in spite of that, we have reached a target of 8.7%, which was before we took over the reins of power in India. And when we compare ourselves with the rest of the world, who also undertook this arduous journey of fighting COVID, how have they performed and how have we performed? If we take a balance, then we realize that we are a little ahead of the rest of the world, including developing countries, except China. Well, I will not mention China because they have been able to control their population. Somehow, we still have not been able to address the population issue in the way that it should have been addressed. In the beginning of the 15th century, China was a few percentage points behind us. Today, it's a few, it's leapfrogged many percentage points ahead of us. And my personal view, of course, is that it is attributable to the large population that has come about over the last 50 years. But getting back to what I was talking about, India today is developing at 8.7%. This is the projection. By 2030, it will have progressed at 14.3. By 2040, it will have progressed at 20.8% annually. USA, in 13-14 financial year, had a growth rate of only 1.8%. In 2021, it has a growth rate of 5.7%. In another 5-6 years from now, in 2030, it will have a growth percentage of 15.3%. And in 2040, it will have a growth percentage of 13.9, which is about 6 percentage points less than India's. As things stand, the world's biggest economic power is going to the way the British Empire went, down the slide, down the chute. And India, hopefully, if we can live up to these expectations and projections, we will be at the top of the ladder. Germany, a country which has faced 2 world wars and has still built itself up. At the beginning of 2013-14, it had a growth in its economy of only 0.5%. In 21-22, they managed to achieve 7.4%. But by 2030, they will decline to 2.8%, and by 2040, they will decline even further to 2.3% of the GDP. Heartening news for Indians. Can we, now that we are on the upswing, can we maintain that momentum? And the countries that we looked up to, and I specifically wish to speak about the 400-500 years of British rule. No, not sorry, the 200 years of British rule. When the British left this country, Indian economy was growing at only 3%. When British arrived in this country in 1800, they were given on a platter a country whose GDP per annum was 24% as compared with the world economy. 24% of the world's economy was Indian. In 200 years, they exploited us to such an extent it came down to 3%. So, here's the challenge. The world is declining. The world economies are declining, except for China, who was our neighbor and maybe our antagonistic neighbor. Can we live with this reality of fighting China economically? Can we live with this expectation that the world economists have vis-a-vis India? Can we live to the expectation of the youth of our country? And can we live up to our history of 2,000 years? This is what the challenge is all about. This is what 75 years of celebration is all about. This is what technology-driven enterprises can achieve only if we were to put a mind and hearts to it. So I thank you all for having joined us today at this iconic week. And I hope that you and I together, the Government of India, Mr. Modi's guidance, and all our joint efforts will project India into the space and into the sphere that it really deserves. Thank you very much.
Thank you so very much, sir, for inspiring and motivating everyone, and the huge progressive change which you see in India, and India becoming, as you said, the coming decades, in fact, belong to India, showing that so much of optimism and inspiring and motivating everyone. And now, ladies and gentlemen, we have a series of releases which are going to be dedicated to the nation at the hands of our Honorable Minister, Ma'am, Shrimati Nirmala Sitharaman, Ma'am. And the very first, as a part of the celebration of the Azadi Ka Amrit Mahotsav, the Ministry of Corporate Affairs, in association with the National Foundation for Corporate Governance, presents a short film that traces the evolution of the corporate governance in India. It also highlights the significant initiatives which has been taken by the MCA, more particularly in the last 8 years in the areas of corporate governance, so as to facilitate an ease of doing business and an ease of living for the citizens. May I request our Honorable Minister, Ma'am, Shrimati Nirmala Sitharaman, Ma'am, to please launch the film entitled Journey of Corporate Governance in India, a Panorama, with a click of the remote.
As part of the celebration of Azadi Ka Amrit Mahotsav, the Ministry of Corporate Affairs, in association with the National Foundation for Corporate Governance, presents the Journey of Corporate Governance in India, a Panorama. The framework of corporate governance in India has evolved through enactment of various acts, framing of rules and regulations based on the principles of good governance, fairness, accountability and transparency. The Indian corporate laws have evolved and transformed in the last 75 years. The Companies Act 1913 was followed by the enactment of the Companies Act 1956. The economic policies introduced in the 1990s expanded the role of the corporates in various sectors, while the economic model shifted from command and control to a facilitative and entrepreneurial approach. The government in the past has taken various measures for putting in place a robust corporate governance framework. Recommendations made by various committees like Kumar Mangalam Birla Committee, Naresh Chandra Committee, Narayana Murthy Committee, Dr. J.J. Irani Committee culminated in the enactment of the new Companies Act 2013. A number of regulatory, statutory and non-statutory bodies were established, which included the National Foundation for Corporate Governance, the Serious Fraud Investigation Office and the Indian Institute of Corporate Affairs. These steps were supplemented by complete digitization of corporate registry through first mission mode e-governance initiative in India, the MCA 21. To cater to the philosophy and needs of a liberalized economy, the erstwhile MRTP Act 1969 has been replaced with the Competition Act 2002. In 2008, the LLP Act was passed to provide a new statutory framework to conduct business. Keeping in view the ease of doing business and ease of living, significant measures have been taken in the last 8 years in the area of corporate governance. Corporate social responsibility or CSR has been mandated for a certain class of companies with effect from April 2014. In the last 7 years of implementation of CSR laws, companies have spent more than 1.20 lakh crore rupees in different activities. The dissolution of the Company Law Board led to the constitution of National Company Law Tribunal and the National Company Law Appellate Tribunal to bring Indian insolvency framework at par with global standards. The Insolvency and Bankruptcy Code 2016 was enacted. In 2016, the Investor Education and Protection Fund Authority was established to educate and protect the interest of investors and refund the unclaimed dividends and shares to the rightful claimants. National Financial Reporting Authority was set up for promoting high-quality accounting and auditing standards. With the objectives of building capacities and professionalization of independent directors, a national-level repository in the form of Independent Directors Data Bank was created in 2019. As part of digitization, the Central Registration Center was established for incorporation of companies and LLPs. Spice Plus, an integrated web form, has been launched, offering multiple services to the newly incorporated companies, thereby saving many procedures, time and cost for starting a business. To facilitate ease of doing business and ease of living to the wealth creators and declogging the courts, various provisions of the Companies Act 2013 and LLP Act 2008 have been decriminalized in the last 3 years. During the COVID-19 pandemic, various policy measures were taken to enable the companies to function without any disruption by allowing the board and general meetings to take place through video conferencing or other audio-visual means, allowing e-voting, etc. Relaxation was also given under the Insolvency and Bankruptcy Code. Simplification of laws, digitization and transparency have resulted in India being seen as an attractive destination for investments and doing business. The aim and resolve now is to become the global leader in corporate governance through involvement and partnership with all stakeholders when India celebrates her 100 years of independence in the year 2047.
So that's the accomplishing journey of the Ministry of Corporate Affairs with all of you. And now, ladies and gentlemen, we have the release of the investor oath, which is now going to be seen and witnessed by the present and the prospective investors, by all of you present here, and also those joining us virtually at 75 locations pan-India. This oath inculcates and instills a spirit of being responsible investors and contributing to nation building. May I once again request our Honorable Minister Ma'am, Shrimati Nirmala Sitharaman Ma'am, to please release the investor oath with the click of the remote.
आगे बढ़ता रहे हमारा देश, इसके लिए संकल्पित है भारत सरकार। इन्वेस्टर एजुकेशन एंड प्रोटेक्शन फंड अथॉरिटी मिनिस्ट्री ऑफ कॉर्पोरेट अफेयर्स के प्रयासों से जुड़े और उन प्रयासों को करें साकार। आइए लें संकल्प ताकि एक सुदृढ़, सुरक्षित और सशक्त राष्ट्र ले सके आकार।
हम संकल्प लेते हैं कि हम जागृत निवेशक बनकर अपनी और देश की वित्तीय स्थिति को सशक्त करने के लिए निरंतर प्रयास करते रहेंगे।
हम संकल्प लेते हैं कि हम वित्तीय उत्पादों के विषय में पूरी जानकारी हासिल करेंगे और दूसरों से भी साझा करेंगे।
हम संकल्प लेते हैं कि हम सुरक्षित एवं समावेशी निवेश के लिए भारत सरकार द्वारा बनाए गए सभी मानकों का जिम्मेदारी पूर्वक पालन करेंगे।
विज्ञापनों और भ्रामक विज्ञापनों से आकर्षित नहीं होंगे और योजना से संबंधित सभी जानकारियों को ध्यान से पढ़ेंगे और गैर कानूनी पाए जाने पर उनकी सही स्तर पर शिकायत करेंगे।
किसी अनजान स्रोत से मिलने वाली जानकारियों एवं सलाहों के आधार पर वित्तीय जोखिम नहीं लेंगे, बल्कि अपनी कुशलता और निवेश का ज्ञान बढ़ाएंगे।
निवेशक को मिले खुशहाली, सुरक्षित हो हर निवेश, बढ़ती रहे जन भागीदारी, यही है भारत सरकार का संदेश।
That's the sankalp, the commitment coming from everyone. And we now have the release of my stamp on financial literacy and investor awareness. May I request Shri Ashok Kumar, Postmaster General Operations, to kindly present the first copy of the album of my stamp to the Honorable Minister Ma'am, Shrimati Nirmala Sitharaman Ma'am, for the release. Ladies and gentlemen, with the very objective to make respective stakeholders understand about IEPFA, its mandate, its initiative for public interest, and the roadmap ahead for investors' awareness. This is the stamp of ₹5 being issued, carrying the very message of inclusive financial literacy as well as IEPFA is also coming up with a very unique initiative for the senior citizens aged 75 and above. That's a special window facility for the senior citizens in which a senior citizen can avail the facility of auto-prioritizing through the MCA 21 portal while filing their refund or claim settlement. Once again, requesting Honorable Minister Ma'am to please launch this special window for the senior citizens with the click of the remote.
भारतीय संस्कृति ने हमेशा हमें बड़ों का सम्मान करना सिखाया है। भारत सरकार भी वरिष्ठ नागरिकों के लिए लगातार नई से नई सेवाएं और अवसर ला रही है। इसी कड़ी में निवेशक शिक्षा और संरक्षण कोष ने 75 वर्ष एवं उससे अधिक उम्र वाले सभी निवेशकों के लिए स्पेशल सेवा की शुरुआत की है। IEPF समय समय पर देश के विभिन्न राज्यों में कॉन्फ्रेंस के माध्यम से SMS सर्विस द्वारा, अखबारों में संदेश देकर, अपने सोशल मीडिया हैंडल्स पर एवं टीवी और रेडियो के माध्यम से वरिष्ठ नागरिकों को सही निवेश और फ्रॉड स्कीम से अपना धन बचाने की जानकारी दे रहा है। इसके अलावा उनकी सुविधा के लिए निवेश की सही जानकारी और क्लेम का स्टेटस जानने के लिए एक ऐप भी लॉन्च किया है।
क्या कर रहे हो पापा? कुछ नहीं, ऐसे ही छोटा सा काम कर रहा हूँ। कौन सा काम पापा? मेरे कुछ शेयर सर्टिफिकेट्स हैं, उनका क्लेम लेना है, तो उन्हीं का फॉर्म भर रहा हूँ।
लेकिन पापा, क्या इसके लिए फिजिकल डॉक्यूमेंट भी जमा करने होंगे?
किस जमाने में जी रहे हो बेटा? ये डिजिटल इंडिया है, सब काम ऑनलाइन होता है। और अपना इन्वेस्टर एजुकेशन एंड प्रोटेक्शन फंड अथॉरिटी भी डिजिटल हो गया है। और यही नहीं, 75 वर्ष के सभी निवेशकों के लिए एक हेल्पलाइन नंबर भी जारी किया गया है, जिससे घर बैठे बैठे आप अपने क्लेम का फॉर्म आसानी से भर सकते हैं।
दादाजी, क्या मैं भी आपके साथ कर लूं?
निवेशक शिक्षित तो निवेश सुरक्षित।
So that, ladies and gentlemen, are our confident and very empowered senior citizens with this special window. And we now have the launch of the National CSR Exchange Portal. This is a digital initiative on CSR by the Ministry of Corporate Affairs. The portal will facilitate matchmaking and bridge demand-supply gap by providing an interactive platform to all stakeholders. It also will enable the stakeholders to list, to search, to interact, to engage, and manage their CSR projects on a voluntary basis. Once again, requesting the Honorable Minister Ma'am to please launch the National CSR Exchange Portal with a click of the remote.
National CSR Exchange Portal is being launched today. Government of India initiated one of the world's largest experiment of introducing the CSR as a mandatory provision in the Companies Act 2013 by imposing statutory obligation on companies to take up CSR projects. The philosophy of CSR is to engage corporates as partners in social development by leveraging their managerial efficiency, best practices, technology, and innovation in the delivery of public good and services. Since the enactment of the CSR provision with effect from April 2014, companies have spent more than 1,20,000 crore rupees in different activities of national priorities. During the evolution of CSR in India, need for seamless interaction between companies and implementing agencies has been felt. National CSR Exchange Portal is an endeavor that will serve as an interactive and exchange platform hosting all India projects. The platform will onboard all stakeholders in the CSR ecosystem, such as corporates, implementing agencies as registered users. National CSR Exchange Portal will provide user-friendly environment, interactive mechanism, advanced visual analytics, project lifecycle management, data exploration, knowledge center, notifications, advanced search mechanism. Launch of the Exchange Portal will facilitate for more effective sustainable development in the country by helping optimize the funds mobilization and utilization, execution and project management. Now let's see how it works. Both companies and implementing agencies will have their separate dashboards. Companies can float RFPs for their CSR projects. Implementing agencies can apply to RFPs with their proposals and can also share their own project plans to companies. On meeting mutual requirements through exchange, the project could be initiated for implementation. The portal would also facilitate bringing together diverse think tanks, contributors and implementers under one platform, sharing ideas, strategies and information by taking a smart step in implementing CSR initiatives. The Ministry of Corporate Affairs launches National CSR Exchange Portal. Log on to www.csrexchange.gov.in.
This portal, ladies and gentlemen, is a testimony to the very idea that technology empowers the less empowered. And may I now request the Honorable Minister Ma'am to kindly release the publication on the theme Insolvency Now and Beyond. This has been prepared by the Insolvency and the Bankruptcy Board of India and the Foreign Commonwealth Development Office, UK, for the benefit of stakeholders of IBC ecosystem in India. This publication, ladies and gentlemen, is a compilation covering UK experiences and best practices on the emerging areas and also the issues under the insolvency ecosystem in India. The papers in the publication have been authored by prominent experts from various jurisdictions, including India, UK, and Singapore. Ladies and gentlemen, IBBI, in collaboration with mygov.in and BSE Investors Protection Fund, had conducted the third national online quiz on Insolvency and Bankruptcy Code 2016. This was towards promoting greater awareness and sensitizing and understanding of the code among the various stakeholders across the country. The quiz received very overwhelming response, participation from more than 71,000 participants from a wide range of stakeholders, including the students, professionals, employees, representing various states and union territories of the country. And we now have the prize distribution ceremony towards this national online quiz competition on IBC 2016. As I invite the winners here on the stage, may I request our distinguished dignitaries, honorable ministers, and all the dignitaries to please step forward in honoring our winners today. So there are three awards or prizes which are going to be presented here. And we are going to be starting with the bronze, going bottoms up. So the second runners-up, ladies and gentlemen, is Pankaj Ninwani, who's conferred with the bronze medal, along with a cash prize of 25,000 rupees. And so there's a medal, the bronze medal, and also the prize money of rupees 25,000 rupees. And now the first runner-up. The first runner-up, ladies and gentlemen, is Kishan Verma, honored with a silver medal and a cash prize of 50,000 rupees. He's not been able to join for some reasons, but we have Shri Raghav Maheshwari joining us here on the stage to accept the award on behalf of Kishan Verma, the first runners-up, conferred with a silver medal and a cash prize of 50,000 rupees. And now, ladies and gentlemen, all the bling with the gold medal conferred on Dipali Mamodia. She's been presented a gold medal along with a cash prize of 1 lakh rupees. So this was a national online quiz which was organized on Insolvency and Bankruptcy Code 2016, and the 3 winners, the best of the best 3 winners being recognized here. May I also request now our Honorable Minister Ma'am to please release the e-book, a compendium on CSR with the click of the remote. Can we have... So that's the e-book, ladies and gentlemen, for the benefit of stakeholders and ease of accessing the information. The Ministry of Corporate Affairs has compiled all the existing knowledge resources on CSR, that is the CSR provisions of the Companies Act 2013, the Companies CSR policy rules, Schedule 7 of the Act, various clarifications and the facts issued by the Ministry. It also captures the data on CS expenditure in aspirational districts, all being compiled into a single source and prepared in the form of this e-book compendium on CSR. So thank you to our Honorable Minister Ma'am for releasing these various publications and the other launches, and also for honoring the quiz winners. Thank you. And now, ladies and gentlemen, as all of us are eagerly awaiting to be guided and to be led by our Honorable Minister, may I request Srimati Nirmala Sitharaman Ma'am, the Honorable Finance and the Corporate Affairs Minister, to please address the august gathering.
Namaskar. Shri Rajesh Verma, Secretary of MCA, Sanjay Kumar ji, Additional Secretary and the Financial Advisor, Shri Ashok Kumar ji, Postmaster General of India, and all heads of the regulatory bodies, institutions which impart education on various corporate related subjects, officials, invited guests, and the media. Today we are here following up on the inauguration which the Honorable Prime Minister did yesterday, both for the Ministry of Finance and also for the Corporate Affairs, which during this week will be celebrating the Azadi Ka Amrit Mahotsav. In other words, taking the opportunity to be able to communicate with the people of India as to how this journey of 75 years has been, what role that the ministry has played in the lives of Indian citizens for the 75 years, and also putting before ourselves what the next 25 years are going to be when India reaches the 100th year of India's independence. So actually speaking, this is a very important phase in free India's life, where government comes before its citizens, even as it marks 75 full years of its independence, to say what these 75 years have been in governance, in being accountable, and in being responsible towards making the lives of citizens better. So, Honorable Prime Minister had started this Azadi Ka Amrit Mahotsav in 2021 in March, when he participated in the Salt Satyagraha once again in Dandi. And from then, 75 weeks up to August 2022 will be part of the Azadi Ka Amrit Mahotsav. However, of course, even after August this year, till August 2023, Azadi Ka Amrit Mahotsav will be continuing so that we are able to do so many different things. Recall the sacrifices made by the freedom fighters. Who were they? Which regions they belonged to? What kind of sacrifices they did? Does this younger generation have the same opportunity to know and appreciate them? As much as also saying what kind of challenges this country has faced from 1947 till today, and despite all those challenges, have reached where we have reached today, and where we have reached today, I'm sure all of you all will agree, subject to some conditions, that it is something about which Indian citizens can feel happy and proud about, that despite all the differences, despite all the challenges, despite all future problems that we may have to overcome, we together as a country, center and states, people from all different regions, have, as a democracy with all the rights intact for individuals, have pulled along to reach where we are today, and therefore it is important for us to pause for a minute and look back and see what these achievements have given us, or the challenges that they have posed us, and how to take us forward in the next 25 years. Whilst I'll be part of Corporate Affairs Ministry and also the various departments in the Finance Ministry, I think the Corporate Affairs Ministry is uniquely placed in dealing with this Azadi Ka Amrit Mahotsav. It is uniquely placed because it's a regulatory ministry. It has under it so many very critical, very important regulatory bodies. And as we saw in that picture which was shown about MCA and its contribution in the last 75 years in its various different avatars, it clearly shows, though it's a regulatory ministry largely, how it has impacted the lives of common Indians, be they in small business or a part of a larger business or even a small investor. How during these 75 years, catching up with what's developing, the ministry has evolved the various instruments through which it relates to the common Indian citizen. The various laws that it had to revisit and change and keep it up to date are all very clearly shown in that very crisply made film. But I would certainly say that while the rest of the departments of Finance Ministry also have their own complex relationship with the citizens of India, Ministry of Corporate Affairs is certainly uniquely placed while facilitating even as it is regulating. The two examples I can take right up front are the ways in which the Companies Act and also the IBC, in order to keep itself robust, time-relevant and nimble, have continuously kept responding to the need of the hour, need of the day, and the global best practices, and therefore didn't fight shy of going to the Parliament any number of times with amendments. And therefore, I would think the Corporate Affairs Ministry has so much more to talk about and to relate and, in fact, directly or indirectly inform the public about the ways in which this Azadi Ka Amrit Mahotsav can tell us where we are and take the feedback of where we have to go and how we have to go in order to reach 2047. I'm sure the institutes, the Institute of Chartered Accountants of India, Institute of Cost Accounts of India, and Institute of Company Secretaries are very potent bridges for and through their students, through their practitioners, through their certified members, to communicate this to the people of India and be able to also get the inputs from them to see how this ministry can take it forward further. For my part and for the part of the Government of India, I can say, whilst every decade had its own significant contribution, particularly after 2021 budget, I think the nature of the economy, whether it is thankfully to the COVID, which was a challenge, but that challenge, I'm glad to say that the ministry literally kept itself on its toes, that it could come up with so many different quick-footed steps that even during the lockdown or during the pandemic, people of India could go about their normal businesses, particularly those in small companies, could go about their normal businesses without having to worry if compliances are going to be challenged, if compliances are not going to be kept up, purely because they're all under a lockdown. But on the contrary, what we find, and I'm sure the data is available for all of us to know and validate, if we observe that contrary to the fears and suspicion, India set pioneering steps forward in enabling companies to keep fulfilling the compliance norms by opening it up to be digital, allowing video conferencing, keeping on, technology-driven answers when you really couldn't meet in person. So I must say that a department like Company Affairs was very imaginative enough to come up with technology-driven solutions and make the lives of Indians, companies, small investors, and certifying bodies, and small chartered accountants who were in their own local areas doing their businesses far easier to do their compliance and regulatory performances without worrying, because technology was available and handy. Now, if that was the case from 2020, 21 and 21, the budget of 22, in fact, looks forward for the Amrit Kal, for the next 25 years. And in that too, I'm sure the Corporate Affairs Ministry will be able to take forward quite a few of their forward-looking and out-of-box thinking steps. And I would say, if each of the earlier decades had its own character, the decade of 2020 upwards to 2030 or even further is so distinctly infused with digital methods. No wonder, therefore, in the budget of 2022-23, we had so many announcements, all of which are digital, whether digital currency, digital university, digital banking, and looking at ways in which we can further strengthen digital payments. Therefore, I would think this decade for the MCA, adapting to the digitized performances, which is going to make our lives easier, is going to be one big challenge. And I'm glad I saw the presentations this morning of the various agencies, which are largely regulatory, the Competition Commission of India, the NFRA, the National Financial Reporting Authority. You can clearly see all of them are seized of the fact that the world is moving towards greater digitization, and in that, India leads by having come up with the India stack, with which a lot of our functions are happening digitally. So the impact of this digitization is certainly going to have an impact on the markets, and if it has an impact on the markets, obviously the Competition Commission or the National Financial Reporting Authority will all have to be ahead of the curve to see where the regulations will have to fall in place, where the regulations should be soft touch, where the regulations will have to be deterrent strong enough. And therefore, I think this feature that the next 25 years will be digital and driven by digital considerations, because that's become now a habit, good habit, easy habit. We need to have agencies ready to be able to gauge what that is going to do to fair, accountable, and transparent practices. And therefore, I would seek to draw the attention of all the regulatory bodies to be seized of this fact that this is now going to pervade all aspects of our society. We cannot be behind the curve. The regulators will have to understand at what level and with what effect you need to come in. And you have to be well advanced in understanding the situation rather than be caught unawares. This also, of course, gives the challenge of digital, the black dark world, which can do things in the digital arena, which can itself be a big threat. So it's very well for the regulators, it's very well for the institutes, it's very well for those who are coming out of these institutes to benefit from the digitized era. But we also need a strong manpower, which is going to be constantly looking at ways in which they can evolve the firewall mechanisms which are so required to safeguard the digital enabling platforms, the digital world that we have created for our convenience now. And the convenience has been tasted by every Indian citizen, in the smallest in the villages or even the most sophisticated in institutions. Now, every institution, therefore, I would think, will have to equally give attention to experts who will have to be with you on a constant basis, understanding the challenges where they come from, and strengthen and make robust your firewall mechanisms. Or else that which made our lives easy, that which is making our lives continuously easy, can itself become the biggest handicap if we are not able to prevent any unforeseen disaster that can be in the name of a hacker or a person who can misuse this technology, which is today so full of promise, but it shouldn't become a deterrent. Now, there are just two things that I'd like to draw the attention of the August gathering here today. During the pandemic, the MCA did perform, as I said, its roles with a lot more future-looking approach, and also understanding that that's an opportunity for us in reducing government's presence and maximizing on governance. So I think with all that, it didn't become a deterrent or a handicap. It didn't become a deterrent or a handicap, but it actually enabled people during the pandemic, is proven by the statistic before me. I'd like to share that with you. During the financial year 21-22, MCA registered more than 1.67 lakh company incorporations. And if you compare that with the earlier year, 2020-21, when it was only 1.55 lakhs. So if 1.67 lakh companies got incorporated during the year 21-22, it shows that the mechanism through which they are registering are, one, easy, two, also that the ground is not deterred by or challenged by or made difficult by the pandemic. Equally, the kind of steps which were taken by the MCA, who were transforming the regulatory environment, are worth recalling. There was a revision of the definition of small companies, which has reduced compliance burden to about 2 lakh companies. This happened during the pandemic, and I would want to put it on record here for us to know that a ministry like Corporate Affairs was actually on its toes, making sure that during the lockdown, companies are not put to difficulty. So a definitional change also happened at that time. Then there was 0 MCA fees being collected for company incorporations up to 15 lakh rupees of authorized capital. 0 MCA fees. Then there were incentivization of incorporation of one-person companies, the OPCs. Incentives were provided. This happened during the pandemic. So if we are looking at the ways in which in 75 years, the Ministry of Corporate Affairs responded to the growing needs of the free India, but the challenging period of the pandemic also kept them very related to the ground and responding to the needs of the ground. So incentivizing one-person companies. Very important, and an effort which shall continue, is the decriminalization of technical and procedural violations. Decriminalize them under the Companies Act 2013 and also under the Limited Liability Partnership Act of 2008. That, I think, is a very important step taken, particularly during the pandemic. The time given, time for consultation, all taken on board. Decriminalization actually is something which the Prime Minister has been very keen on, because his message has been, trust your businesses. Give them that confidence that government is looking at them favorably, because we want them to do their business without worry and prosper. It is that which is going to help India to move forward. Not if you're suspecting them in every measure, every step. And therefore, decriminalization is something which the Honorable Prime Minister has been insisting. And I'm glad during this pandemic, the time was effectively utilized by MCA to remove those clauses or amend those clauses, which brings in that element of criminalization. Also, I probably mentioned it earlier, that during the pandemic, just so the companies can continue with the general body meetings, video conferencing was allowed for board meetings, for EGMs and for AGMs. Now, if this was done, equally, the NCLT, the Company Law Tribunal, enabled e-filing mandatory at all its benches across the country under the e-court initiative. Even this was done by the NCLT. I would very quickly like to put on record and also compile the reforms and initiatives which have been taken by the other organizations, all of which come under the MCA, whether it is the IEPF, the Investor Education Protection Fund Authority, which have been very effectively shown in the film. They have simplified many of those processes through rationalization of various requirements for it. Similarly, they've already said that 62,000 investor awareness programs have been held by IEPF. In a way, I would think, quietly, these have helped during the pandemic, the very significant increase in retail investor numbers in India. In fact, there are times when I've answered, even in the parliament, that if FPIs are going away and coming into the country as and when, and giving us a feeling that funds are going out of India, retail investors in India have come in a big way, that they seem to act like the shock observers. If FPIs went away, FIIs went away, our markets did not really have to show the ups and downs in a very distinct way, because the small investors in the country have come in a big way, trickling into the country. And that is one of, I would think, in the 75th year for us to be able to say that Indian investors, the small and the big and everybody, are coming into the market and coming in with greater awareness being given by institutions like IEPF. I'm very happy, and I would think that brings the benchmark a bit higher for IEPF itself, because the next 25 years you have even better to perform and improve your own standards. So 62,000 investor awareness programs have not gone without being noticed and without having a concrete outcome. So I'm glad for that. The Institute of Corporate Affairs plays a significant role also in supporting organizational reform and in capacity building, also under the MCA. So I think the Amrit Kal, we have quite a few number of institutions under the MCA who are going to have to build a lot of information platforms and get in touch with citizens of India to say what you're up to. IACA, the Corporate Affairs Institute, also has done a policy advisory function which has helped us to, be able to change the IBC, deliver on very many of these corporate social responsibility related matters. I can see the members of IICA seated there. Your role is very significant and you have to keep performing much more there. I think also because today the public outreach and the research and study with the stakeholders on board is one big step that the IICA has taken, and I think that will definitely make a big difference. You should continue on that. Similar such role, and for a body which is fairly new, is being performed by the Competition Commission of India. The CCI has made a major contribution, and I'm very proud of this institution in being able to burst cartels, not allowing cartels to be formed, making their presence felt but not really becoming an obstruction. So bursting cartels, controlling mergers in a very soft but significant way, giving consumer the necessary protection, making sure that the markets feel that they are being remotely but silently being controlled, in the sense understanding the market and allowing it to function in a free and fair manner but without interfering in their function. And also enabling new age markets, international cooperation, and so on. I honestly think the Competition Commission of India, when of course I'm in their private audience, in the sense when I attend their CCI programs, I keep telling them, you've not done enough, you've not done any number of suo motu studies, you've not picked up on certain things which are very critical for India, your presence will have to be there, felt by everybody, and so on. But for a minute, let me imagine that this road doesn't exist, nobody's here. They are actually doing a significant job in making sure India's free market is fair market, and making sure in an era when mergers and acquisitions are going to happen in a very big way, mergers and acquisitions are happening in India in a big way, the CCI is remaining like a shadow but without affecting functionalities. So I wish the CCA in the next 25 years also makes sure that a modern India, digitized India, a corporate India, an India where retail investors want that support, CCI will stand up to the challenge and meet the expectations of the Indian citizen. A recent, but I'm treading on a bit of a sensitive area. Like in the Western world, they would say you're treading on a minefield, but I'm not treading on a minefield, but an institution which has yet to make a very big beginning, but has a role to play, is the National Financial Reporting Authority. I think they have a big role in that they are looking at listed companies, they are looking at not so listed companies, but of a certain stature. They're also looking at firms, and they should also expect that the government will also come up with requests on certain companies on which I would want them to understand the significance as our institutions abroad. And this morning I heard the chair of NAFRA telling me, I don't know, there is also hesitation in using the word NAFRA. It's nothing to do with Nafrat. It is National Financial Reporting Authority. which has a very big role to play, is the size of the job, the audience that they are dealing with, the companies that they are looking at, and the stakeholders who they are going to have to address. I'm being told by the chair is comparable exactly with their counterpart in the United States of America. But they are recent, they are in the US, fairly old body. But NFRA is again a body which has to do quite a lot of work. And I understand you have issued financial reporting quality review reports. You've also had 4 audit quality review reports, and you're also now looking at recommending amendments to various rules and regulations. I wish the body all success. You also have to catch up with a lot of work which is now before you, and I hope in the next 25 years this body also will stand up and meet the demands and expectations of the people of India. Very quickly on the National Foundation for Corporate Governance, definitely you're trying to have a lot of voluntary adoption of good corporate governance practices. I wish all the very best even for the corporate governance body. So for the next 25 years, not just this week, this gives us an opportunity for us to be able to speak about our achievements, but more to think in terms of a futuristic, visionary, for a fresh new India which is so bubbling with the youth, all of whom want to be in this country but receive the best of global practices in terms of running their companies, in terms of meeting with expectations of people who give them equity fund or people who are providing debt funds. We need to have government and government's policy giving them that little hand-holding rather than being a tough regulator. So I'm in the midst of a ministry, institutions, and regulators, all of whom are strong regulators. But your profile itself will have to be of a facilitator. Your profile will also have to be those who are showing the light on the path in which this country will have to go, so that the youth of India will not just be looking for jobs, but will be creating jobs and delivering on innovative ways of living our lives. So thank you very much for giving me this opportunity, and I wish all of you all the very best for the next 25 years. Jai Hind.
Thank you so very much, Honorable Minister Ma'am, as our leader, complimenting everyone here, all the institutions, for the good work done by them during the COVID, and also guiding and leading everyone on the very prominent and significant role which everyone has with technology at the core of all transformations towards making India globally competitive, India which is looked up to, India which is a global leader in all respects, and where there is a good quality of life for its people. Thank you, Honorable Minister Ma'am, for guiding us. And ladies and gentlemen, as we conclude this inaugural session, a very important session, may I now request Shri Sanjay Kumar, the Additional Secretary and Financial Advisor, Ministry of Corporate Affairs, to please propose a formal vote of thanks.
Honorable Minister of Corporate Affairs and Ministry of Finance, Shrimati Nirmala Sitharaman ji, our guest of honor, Shri Inderjit Singh ji, Secretary, Minister of Corporate Affairs, heads of various regulatory bodies and other organizations, all senior officials, dignitaries, ladies and gentlemen. At the outset, I would like to offer my sincere gratitude to Ma'am, Honorable Minister, on behalf of the entire MCA family, Minister of Corporate Affairs family, for sparing time to attend this iconic day and making it truly iconic. Ma'am, we can't sincerely thank you enough for sparing your valuable time and motivating us with your gracious presence and by your truly inspirational speech, ma'am, emphasizing on good governance, backed by technology and more transparency. Ma'am, you have kindly mentioned some of the good works done, some of the achievements made during last 3 years. All this has been possible with your kind guidance and encouragement only, ma'am. This ministry, as you mentioned, is uniquely placed, and we have already, as you mentioned, we have made good contribution to the building of country's economy, and we will ensure that we attain further glory with your kind guidance and your leadership, ma'am. I'll also like to thank our guest of honor, Shri Inderjit Singh ji, for his mentorship and valuable guidance and support throughout the preparations, especially for the very inspiring thoughts how in the next 20-25 years, backed by solid and concrete statistics, how we can really go back, achieve our old glory. Really thanks to you, sir. On behalf of the ministry, I'd like to thank Shri Rajesh Verma for his constant and all-along support, guidance and direction for all these works which we are doing. I'd also like to offer my sincere gratitude to all the dignitaries, all the guests and invited panelists for the upcoming technical and plenary sessions, for accepting our invitation and adding value to this iconic ceremony. Ma'am, we would like to thank you for releasing short film on corporate governance, commemorative postal stamp on investor awareness, investor oath, e-book on CSR compendium, publication on IBC, launching of the CSR exchange portal, and special window facility for the senior citizens, which will go a long way in easing the way we conduct our business and understand the financial world, and also presenting awards to the winners of the National Online Quiz. Last but not the least, I would like to thank Shri Manoj Pandeji, our Joint Secretary, and each and every staff and member, distinguished guests, officials, professionals, students, ladies and gentlemen, whose sincere and tireless efforts and participation has made it possible to make this event a grand success. Thank you, everyone. Jai Hind.
Thank you, sir. And with that, ladies and gentlemen, we conclude the inaugural session, thanking once again our honorable ministers and all the dignitaries here on the dais, all present in this august gathering also, and also those joining us virtually across 75 locations in the country. May I request you all to remain at your respective seats, for we are going to be moving into our next session, the first technical session. Yes, please allow us just another 5 to 10 minutes. Probably we can have a small stretching break and a bio break, and then 10 minutes, 12:20, we'll start with our technical session. The first technical session, you can be seated by 12:15, so that we are in time for our technical sessions. 5 technical sessions we have today, 1 pre-lunch, 4 post-lunch, and we are going to be concluding the day with the plenary session at the end. So just 10 minutes of short break. There is no tea, but yes, stretching break. And if I can just request the stage to be set for the next session, please. Thank you. all the sessions, and just after the session we have the lunch. We will have to, in case we are not going to die, we will have to slightly shorten also the lunch break. तो सभी के इंटरेस्ट में है कि हम अपना सेशन टाइम पर शुरू करें. So we have, as I mentioned, 5 technical sessions on different topics. We've already, and as the Honorable Finance and the Corporate Affairs Minister, Honorable Minister Srimati Nirmala Sitharaman had also mentioned that we need to build on creating more investors' awareness, protection for our investors, driving a more inclusive economic growth for the country. So towards that, we have our very first session, the technical session. May I just request people joining us to kindly be seated as soon as possible so that we start with our session. Our speakers of the session are already here. Please requesting you all, ladies and gentlemen, to kindly take your seats. We are going to start with our technical session 1. Just awaiting for your presence at your seats, please. So welcome to everyone to the first technical session, and as we work on building the samarth of our investors, we have the investor education, awareness and protection for inclusive economic growth technical session on the subject. We have our panelists joining us, Shri Gopal V. Kumar, actuary and economist, Radco and Company, the moderator of the session. Shri Vigyan Mishra, he represents the consumer's perspective, a consumer activist. Shri Dhirendra Kumar, finance expert, CEO of Value Research. Shri Anil Kumar Sharma, Executive Director of the Reserve Bank of India. Shri Rakesh Jain, Chartered Accountant and Director FSL Software Technologies Limited. And Shri GP Garg, Executive Director, SEBI. The session chair, ladies and gentlemen, Shri Manoj Pandeyji, Joint Secretary, Ministry of Corporate Affairs. Just before I hand over to our Honorable Chair of the session. Just requesting once again all of you, request your kind attention, in fact your utmost attention to the session which is just about to begin, the technical session on investors awareness. Please take your seats. सभी लोग जो पीछे की तरफ खड़े हैं, प्लीज आप यदि जल्दी बैठ जाएं तो हम अपना सेशन शुरू कर पाएंगे. Especially at the back, may I just request you to please take your seats. So thank you once again to everyone for joining us, and with that, as we begin the session, may I request Shri Manoj Pandey, Joint Secretary, Ministry of Corporate Affairs, and the Chair of the session for his introductory remarks.
Thank you very much. Today, I am joined with my colleagues in IEPFA board, Shri Gopal V. Kumar, Shri Rakesh Jain, Shri G.P. Garg, and Shri Anil Kumar Sharma, and also well-known experts, Mr. Dhirendra Kumar and Dr. Midul Sagar, who is now our research chair at NCAER. He has recently joined. He was also a member of MPC. And we, in fact, as part of deliberation, we also will be joined by well-known consumer activist, Shri Bejon Mishra. The context setting, the moderation will be done by Shri Gopal V. Kumar of this session. But let me set the context. You would all be aware that in year 2016, Investor Education Protection Fund Authority was established. The twin objectives of this authority are: one, refund back the dividends and the amounts which come back to the Consolidated Fund of India if they remain unclaimed for 7 years. Earlier, they were not refunded back to the claimants. Government took a big step and said we should refund back the amounts and dividends to the rightful claimants, if there are rightful claimants and they are coming forward. Second, the bigger step was the underlying shares. Now, underlying shares also are coming to Investor Education Protection Fund Authority, and they are lying in our demat accounts. Now, dividends, amounts and the shares combined together would be a huge sum to a person. Because of some reason or other, he is not able to claim from the companies. Maybe because of change in address, maybe because of inheritance issues, maybe because of death in the family, there were legal heirs who want to claim. The process started in 2017. And we have today huge number of shares and huge amount of dividends and amounts lying with us. The challenge is how to trace out the claimants and how to spread the message that please claim those amounts, please claim the shares. That is one objective. The second objective, which Honorable Minister also mentioned, is about spreading awareness about importance of investment and also regarding Ponzi schemes. In rural areas particularly, people have fallen prey to those Ponzi schemes, and we are helped up by several institutions like CAC governance, India Post Payment Bank, representatives are here from those institutions, Nehru Yuva Kendra Sangathan. So we have taken support of all these institutions, going among youth, going to rural areas, going to semi-urban areas, explaining them through short videos, through short films, through documentaries, through literature, through regional literature in several regional languages, Investors Handbook, and also going to states and organizing conferences. We organized one at Bhubaneswar, second at Dharamshala, third recently at Guwahati. Why? Because we have found that people have fallen prey to the Ponzi schemes, they are getting duped, and at the same time, we are also encouraging that invest wisely. It's wise to invest, and what are the right products to invest. With these two twin objectives, as Honorable Minister has also said, we have now conducted more than 60,000 investor awareness programs in the last three years. We are a new organization, established in 2016, started working in 2017, and within next 2-3 years now, what we have done. When we started in 2017-18, the number of claims filed were around 12,000 or 13,000. Today, the claims which have been filed before us have crossed 87,000. Why? Because we are settling the claims also. We have disposed 50,000 plus claims, approved last year only more than 12,000 claims. The claims which are pending with companies and the claimants, we are asking them to file e-verification report. It is all digital, no physical documents are required. It's digital filing is happening, and through digital processing, the shares are refunded back to the claimant's demat account, and amounts are getting transferred to the claimant's bank account. We have so far refunded about 1.63 crore number of shares. It's not a small amount. 1.63 crore shares have been refunded, and the amount, if we calculate the market value, it would be around 1,500 crores as on date. It depends. It could be because of market fluctuation. Similarly, dividends have also been transferred to these now 28,000 plus claimants. The challenges in next 25 years, because that is the idea of today's deliberations, what we have done in last 5 years, last 4 years, and what we intend to do in next 25 years. We have to go to rural areas, semi-urban areas, and also to urban areas, because we have seen that in urban areas also, the right investments have not been made. The people are being duped. There are Ponzi schemes which are there. But to attract investment and to say you have to invest in market products, we have to go to rural areas, we have to go to semi-urban areas, encourage savings, encourage investments. I'll request all the August gathering here that please go to our portal and the website. You will see variety of material. Plus also we launched a series of films, short films, talking about importance of budget making, importance of savings, importance of investments. Small, see, there are rural characters who are in fact playing roles and giving information. I'll further, through scroll messages, through Doordarshan telecasts, through Lok Sabha televisions, and through jingles, through various publications, we are reaching out to people. An important part is partnership with IGNOU, where 75 lectures, series of lectures are happening, where importance of investments will be told to the viewers. And it's a very important platform for us. We have research chair at 2 places at present, one at IICA, other at NCAER. And we are, in fact, our campaign is happening along with Chartered Accountants Institute, Cost Accounts Institute, and Company Secretary Institute. We take help of them. As part of simplification, just last year we simplified the entire process, where we have dispensed with certain requirements of affidavits, etc., and self-declaration has replaced the affidavit taking. So it's a simplification of claim process has happened. And today we have launched the single window facility for 75 years and above. Because what we have seen, we used to get a number of calls that we are retired, our claims are, we have heard that our shares are lying with IEPFA. The company has told us that because of change in address, the dividends and the shares have transferred to them. So today we are starting a dedicated facility for them. We will reach out to them and we will help them in filing the forms. We will call them back. We will ask that, okay, you send your requirements on this email. We will reach out to you. With these words, I'll hand over the session's deliberations to Shri Gopal V. Kumar, an expert in actuarial matters and financial matters, who will be moderating the session. Thank you very much.
Thank you, Manojji, for setting the context of this discussion. This discussion is very important. Whatever Honorable Minister said, the role of investor education and protection is very, very important for Prime Minister's vision of 100 years of independence. Indeed, a great pleasure to be among this distinguished panelists. An august audience, a warm welcome to all of you to this technical session on investor education, awareness, and protection for inclusive economic growth. हम आज़ादी के अमृत महोत्सव मना रहे हैं और उस महोत्सव के अवसर पर इस गंभीर विषय पे मंथन और चिंतन हमें जरूर करनी चाहिए और हम करेंगे। और इस मंथन और इस चिंतन से बहुत सारी ऐसी अमृत संकल्पों का अमृत, हमारी नई ऊर्जाओं का अमृत, विचारों का अमृत निकलेगा, जो हमें अगले 25 साल के हमारे देश के सामने जो चुनौतियां हैं, सपने हैं, उनको पूरा करने में हमें बहुत सहायक होगा। As you know, we have to be economic superpower. What is our economic objective of the role of financial savings and investor protections are very important. To reach the goal of 5 trillion USD, we need to have very high capital formation, and the role of financial savings and protections is very important in that. The topic is investor education, awareness, protection for inclusive economic growth. Manoj ji has already set the context, and that context is what we have achieved so far, which will help us understand and plan for the next 25 years. Today's discussion is 75 versus 25, but we'll talk about 25% about what we have done in 75 years and 75% of what we'll be doing in next 25 years. That is important because we have to look ahead. Book value is right, but intrinsic worth is more important than book value. So there are three concepts in this topic. One is investor education, awareness. There are many connotations. We start with awareness, education, right? Education, then it goes to empowerment. The time has come that we should move from investor awareness to investor empowerment. And what is investor education? It's just creating those abilities in our investors to take financial decision. We have to make them enabled to take that decision. And protection is creating an ecosystem to protect the interest of investors in the world of information asymmetry, especially in the financial world. Right? We need someone to take care. And inclusive growth is economic growth that is distributed fairly across society and creates opportunities for all. Generally, it is said that educated investor is a protected investor, but we'll add one more line here. Educated investor and protected investor are engines of inclusive economic growth, and we want both educated and protected. If investors are educated, the onus on protection lessens down, right? If you are not educated, protection element will be higher. So you have to play the balancing act. Today with the distinguished panelists, we'll discuss the various dimensions, subject, and try to collect some amrit, some nectar out of that discussion, which will motivate us in next 25 years. I heard Honorable Prime Minister yesterday, and he said that we should move towards people-centric governance from government-centric governance. I think this has a huge scope where we can go. And that is what we need to inculcate in our governance in next 25 years where we want to achieve. We'll introduce you to the panel. I think in next 30 minutes it will be very difficult to get the amrits from them, but we'll try to extract as much as we can. So our chairman, Manoj Pandey, we have Shri Vigyan Bhawan, consumer activist, Shri Ashok Kumar, finance expert and CEO Value Research, Shri Anil Kumar Sharma, Executive Director RBI, Shri Rakesh Jain, Chartered Accountant and Director FSL Software Technologies, Shri GP Garg, Executive Director SEBI, and Dr. Midul Sagar, Research Chair, IEPFA at NCAR. Obviously, as I said, that 25% of the time for 75 years what we have achieved, yes, we have achieved a lot. We have achieved a lot. If you see demat accounts, I think it's 83 million. Mutual fund, if you see AUM to GDP ratio, it's very high. Life insurance penetration has gone up. But have we achieved our potential? Probably no. We deserve much more than what we have achieved in last so many years, right? So we have to move to the next level. So we'll start that, and my request to the panelists is that, as we discussed, we will focus 25% time on what we have achieved. Milestones are important, history is important, but we have to focus on, come out with some ideas, thoughts, which will guide us in next 25 years. So my first request to Mr. Vigyan Mishra, who has been an activist, consumer activist, and जागो ग्राहक जागो इनका एक मूल मंत्र रहा है, तो मैं पूछना चाहूंगा मिश्रा जी से, ये ग्राहक अभी भी सो रहे हैं या जाग रहे हैं?
थैंक यू गोपाल जी। पहले तो बहुत बहुत मुबारक सबको, और हमारे जितने EFPI का जितने लोग हैं जो इस कार्यक्रम को बनाए, सबको बधाई। इट्स अ बिग सक्सेस, लेट मी टेल यू। यू हर्ड द ऑनरेबल मिनिस्टर, शी इज़ ऑलरेडी प्रेज्ड, एंड आई once again wants to take this opportunity. मनोज जी, आपने कमाल का काम किया है। Thank you very much for doing this great work. You see, हम जब बातचीत शुरू करते हैं तो हम लास्ट रो को देखते हैं, 4 लेडीज बैठे हुए हैं वहाँ। आप सुन पा रहे हैं हमको? जोर से बोलिए। वेरी गुड। आप आपस में बात नहीं कर रहे हैं ना? वेरी गुड। You see what I want to tell you, जागो ग्राहक जागो शुरू कहाँ से हुआ? बहुत लोगों को मालूम होगा, बहुत लोगों को मालूम नहीं होगा, लेकिन हम आज जिनको नहीं मालूम है उनको मालूम करवाना चाहते हैं। हम 1983 में जमशेदपुर से उपभोक्ता संरक्षण पे काम करना शुरू किए और 1986 में एक हम लोगों को सबसे जो बड़ा मतलब विक्ट्री मिला वो था कंज्यूमर प्रोटेक्शन एक्ट ऑफ 1986। उपभोक्ताओं को कानूनी रूप से एक मान्यता मिला उनका राइट्स को लेकर। 24 लॉज थे उस समय भी, बट वो लॉज थे इंस्पेक्टर राज का। वो लॉज थे किसका? कोई भी इंस्पेक्टर कहीं भी जा सकता है, कुछ भी कर सकता है, लेकिन उपभोक्ताओं को संरक्षण नहीं मिलता था। 1986 से उपभोक्ताओं को संरक्षण मिलना कानूनी रूप से शुरू हुआ। जब ये काम हम लोग शुरू किए तो कई अमाउंट्स कंपनीज के पास पड़े हुए रहते थे जो कंज्यूमर के थे। कैसे? जैसे आपने एक्साइज ड्यूटी पेमेंट किए, आपके प्रोडक्ट के साथ वो आ गया कर, और वो कर उनके पास रहना नहीं चाहिए, वो वापस कंज्यूमर को जाना चाहिए था। लेकिन कैसे पता लगेगा किस कंज्यूमर को कितना देना है, कितना वापस करना है? तो सुप्रीम कोर्ट तक ये बात चला। सुप्रीम कोर्ट ने डायरेक्टिव दिया कि ये कंज्यूमर वेलफेयर फंड बननी चाहिए। तो सरकार ने 1991 में अंडर द सेंट्रल एक्साइज एंड सॉल्ट एक्ट ऑफ 1944 में अमेंडमेंट लाकर 1991 में कंज्यूमर वेलफेयर फंड शुरू करवाया, जहां पर आपका पैसा कंपनी से आकर इट गॉट डिपॉजिटेड इनटू द कंज्यूमर वेलफेयर फंड। एंड नाउ under section 57 of the GST Act of 2017, it is being managed by the Department of Consumer Affairs, but it is under the Ministry of Finance. Why I am giving you this background is that similarly, the Investor Education and Protection Fund got created and an authority came into place. And in 2019, under the new Consumer Protection Act, under the Modi ji's leadership, we got a new law which brought in a regulator called Central Consumer Protection Authority. So जागो ग्राहक जागो शुरू हुआ उस प्रेमिस से कि करोड़ों रुपया सरकार का, उपभोक्ताओं का पैसा सरकार के पास था, लेकिन सरकार को नहीं मालूम था कि कैसे यूज करें। So the use of that money was created to create a brand called जागो ग्राहक जागो। आपको मालूम होगा कि जितना ना प्रोडक्ट है मैगी नूडल्स का, उसका 10 गुना पैसा पब्लिसिटी में खर्चा होता है ब्रांड क्रिएट करने के लिए। और उसी ढंग से हम लोग को करीब 21 प्रेजेंटेशन उस समय प्लानिंग कमीशन, अभी उसको हम लोग नीति आयोग कहते हैं, प्लानिंग कमीशन के सामने प्रेजेंटेशंस दिए कि हमको फंड से उपभोक्ता जागरूकता लाना है और हमारा टैगलाइन रहेगा जागो ग्राहक जागो। और 100 करोड़ हर साल रिपीटेडली खर्चा होते गया। और आज आपको मालूम होगा कि हम यदि 10 लोगों से पूछते हैं उपभोक्ता संरक्षण के बारे में, आपका राइट्स के बारे में आपको मालूम है, तो उसमें से 8 लोग बोलते हैं हाँ। पहले था 10 से पूछिए 2 बोलेंगे हमको उपभोक्ता का मालूम नहीं है अधिकार क्या है। तो हम केवल इतना ही कहना चाह रहे हैं कि द फर्स्ट 75 years of our journey was created to create a brand called Jago Grahak Jago. And that brand needs a lot of investment. Let me tell you, like we are trying to do under the Investor Protection Fund. We are creating a brand now. What is that brand? That brand is saying that if you have your money and it is lying unclaimed, I will give it back to you. As Manoj ji said, if you are a victim of Ponzi scheme, come and tell us. So this is what, the whole history of Jago Grahak Jago is. Today it is almost again going back to sleep, but we are constantly trying to wake it up as and when we can, in whatever manner we can.
थैंक यू सर। सर एक क्वेश्चन इससे रिलेटेड है कि कब ऐसा वक्त आएगा जब हम कहेंगे ग्राहक से, ग्राहक आपने इन्वेस्ट कर दिया, आप सो जाओ, हम आपके लिए जगह।
एक्सीलेंट, एक्सीलेंट, बहुत ही अच्छा। यही हम अमृत काल के बारे में बताना चाह रहे थे। अब हम लोग अमृत काल पे जा रहे हैं। अमृत काल में क्या होना चाहिए? There has to be a strong surveillance mechanism. आपको चिंता नहीं करना है, आपको केवल एक जगह से पूछना है, यदि किसी ने भी आपको फोन किया कि ये प्रोडक्ट खरीदीजिए, इसमें आपको बहुत अच्छा रिटर्न मिलेंगे, फलाना ठिकाना, आपको सेल करेंगे, मिसलीडिंग डिसेप्टिव मार्केटिंग करेंगे, एडवर्टाइजमेंट करेंगे, केवल एक ही जगह पे जाइए, वो है इन्वेस्टर प्रोटेक्शन फंड के। हम लोग एक टैगलाइन निकालेंगे, इसके बारे में हम लोग बात करेंगे मनोज जी से अलग से, लेकिन टैगलाइन एक जरूर निकालेंगे, एक ब्रांड क्रिएट करेंगे। वो ब्रांड होगा कि आप केवल उनसे पूछिए और आप सुरक्षित हो। And that can come through a good surveillance mechanism, a mechanism which is going to be 24/7 awake, like what I learned from the Citibank. City never sleeps. Investor IEPFA will never sleep. It will be awake 24/7. And for consumer, the real, the strong point is, हम जब ट्रबल में हैं, is there somebody to listen to me? And that's why I always promote and I tell the government that our helpline, if it is not 24/7, it is not a helpline. Thank you very much.
Thank you, sir. So we hope the time will come. Next question to Mr. Anil Sharma. We'd like to know from you the experience from the central bank perspective. What are the indicators of investor awareness? Investor awareness is a very qualitative connotation, right? How to measure that? I tried to find out, I read one speech on RBI website, financial inclusion index you have, where you have 4 parameters like branch penetration, deposit penetration, credit penetration, insurance penetration. Do you think next 25 years these indicators will be sufficient with the way technology is changing? And do you think other parameters like this talk about access to financial products? What about the uses of those products? What about the quality of delivery of those products? So, sir, I would like you to focus on these 2 things.
Thank you. Coming specifically to the question which you asked, that financial inclusion index was constructed last year in July. It would be done every year. So this July we'll come out with the second iteration of that index. But it doesn't have 4 parameters as you indicated. There are 97 parameters. It has 3 dimensions. One is the access, other one is the usage, and the third one is the quality. So usage itself has around 50 odd parameters, and similarly for the access and the quality also. And this year, when we are doing a review of that after 1 year of operation, we'll be adding a few things and we'll be fine-tuning it, a few parameters. And if you have seen the index values, they are 73. If the maximum value is 100, then on access we are 73. And on usage, we are around 53, 54, and similarly on quality, we are around 50. So as we can see, on access, making financial services available to the people at large, we have done reasonably well. You can go back to priority sector lending, agriculture, small trade, etc., lead bank scheme, and self-help groups, and small accounts, and digital payments, etc. We've come a long way. That's why we stand at 73 in excess. And that doesn't mean only banking services. It includes the other financial products, for example, insurance and pension as well. But as you can see from the index value, usage and quality is lagging behind a bit, and it is there going forward. We will have to do heavy lifting going forward. And I'm sure that having addressed largely the access element, we will be focusing more on the usage and quality. So if any particular aspect you want to focus or want me to focus on, then...
I think usage is important to understand. So okay. I would like you to elaborate on the usage.
Okay. Like, for example, if ATMs have been set up, then that is an infrastructure which is available. But are they being available? What is the uptime? What is the downtime? What are the issues coming out of the usage of the ATMs? Whether those grievances are being addressed properly? Because if the grievance redressal is taken properly, then the usage will be, it will be higher. Similarly, the quality, and this has the element of quality also. For example, we have ATMs and we have banking outlets and we have BCs. But if you see, forget the country, if you see within the state, let's say take any example, any state which is advanced, let's say Maharashtra is comparatively advanced state. But the situation in terms of the availability of infrastructure is not the same in Western Maharashtra and Eastern Maharashtra. Similarly for Rajasthan, for example, the Western Rajasthan has a different availability parameters vis-a-vis the Eastern Rajasthan. And similarly it goes northeast, east and other areas. So that element of differences in the availability of the infrastructure at the district level, we have gone to the district level for getting this quality parameters. That has been factored into the quality component, and that is factored into the measurement of the quality.
Any specific suggestion you have how to improve it further in next 25 years? What would be your advice on that?
See, improvement would be if people are going to find the infrastructure reliable, ATMs work, banking outlets are available, BCs are delivering, and they are delivering the quality service, the usage will go up. If the digital payments are, are making it convenient and easy for people to do transactions, they are going to use more and more. And if there are any grievances which are coming out of such usage, if they are addressed properly, people are going to get confidence and they're going to come back even if there are a few mistakes here and there. So that is where the driving will have to take place.
Right. Thank you, sir. Next question for Mr. Dhirendra Kumar. You have been an expert on the subject. What other factors you think can be added to the awareness benchmarking? Some of the factors which generally we read in newspapers is that still our financial savings is down and our savings is a lot on physical assets, right? And probably the awareness and education take us to the financial savings, our investment in the financial products. So can it be a factor? Should it be a factor? Because ultimately education should take you to the next level of investment. That is one. Second is that one of the challenges in the market, in the consumer mind, has been their risk and returns are not aligned. They always see return, right? And return overshadow their risk, understanding of the risk. So how should we really align the risk and return and communicate to the consumer, to the investor at large, that you have to think about risk and return together, not just return?
The financial landscape has changed quite dramatically. The risk and return, it is very difficult to relate to it for an individual simply because return is measurable. It is quantifiable. You exactly know that you'll get 8%, 7.7% or 7.3% in this scheme, that scheme. Post facto, you can measure it for the index, for the stock, for a mutual fund. But and risk visits you once in a while, and risk visits you once in a while, and it hits you very hard. And till it hits you, you don't know what the risk is, because it's almost like you are normally averse to wearing a helmet because it creates discomfort. Only once in a while you get a feel that, okay, this guy actually had, met with a calamity simply because of this stupid thing, one small thing. So, risk has to be appreciated that way. And there is a reason why people don't understand this. Historically, India is a fixed income country. Historically, and there is a reason for it. Till the 90s, in fact, I just think of the way the market has changed ever since I've been looking at the market, or the way our market environment has changed. If somebody gets up, today, who died in 1990, and comes and sees that, okay, this is our stock market, he will find that, okay, all the new thing that has come up, the stock exchanges, in the current form, they did not exist before. The dematerialization, people are not sitting underneath the tree and actually talking of the Badla system. That is the system we had. 40% of the securities that were delivered to people used to be bad, bad deliveries. So when you look at the changing complexion, so on that count, I think we have traveled a long way. We have made our market very secure on the nuts and bolts aspect, the mechanics of it, the dematerialization, the security of the system, the SEBI coming into being, they're able to get after somebody who misbehaves, and all that. The regulation of the companies going public. We had vanishing companies before that. Then comes, you know, the mindset bit. That I don't think is changing. That is something which has to, and that I think is not a, it is not a crisis. It is going to be a huge problem. It's going to be a crisis for which we have not prepared our population for. You know, most Indians are unlikely to be getting inflation-adjusted pension, which historically all the people in the organized force are used to. So that's one. The other is that people are going to live longer. If people retire at 60, and they used to live till the age of 75, and now they are going to live till 85, then you are not going to live 10 years more. You are going to live 66% more, and that will be your unearning years. So this is something which, and also, you know, in India, where we have been a fixed income country, we just put our money in our, you know, the government of India, RBI bonds used to fetch 13%. While I was coming into, you know, the workforce myself, and then it became 11%, and that too tax-free. And also, you know, in a tax regime where if there was no TDS, all income was tax-free. So in that sense, you know, people have to really understand that this is not a small crisis we are facing. We have the environment, we have the ecosystem, and we also might have the education. Your pension, authority will actually create awareness and make you aware about all the things that you should not be doing, because personal finance is not about what you do.
Mr. Kumar, actually, I want to your specific comment on, can we have some kind of quantification of risk which can be easily understood by investors? For example, if you can say 8% return, can we have, say, risk or volatility or any such measure which can give us, you know, a quantified number where investor can take some view about that? Can we have that next 5 years, 10 years? Means, do you need that number? I think yes, because investors, they don't understand it. So if they don't understand, can we help them? Can we facilitate them with some numbers, some scoring model? Anything for that matter can help.
Yes, but there are quantification of risk. You know, if you look at credit rating, it is a view on it's a view on the risk, the likelihood of getting your principal and you know, interest on time. But that apart, I think the quantification. I think more than quantification, we need because volatility is not risk. Volatility is risk if your time horizon doesn't match, and that requires a great education. You know, that is something. This is where I think, you know, education, basic financial education being an integral part of our curriculum till we are in class 10th, that I think should become mandatory. And I think that is only the government, state government and central government can take an initiative, because we take great pride in, you know, we are still a country. I have grown in a family where I was not aware of whether we are a well-off family or whether we are a rich family or whether we are a poor family, where parents don't share about the financial status of it is not considered a cool thing to be financially minded. I think that is something which we have to become conscious of, and you know, great deal of education on the understand, which will enhance the understanding of risk.
Education is the key. That's what we understand, right? Now, next question to Mr. Garg. Your organization is regulating the most aspirational asset class, financial assets, like, you know, aspiration in terms of risk, return, contribution to growth, etc. And what has been your experience during, say, last 25 years or 30 years? What have been the major achievements, what we have seen in the market because of your, you know, organizational initiative?
Thank you, sir. In fact, I would say that one of the, mandate of SEBI is investor protection. And protection you do both ways. You educate the investors, or if their rights are violated, you empower them so that their rights are protected. I would just give you a very small example that sometime in 2009-10, when SEBI used to do investor education programs, we realized that the number of investors are so less. In fact, the people had no knowledge about the basic banking products, so they had no knowledge about the insurance. And if we talk straight to them about the securities market, that would be probably not the proper way of doing the education. So we came with the concept of resource persons who would actually train these people in any part of the country about the basic financial education. It will not talk about the securities market. It will talk about some of the basics of finance. And let me tell you, this program has been very, very successful because it has helped two things. It demystified the finance, personal finance, and it also prevented a lot of people from not falling to the Ponzi scheme. It is equally important that you don't lose the money. Earning money is equally important, but you should be very careful where you are putting the money. So this is one area. And second, then we came to the next level through investor awareness programs. And recently with our SMARTS program, where these programs are purely, you see, investor education program. But I agree with Mr. Dhirendra Kumar that unless we make it part of our curriculum, which SEBI and all the regulators are jointly doing through National Center for Financial Education, where we have made efforts that it should be taught from class 6 to 10th. Some of us, unless we are students of finance, if you are a student of engineering or science or arts, you would not understand the finance, and maybe finance is not maybe too exciting a subject. It is not discussed in your family. Parents never tell you what their worth is, where they stand. So now we have tried all the regulators together through National Center for Financial Education. Mr. Sarma was earlier chair of the NCFE, currently from SEBI, I am the chair, where we are trying that this basic financial education should be part of a school curriculum. I'm extremely happy to share that 19 states have agreed to make part of their school curriculum from class 6 to 10th. They have mostly agreed to whatever we have said, partially or fully. And I'm very sure that these, our youngsters, once they come to the college and when they will actually earn, they will understand and manage their finances much better than rest of us. Just to give one small figure, in 2019, when we did a survey, how many Indians are financially literate? Because you asked this question earlier. Let me tell you that only 27% of Indians we found are financially literate. So I'll say that in Amrit Kal, we have to say that we go to 100%. So that's the one area where we all have to, work hard. While we take pride that there are close to 9 crore demat accounts, mutual fund folios around 13 crores, but if we see the number of, adults population which is investing in India is only 7%. So again, it is education which will play a very crucial role. And let me submit you that with our recent initiatives like launching of our education platform, Sarthi, SAARTHI. I'll request everyone, please download this app. I'm just selling SEBI through this platform to request you kindly, so you understand what the investor education is all about. Recently, we came about the investor charters, that what are the rights of the investors, how to empower that. So I think some of these measures where, citizens feel that they are putting their money for their own benefits, for their betterment, this place is safe, and they will get, long-term returns. I think we will, do a lot for the country, and that will be the real inclusive growth. From 7%, I would prefer that in Amrit Kal, we must definitely go to at least 50% of Indians, because that is the figure of the most developed countries, and 100%, financially literate Indian population.
Thank you, Mr. Garg. Now, Rakesh ji, you have seen investor awareness, education and protection from a different dimension, right? And this dimension has its own shares of achievements, right, and challenges. So what do you think are the 3 important strategies to boost investor confidence, and how important is investor protection in creating that ecosystem?
Thank you, Gopalji. It's an excellent question about investors' confidence. You see, in your statement, you have said that educated and protected investors are the engine of inclusive economic growth of the country. Now, it's a very important statement, and I think we must understand that education and protection goes hand in hand to get you the investor parameters which you are looking for. If I talk about past, I think in the last 10 years, various agencies have been working on, besides investor education, IEPFA, SEBI, stock exchanges, mutual funds, in investor education, and I think today, the degree of investor education is fairly good. And people are conscious of the Ponzi scheme. They are conscious of the fact that in case they are getting extensive returns or very extraordinary returns, that means there is something wrong. Something is missing. So with education being in place, what I personally feel is that protection part has to be little more. Little more in the sense that what is happening is that investor should take very informed decision, which he is learning by education as well as by awareness programs. And the very fact what Garg Sahab has mentioned that now 19 states have really agreed to bring this financial education into their curriculum itself is a very major step, which will lead to, again, better education. When we talk about protection, protection is to be looked at from two angles. One angle is that if, in spite of the best decision, because of somebody else's mistake or somebody's misleading nature or wrong data being fed, somebody loses, it is the responsibility of the nation to compensate them or to see that somehow they get, their problem get addressed. In other words, if suppose the corporates have given wrong information because of which the investors have lost money, like you have class action suits and all that, there could be mechanism by which the properties or the assets of the directors as well as the company could be forfeited and could be divided among the investors who have lost. So once investors will start seeing that if they lose for any reason, not of their fault, not because of lack of knowledge, but even after exercising due diligence, if they lose, there is some mechanism which is available. Although governments have provided various mechanisms in this regard also through investor protection funds and all that, but the awareness of that, in my opinion, is little less, and I think we need to really talk about improving that awareness and increasing funds getting allocated to the lost investors. In this regard, I will just add one more thing that what Honorable Finance Minister has mentioned, that smaller investors have really handled the market when FIIs and FPIs have been selling continuously for the last 5-7 months. That shows that there is a tremendous amount of investor confidence which is getting built in the market, and I'm sure that with the steps which we intend to take or which is under government consideration, it will go many-fold, and I think in long run, it will be a big step for investor protection and investment for economic growth.
Thank you, Rakesh ji. Now, our question to Dr. Sagar. From macroeconomics perspective, how important is investor education and protection? And second question is that how investor protection guidelines need to be aligned to the changing business and distribution model of financial services provider?
Thank you, Gopal. Both very interesting questions. And I think why from the macro point of view, investor education is important is obviously because if we want to wish the economy to grow faster, you need more savings, you need more capital formation, you need deepening of financial markets. And that cannot come about unless we have a reasonable framework for investor protection. We are celebrating 75 years of independence, and I think I must also compliment the IEPFA as well as the Ministry of Corporate Affairs, the regulators here, for setting a very good environment for investor protection. I think the Indian markets are pretty much on par with the advanced economies financial markets. We just have to make a little more nudge and we would be there in a big fashion. When I look at the macro data, I mean, I recall that during the 1950 and 51, or maybe 50 to 55 if you see, our saving rate was in single digits. Like the gross domestic saving as a percentage of GDP hovered around, on an average basis, around 9.5%. Now that number has grown. I think we touched 29.4% before pandemic. It has slightly come down to 27.8%. I'm sure when the data comes for the next 2 years, this number would be back and above that. The capital formation rates have also picked up. financial deepening has occurred in a big way, and the flow of funds data, if one sees, we are now having finance ratio close to 45%, which is pretty comparable to the advanced economies. And this has to do a lot with investor protection, because otherwise people won't really be coming for financial protection. That doesn't really mean that we don't have challenges. I mean, in a sense, we've had bank failures, we had mutual funds wind up schemes during the pandemic, one of the major mutual funds. But when I look at it in terms of the global comparison, I think we are way, way better. A lot more banks fail in US. The Fed number would be close to like 10 or 15 in a year, and smaller companies also fail there. There is this interesting angle of the corporates. While most corporates are contributing to our growth environment in a very positive way, you would find odd corporate owners actually, I can use a technical term called looting. Looting actually is in economics a very technical term, which comes out of works of two Nobel laureates, George Akerlof and Paul Romer. They say the economic underword of bankruptcy is essentially for profits. So they actually try to capture and make profits by going bankrupt. We had seen the US junk market collapse basically in a takeover boom and bust waves. So we have to be guarded against these things, and we need to work on those issues. Now, in terms of the investor protection, we are a bank-dominated economy, financial system, but we are moving very rapidly towards markets. So we need to figure out on both fronts that we need to really sort of go on both these planes. We need to tighten the investor protection, and investor protection not necessarily means the small investor, which obviously is very important. And I mean, a typical small investor loses when there's a financial repression. If interest rates are kept too low and negative real interest rates are there, that itself is lack of investor protection in some way. But there are many other ways. There are corporates which have lost money on Forex deals, and they blame banks for not really informing them well. So there are investor protection issues even on the larger planes. So let me, I think, paucity of time, so stop. Your second question, I think I didn't quite address.
Guidelines should be aligned with changing business and distribution model.
So clearly, I mean, there has to be some realignment in the sense that, see, I cited the example of bankruptcy profits. Now, why this happens is because there's an implicit government guarantee that they will actually bail out the firms, and therefore money is siphoned and kept somewhere else. And with changing environment, I mean, the FRDI bill, which we couldn't run through, probably in some form we can rethink about sort of insolvency framework for financial institutions. Similarly, on the digital space, with so much of things happening on the digital space, I think we need to move very fast and do a lot of work there. Even the data protection is investor protection, essentially, where Reserve Bank has been doing a lot of work, and despite tremendous pressures, it really withstood those pressures and said that data protection is very important. The owner of the data should have the democratic rights, and that's what really helped. So I will stop here and maybe.
Thank you very much, sir. We have बहुत सारे अमृत इकट्ठे हो गए हैं. हमें अभी कोलैबोरेटिव और इंटीग्रेटेड तरीके से इन सारे सजेशंस को इम्प्लीमेंट करना है और एक इंक्लूसिव इकोनॉमिक ग्रोथ को एक सच बनाना है. Let's join the journey of awareness to empowerment, protection to confidence, and economic growth to inclusive economic growth. Thank you very much, all the panelists, for your... Yeah, please. कोई लेना चाहेंगे? उसके पहले मैं बता दूं, ये सबका मूलतः एक सॉल्यूशन एजुकेशन है। अगर आप कोई ऐसा ऐड दिखाया जा रहा है जहां पे आप समझ नहीं पा रहे हैं चीज़ों को, तो ऑब्वियसली इसका सॉल्यूशन एजुकेशन ही है। और IEPFA ने बहुत ऐसे कदम उठाए हैं जिनसे हमारे इन्वेस्टर अवगत हो सकें कि इसका मतलब क्या है। हमने बहुत सारे ऐसे वीडियोस, पब्लिकेशंस लॉन्च किए हैं। बट ये एक सतत जर्नी है, ये यात्रा है। इन्वेस्टर एजुकेशन एक दिन का सब्जेक्ट नहीं है। हमें अपनी रिस्पॉन्सिबिलिटी को समझना होगा। ऑब्वियसली यहाँ पे रेगुलेटर, डेवलप अथॉरिटी हैं, बट हमें इन्वेस्टर की भी कुछ रिस्पॉन्सिबिलिटी है और हम इन्हें इस रिस्पॉन्सिबिलिटी से बहुत सारे माध्यम से अवगत करा रहे हैं और कराएंगे।
आई जस्ट वांट टू
या प्लीज।
बहुत बहुत धन्यवाद कि आपने ये बात उठाया है। ये बहुत ही अहम बात आपने उठाया है। हम इसलिए कह रहे थे कि, और आई एम श्योर मनोज जी इसका भी ध्यान देंगे आगे चलकर। हम लोग जो सर्वेलेंस मैकेनिज्म हम प्रपोज किए हैं उसमें आपका भ्रामक विज्ञापन के अगेंस्ट में भी हम लोग कार्रवाई तुरंत से शुरू करेंगे, ताकि उस ढंग के विज्ञापन जल्दी से जल्दी उतारा जाए, मार्केट में ना रहे। ये सारे जो आप कहें बहुत इम्पोर्टेंट है, हम लोग जरूर इस पर ध्यान देंगे।
Anyone?
IPF के बारे में आप बार-बार ये बोल रहे थे। हमने IPF में नवंबर में
नहीं, आप जो प्रक्रिया है, आप अवगत होंगे प्रक्रिया से। प्रोसेस कुछ ऐसा है कि अगर आपने सारे डॉक्यूमेंट सबमिट कर दिए हैं और कंपनीज ने वेरिफिकेशन रिपोर्ट सबमिट कर दिया है, तब तो कोई परेशानी नहीं है। कभी कभी क्या होता है कि आपके या तो डॉक्यूमेंटेशन में कुछ कमी रहती है और कंपनीज उनको वेरीफाई नहीं करती हैं टाइम से, और जब डॉक्यूमेंटेशन की कमी रहती है तो वो समस्या खड़ी होती है। लेकिन आप जो कह रहे हैं वो उसी परेशानी को देखते हुए हम लोगों ने प्रोसेस को सिंप्लीफाई करने की कोशिश की। अपने क्लेम को ट्रैक करने के लिए आप हमारे वेबसाइट पे देख सकते हैं। हाँ, ये मैं मानता हूँ कि इस प्रोसेस को और फास्टर और क्विकर किया जा सकता है। उस प्रोसेस में हमारे बोर्ड के जो मेंबर्स हैं वो भी हमें सुझाव देते हैं और उस सुझाव को मानते भी हैं हम लोग। कई कंपनीज़ को हमने लिखा भी कि आप अतिशीघ्र आप हमें डॉक्यूमेंटेशन कंप्लीट करें जिससे हम इन्वेस्टर्स को क्लेम सेटल कर पाएँ। हमारा काम है इन्वेस्टर को वापस करना जितना जल्दी हो, वही हमारे परफॉर्मेंस के का क्राइटेरिया का भी मेजरमेंट है। और हमने कहा है कि अगर सारे डॉक्यूमेंटेशन कंप्लीट हो तो विद इन 60 days वी विल रिटर्न बैक, एंड दैट वी आर डूइंग, एंड वी टेक फीडबैक फ्रॉम द रिस्पेक्टिव सब ग्रुप्स इन आवर अथॉरिटी। बट येस, पॉइंट वेल टेकन। अथॉरिटी को और जल्दी एक्सपेडाइट करना चाहिए और हमें शीघ्र अतिशीघ्र सभी का निष्पादन भी करना चाहिए। मैं इस सुझाव को लेता हूँ। इस पे और जितना सिंप्लीफिकेशन हम कर पाएंगे वो हम देख रहे हैं कि और कितना सिंप्लीफाई करें। लेकिन जैसे सजग निवेशक है सुरक्षित निवेश भी होना चाहिए। तो कई बार हम लोगों ने ऐसा भी देखा कि एक क्लेमेंट जिसने कहा कि मैं ही वो क्लेमेंट हूँ, सही डॉक्यूमेंटेशन मेरा है, पैन नंबर है, आधार नंबर है, और जब वो कंपनी ने उसको वेरीफाई भी कर दिया कि हाँ यही आदमी है, जब शेयर लौटाने की बात आई तो एक काउंटर क्लेम भी आ गया हमारे पास कि हमारे पैन को फोर्ज कर दिया गया, हमारे आधार कार्ड को फोर्ज कर दिया गया और हमारे शेयर को दूसरे क्लेमेंट क्लेम कर रहे हैं। तो थोड़ी सावधानी, चूंकि हमारा काम दायित्व इन्वेस्टर प्रोटेक्शन का भी है, तो वी हैव टू प्रोटेक्ट द राइटफुल क्लेमेंट्स। आई एम ऑलवेज यूजिंग द टर्म राइटफुल क्लेमेंट्स बिकॉज इन द मार्केट सजग निवेशक को ये भी देखना है कि हमारे शेयर को कोई और तो नहीं ले रहा है। We have to be quite guarded also. तो सजग निवेशक का ये कर्तव्य है कि वह देखे कि हमारे पैन कार्ड, आधार कार्ड क्या हम किसी और ने तो यूज नहीं कर लिया, हमारे पोर्टफोलियो में हमारे शेयर जितने थे वो सुरक्षित तो हैं कंपनी के पास, और कंपनी हमारे पास ने डॉक्यूमेंटेशन फाइल किया कई केसेस में कि साहब वो क्लेम गलत है, आप उसे सेटल मत कीजिए, ये राइटफुल क्लेमेंट कोई और है। तो ये कुछ समस्याएं हैं, लेकिन आपने ये ठीक सुझाव कहा कि हमें और भी त्वरित तरीके से हमें क्लेम सेटल करना चाहिए।
Common people. Thank you, sir.
मुझे एक्चुअली क्या है, आप मिस्टर गर्ग हैं सेबी की तरफ से, अच्छा होगा कि लंच के दौरान आप इनसे अलग से बात करें, क्योंकि एक तो मैं भी अवेयर हूँ, मुझे भी कुछ अवेयरनेस ऐसी हो रही है कि 1 बजे तक का टाइम था, हम लोग टाइम एक्सीड कर गए, नेक्स्ट सेशंस हमारे लाइंड अप हैं। तो मैं आपसे आग्रह करूँगा कि मिस्टर गर्ग से आप अलग से मिलकर बात करें, ये आप बताएंगे कि कैसे वैल्यूएशन का तरीका क्या है। तो एक बहुत बहुत धन्यवाद आपके फोरनून सेशन में पार्टिसिपेट करने का, मेरा मिनिस्ट्री की तरफ से ये दायित्व भी बनता है। many thanks, and as Mr. Vigyan Mishra said that was saying that it was one effort of an individual. It's not that. CCI, IBBI, NAFRA, IICA, ICAI, Cost Accounts Institute, ICSI, NFCG, all have partnered together to make this event successful along with MCA officers. So it's collective effort from all. We have a plenary session in evening which is going to be addressed by Secretary Ministry of Corporate Affairs and Head of all regulatory bodies, which is apart from other technical sessions, which would be very insightful. Thank you very much. Join us for a lunch. Thank you.
Before that, ladies and gentlemen, just request few minutes of yours as we express thanks to all our speakers. May I request Joint Secretary Sir, Shri Manoj Pandey to kindly present the mementos. Thanking first our panelist, Shri Vigyan Mishra ji. आपके बस 2 और मिनट लेना चाहेंगे, उसके बाद आप लंच पर आमंत्रित हैं। श्री धीरेन्द्र कुमार जी, थैंकिंग श्री धीरेन्द्र कुमार। Our expression of thanks to Shri Anil Kumar Sharma. Shri Rakesh Jain. Thanking Shri GP Garg. I
expression of gratitude and thanks to Dr. Mridul Saggar. And utmost thanks to the moderator of the session, Shri Gopal V. Kumar. We'll close with a group photograph और विशेष रूप से आप सभी का भी बहुत बहुत धन्यवाद इस चर्चा में भाग लेने का। हमारा 40 मिनट का लंच हम थोड़ा सा शॉर्टन कर रहे हैं क्योंकि हमारे टेक्निकल सेशंस भी हैं, 4 टेक्निकल सेशंस और प्लेनरी सेशन। तो आपसे निवेदन है कि 2:10 पर या 2:05 पर यदि आप यहाँ पर अपनी सीट्स वापस ले लें तो हम अपना नेक्स्ट टेक्निकल सेशन Okay, let us make it, if you can make it by 2 o'clock so that we start our next session on time. The arrangements of lunch have been made outside. Please carry your belongings with you because when you get back, probably you might not be on the same seat. So just ensure taking your things along with you. और 2 बजे आप सभी से निवेदन है कि आप पुनः अपना स्थान ग्रहण करें और हम अपना अगला सत्र जो टेक्निकल सेशन 2 आरंभ करेंगे। थैंक यू।
so that we give also ample time to all our speakers. So this is on the 5 years of the Insolvency and Bankruptcy Code 2016 and the achievements we have been able to make towards it, and doing an introspection, reflecting on those achievements, we now draw a way forward for the code. We have Shri Sudhakar Shukla, the whole-time member of the Insolvency and Bankruptcy Board of India, the chair of the session. Our moderator of the session, Shri Sumant Batra, advocate. Ms. Nandita Mishra, economic advisor in Ministry of Corporate Affairs, Government of India, esteemed panelist. Shri Sunil Mehta, chief executive of the Indian Banks Association, and Shri Puneet Dalmia, Managing Director of Dalmia Bharat Group, along with Shri Swaminathan J, the Managing Director of the State Bank of India. With that, I hand over to our chair of the session for the opening remarks.
Thank you so much for the introductions. Ladies and gentlemen, may I request you to please take your seats. We are starting a session where we need your attention. And I assure you that we will try and wrap this up within the time that has been allocated to us or with your cooperation. Since the introductions have already been done, I'll take the liberty of amplifying the huge credentials of the esteemed panel that I have. I would not have any ways been able to do justice to this. The only one remark that I'd like to make before I hand over to the chairman for his opening comments is that this subject of insolvency is one of the most complex and sophisticated economic laws and is so well recognized globally as such. IBC is therefore not just historic because of this huge law reform that has taken place, but also because of the unprecedented manner in which it has been implemented. Never ever in the history of legislation making and its implementation, at least to my memory, has a law been implemented with such vigor, with so much of political might being put behind it, so much of effort, stakeholders putting together to come and support the implementation of the law. And it is only therefore that we have seen tremendous progress having been made in such a short period of time. And I think it therefore deserves this pride place in this day of session where we are able to speak about this historical law. And of course, I could not have aspired for a better panel than this to be able to share their thoughts on what they think is what we have achieved so far in nearly 5 years, or a little more than 5 years, and what we seek to achieve or aspire going forward from the stakeholders' point of view and also from the policymakers' point of view. Over to you, Sudhakarji, and thank you so much for chairing this session. Your comments, then we move to the panel straight away after that.
Thank you, Batra Sahab, and also the fellow panelists. And my actually just a small job is to how to set the context right so that discussion can be web around and give a meaningful discussion in moving forward. So I think I recall what Finance Minister, Honorable Finance Minister said in the morning, that it's a evolving law, and she said that legislation and has no hesitation to amend again and again if market so warrants. So this is a very positive vibe which she gave, that so many amendments have happened in a very nascent time, but still you can foresee and you can also visualize that what she has mentioned in the budget speech, a 7th amendment is also on anvil. So topic of the day is basically credible journey of IBC and incredible outcomes basically, and moving forward is the aspect, and each of the panelists would be discussing, so I am not going into it. She was mentioning today in the morning that IBC and other statutes as well have to face the challenges head on and also endure and always work towards a vision which is evolving. It's a dynamic vision concept she gave in the morning, and it is very pertinent in the context of IBC that when we envision we don't have, today I don't have horizon for 25 years coming, as in the previous panel discussion it was said. But what we say is that every milestone, every problem we try to encounter to fix the challenge and give a vision for moving forward all the time. So that is important aspect of IBC. And if you see the first amendment of IBC itself, challenge was basically that promoter himself, the first case settled under the IBC, promoter himself took the CD with 85% haircuts to financial creditor. So that has created some discussion in market that IBC is trying to promote backdoor entry of the promoters. So this has to be stopped. And we have seen the 29A in that. And if you see the first amendment, the vision also come into fore, because vision statement of personal guarantor was also laid down in the first amendment itself. So later it was notified and other things happened, but vision on having some provision going against the guarantors was very much part of the first amendment. Then we had 29A, after that 12A came in, and 30, then the 330 days mandatory timelines were announced, but Supreme Court actually mentioned that this cannot be mandatory, it has to be directory. So these things have happened, and I don't want to repeat because time is very essential today, and just leaving you with some road ahead which we are trying to see, and panelists would be alluding more, is IBC has a mandate which is threefold actually. One is basically rolling out the missing elements, and you have seen discussion on cross-border is happening. We also like to have discussion on group insolvency, individual insolvency and fresh start process, and even mediation. So this is how it would be rolling out in future. These building blocks would be covered in due time. In building institutions, actually, we want to reorient the institutions, and we are saying that IP services have to be professionalized. And also we are trying to see that valuation profession also gets its due, along with credit of committee of creditors. We are saying code of conduct is on anvil. So we are doing so many things which are on the side of building institutions, and process improvement is very important, and we are trying to see that delays which are troubling us today should not trouble us in future. So that's what I wanted to say in the opening remark, and I hand over to Batra Saab for leading the discussion.
Thank you so much, Mr. Chairman. I think, I can understand it's very challenging to sum up the journey of, and such a glorious journey of the IBC in the last 5 years in just about 3 months' time, 3 minutes' time. But I'm sure you'll have opportunities during the next 30 minutes also to maybe reflect on it. We've been talking about 5 years. Now, 5 years is a long time for the market, I understand, but 5 years in the life of a legislation is just a pittance. It's very unfair to expect a lot from a legislation of this magnitude in a period of 5 years. Yet, of course, it has reached a lot of milestones, it has covered a lot of ground. But it is actually something which we need to hear from the horse's mouth. I mean, the main players, the main stakeholders who have been using it, what is their sense of it? And therefore, I'll go straight to Mr. Swaminathan here and ask him, with so much of baggage of Sika that we had when this law came into being in December 2016, what do you think has the experience of banks been in the last 5 years in terms of how the IBC has evolved, how it has served its purpose, how it has met the aspirations of the key stakeholders? Over to you, Mr. Swaminathan, please.
Thank you, Batra Saab, and of course at outside, thanks so much for being part of this iconic week. It's a privilege. Thanks to MCA and IBBI for this wonderful opportunity to be part of this panel. Coming to your statement in terms of as the largest consumer, representing the banking industry of this hallmark legislation, I would agree with you that for a legislation like IBC, 5 years is too short a period, so we can be a little less judgmental in terms of its success or otherwise. Having said that, maybe 2-3 points that I can say to set the context. See, number one, that all of us would agree that IBC has brought a way forward for an orderly resolution of corporate stress, which was actually absent, and as you mentioned, SICA, the CDR, the S4A, several measures of the government or the regulators or the banks putting packages in place was all towards restructuring, and there was very little recovery. And IBC as a legislation has brought an orderly way of resolution of corporate stress, which is very, very necessary. It's important to do ease of doing business is what we all talk about. Ease of exit also should be part of the game. Then only the businesses can thrive and succeed. The efficient ones will get better. The second thing that I would like to mention here, you also mentioned about the stakeholders and consumers like us. See, the ecosystem has got to keep developing. For a legislation like this to realize its full potential, you need the whole ecosystem has got to come. And 5 years, I think, great lot of efforts. Of course, IBBA has done great amount of work, MCA has done great amount of work to support, and as part of IBA, we have also been participating in terms of capacity building. Just take case of, you take the resolution professionals, you have about 4,000 odd people today. But when it comes to complex resolutions, there is not even a handful whom you can rely on. So we have got to invest our time and energy and effort in terms of capacity building for adequate number of skilled resources for as resolution professionals, because once the IBC kicks in, as you all know, it's RP, who's the CEO, who takes charge, and he has got to preserve the value, nurture, and then get it turned around for interesting enough for a resolution applicant to come in. The second, of course, as mentioned by the legislation and the code, and as affirmed by the courts, including the highest court of this country, the Committee of Creditors is an institution of faith, and the commercial wisdom of COC is supreme, is what even the highest court has said. That be so, then it casts upon a great amount of onerous responsibility on the part of the COC. So while a lot of efforts have been done to provide capacity building in COC level, I think we are quite a long way to go in terms of bringing in a lot more professional efficiency and capacity to understand complex resolution. So that's the second thing that will have to happen. Third, of course, the challenges you mentioned. There have been very many efforts, including what the chairman mentioned about the forum shopping and steps to frustrate the positive outcome in the quickest possible time is being attempted by several borrowers. And I think this is somewhere we would require the tribunals to be a bit wary of entertaining this, so that the turnaround time that is envisaged on the court can get realized as soon as possible. These are my initial thoughts in terms of IBC as an experience. Net, if you would like me to sum up, is that it has been certainly a success. Can it be better? Certainly yes, and it's an evolving registration, as the Honorable FM also mentioned, that I'm sure things from here will only get better. Thank you.
Well, thank you so much. And I mean, as you spoke, I was just loud thinking a little bit as I'm speaking out now, that, you know, we all recognize that the insolvency legislation serves a much greater purpose in insolvency, and sometimes it becomes very difficult to even articulate in the form of the statement of objects in the code. Of course, the courts have defined it, have clarified it, and we now have much greater clarity on the larger purpose that the insolvency legislation serves in the economy. But we also know that the immediate urgency in bringing this legislation was the large amount of NPS sitting on the balance sheets of the banks. And in this matter, you, as someone, even in your previous avatar, before coming to the IBA, you had looked at this subject very closely because of the bad bank loan and bad bank solution that was being considered, and of course, you have applied your mind. I mean, do you really think that this is something which has served the immediate need in the short term that was really expected of this legislation? That is to deal with the non-performing assets in a
Thank you, Sumant, and it's a very relevant topic which you have raised. Let me tell you from a banker's perspective, this IBC is the most important legislative reform which has come into the financial sector after this SURFACE. So this reform has made a lot of changes into the ecosystem. The most important change which has brought into the ecosystem is financial discipline. Before introduction of IBC, if any account is getting sick, everybody, the entrepreneurs, everybody was much relieved. They know that nothing will happen because they can go to the SICA and they can keep a long-term forbearance, nothing will happen. Even the judicial legal process may take years together before any stress is resolved, and by that time the bankers will also lose the interest. So this is one reform which has really brought a lot of improvement and financial discipline into the country. And this is very well reflected into the gross NPA figures of the entire banking industry. The RBI data, if you look at, before 2016, like before introduction of this IBC, the gross NPA levels of the industry was into the 7.5%. And now, as on September 21, that is the last published data, it has come down to 6.39. So a drastic more than 1.2% reduction into the gross NPA despite increasing size of the economy. So that is one major contribution this has made. Another important thing is, before that, this insolvency processes in our country was not very well, very systematic. It was having in the form of a bankruptcy was not in a structured way. So this reform has given a freedom of entry and exit in the to the entities. Third major change which this entire IBC process has brought into the entire ecosystem is now with the introduction of Section 29, as rightly said by the chairman of the panel today, that this 29 has really brought a change into the mindset of the promoters. Now they know that if you go for a leveraging, if you go for a debt, then you must keep in mind whether the debt will be serviceable or not. Otherwise, they can lose the assets which they have acquired. And this has inculcated a habit of deleveraging the balance sheets. This has started a habit of mobilizing more equity, putting more stake of the promoters into the system, and that has created a vibrancy. So you will observe that because of these changes into the ecosystem, the delinquencies in the corporate sector has gone down substantially. Even during pandemic time, very few cases came for restructuring and the delinquencies levels have come down to a very great level. So this particular legislation has really made a great contribution in changing the mindset of the entire ecosystem. Now the bankers have also become more responsible. They understand that if they do not take a right time decisions, they will be forced to take the case to the NCLT, and in the process, sometimes you get a good resolution applicant, otherwise the case can land into the liquidation where the banks will have to take a very heavy haircut. So it has disciplined both, not only corporates, it has disciplined the bankers also.
So Sunilji, I'll come back to you again on another issue which is a drop down from this, but I mean, as you mentioned about the fact that the figures themselves speak about the outcome in terms of how it has impacted the reduction of the NPAs or dealing with the resolution. One question that I had from you, for you, Mr. Swaminathan, here is that, while of course in the first 2.5 years or 3 years, if I may say, we saw a great amount of excitement amongst the banks to use IBC. And then of course COVID happened, and COVID obviously resulted in a complete lockdown and slowdown as well. But I mean, we expected that the things would pick up from where they left before the COVID, and you will see again big rush of cases coming into the NCLT by the banks. We haven't really seen that. Or is it just a perception, or is it just or is it a shadow of doubt that is appearing, or is it, what's the reason, or is it just, as I said, a myth?
Oh yeah, that's a good question. Maybe I would like to put that in two parts. See, number one, are there less number of cases being filed or less number of invocations? Yes, that's a fact. The statistics will speak for itself. But what's the underlying reason for the numbers being less is all we know. That we had a period of, all of us are aware, 2012 to 2015, and then 2015 to 2018, the two blocks of a huge amount of corporate stress that we saw. So when the IBC came into being sometime in end of 16, and there were kind of a huge number of cases which have got to be filed. So there is no point in comparing that particular period with the current period, number one. Number two is that, we had about a year of COVID. The invocation of IBC itself was in suspension for about a year or so. And in the year that followed, there was so much of assistance provided by the government and also forbearance given by the regulators that there is not enough defaults, in the sense people who are under stress on account of COVID have been supported as well. So we don't see that much of stress piling up. So these are the two reasons I would see as to why there have been fewer invocations. Certainly, it is not on account of that, bankers are not interested in IBC. Certainly, we are seeing IBC as and NCLTs as one of the definitive ways of resolving corporate stress. But fewer numbers, I think, is a good sign.
Well,
we can be happy with
that's
that.
encouraging to hear because, I asked this question, in fact, largely for the purpose of the market. We understand as somebody who operate within the system as to what the reasons are, but sometimes it's important to dispel the perceptions and impressions that get created because of the slowdown in filing. Yeah, but yes, one thing is a reality. I believe that one of the reasons why probably we could have achieved more resolutions or probably even greater valuations and price discovery would have been had we been successful in developing if I may say, a formidable debt, non-performing asset resolution market through distressed asset investors coming into the country, setting up shops. A lot of them did in the form of ARCs. Their Indian culture is quite really different from that which appears in other parts of the world in terms of how you cherry pick assets which are low-lying fruit at a very high discount. In the Indian market, it's quite unrealistic to expect such heavy discounts at which the offloading of the non-performing assets will happen. But Mr. Dalmia, you have been operating this market very actively. Do you really think that that's a factor that we need to focus on going forward in terms of building a distressed asset acquisition market by even bringing foreign players and also, of course, incentivizing the Indian players?
Sure. Thank you, Mr. Batra. I think it's a privilege to be here. And I think, first of all, if I just step back, I think since independence, this is one of the most path-breaking reforms that we have seen. And I believe that, capitalism without exit is actually socialism for the rich. So people who've got assets, they can just roll over, they take risk, but they don't have an easy exit. So they get supported by the system. And I think this reform has brought in a lot of discipline in both entrepreneurship and even dispensing credit. So I think that's a great thing that you balance the risk-taking in the economy. The second part is I think all assets are going concerns. And when an asset becomes sick, these are national assets. Sometimes it is inefficient, sometimes it is just bad management. I think these are national assets, so they need to be revived quickly to preserve jobs and to ensure that they contribute to the GDP. And I think the fact that 6 lakh crore worth of resolutions have happened is a very, very encouraging sign. And it has a multiplier effect because if the bank balance sheet gets strengthened by 6 lakh crore, the credit dispensing ability will be 4 or 5 times. So it's 25 to 30 lakh crores of extra lending capability. So I think it has been a very encouraging reform. And the second part, which I also feel, is that the government has been very engaged. I think not just they did a bold reform, I think there have been several places where they've engaged with all stakeholders and they have come up with new ideas on what to improve. So all in all, both in terms of, strengthening the economy, providing transparency and just engagement to improve the market, I think it's been great. Now, regarding the development of the market, I would just say that, many times different lenders face different circumstances. And, sometimes when you get into IBC, it's a long process, 330 days. So some lenders may, depending upon their circumstances, want to offload debt early. And if you can provide a secondary market for stressed loans, I think that could be an interesting, thing to examine. What are the merits and what are the checks and balances required before, putting this in place? Like you could sell the loan on an exchange or a, with proper price discovery. So different people can sell their, loans either through the IBC process or through a secondary loan market. I think that will deepen this market. And I've also seen while Indian entrepreneurs are willing to go through the legal proceedings and they have the patience to go through the ups and downs of litigation, many foreign players, stay away from such things. So for them, if there's an easier way where they can buy loans from the secondary market and take the risk, it is something that will invite foreign players a lot more. So I would say overall, it's a path-breaking legislation. Government is very engaged. It's helped the economy, and all stakeholders are contributing to further enhancing the effectiveness of this resolution. And I think that's a great sign for India.
Well, thank you so much. I mean, I think you made a very valid point that, in order to attract investors, especially the foreign investor, you need certainty around the law about the outcomes and also the time that it takes. And that's where we are still making progress. We still have some ground to cover, but I think we are reaching there, and we will in times to come. I just want a 30-second input from you, Sunilji here. He made a point about the secondary market being developed, or the need to develop that. And we all know that. There has been also a market in the past, but it hasn't really gained the confidence of the market as much in the form of asset reconstruction company. Just a 30-second comment from you in terms of what you think is something in the pipeline which we should expect in near future or something like that.
So let me share with you, I think regulator and the banking system is closely working for creating a secondary loan market, and it's already housed in the Indian Bank Association where the platform has already been created. It is under testing. Because right now the IBC offers a platform only when the account becomes sick. So after it becomes sick and it becomes NPA, then only it goes to the IBC. But with this platform, the advantage will be that the account can be, you can have a change of hands, and even the lenders can transfer the asset to another person who want to invest into that asset at a even pre-NPA stage. So that will facilitate a market development for these type of loans, and this is a work which is already in progress. Only thing what is needed is standardization of the documentation processes and the standardization of terms and conditions. So our banking industry is closely working for making this secondary loan market as a reality and an operating unit in a short period of time.
Excellent. Thank you so much. And that's very heartening news. I mean, I think that's what really the market desperately needs, to be able to complement the insolvency law, because insolvency law doesn't work in isolation. You need a whole ecosystem around it. And whatever we can facilitate to even prevent an insolvency is a part of the ecosystem in that sense. I just want to ask one question to you, Shuklaji, before I really move to the next, the futuristic aspects of the reform. There has been a big debate about the insolvency resolution versus liquidation. Some people believe that liquidation is also part of the insolvency. I mean, if there is no real value, why should we desperately continue to attempt the resolution when we know at the end of the day, you will actually end up in liquidation? It's just like kicking the can down the lane. Do you really think that, and from a regulator's point of view or a policymaker's point of view, what is your take on that? I mean, we know that people see the numbers, they say, oh, a lot of liquidations have happened, or the resolution is not working. I mean, that of course is a myth. You may want to dispel that. I may have a comment on that as well after you've spoken.
Thank you. Actually, if you see the numbers, and I don't want to quote them because there is a paucity of time, but if you see the numbers, dispensation under resolution, adding 12A and the inherent powers of AA, these numbers have been actually much more than the liquidation numbers. So that is very clear from our newsletters, all the time we are saying it. So just to say that liquidations are more is perhaps a misnomer to start with. But I will just want to add here that code provides reorganization, and reorganization has two elements, resolution and liquidation. And it is left to the market forces actually to see which kind of reorganization is better suited for a particular class of assets which we are discussing.
Right. Yes, of course. I mean, and globally it's well recognized that even liquidation can be a form of restructuring, because at the end of the day, the assets you sell in liquidation go back into the economy, into the hands of probably more efficient managers. You still are able to create employment around it and jobs around it. But that's again a separate debate for a later date. I need to move on to now the futuristic thing, and of course, the most topic and important topic that you had saved for you, and also I think which the market really wants to learn. Cross-border insolvency law is something we all have been eagerly awaiting. It's been quite a while. There have been discussion papers, there have been draft bills, there have been comments by the parliamentary committee, but we haven't really seen it seeing the light of the day. But that apart, please tell us about it. I mean, what's the thinking of the government at this point? What's holding it back? Right.
Thank you, Mr. Batra. As emphasized by the chair and my learned co-panelists, I would like to reiterate that the central government is continuously trying to strengthen the IBC since 2016 based on market realities and emerging jurisprudence. As a result, the code has evolved into a very dynamic economic legislation almost. It has undergone 5 major amendments. The latest one was amidst the COVID pandemic, where the MSMEs were tried to be salvaged. They were provided a much easier exit process as they were severely impacted. As regards cross-border, you would know that the process started with a number of committees making their recommendations. The report of the Insolvency Law Committee was submitted in the October of 2018, which primarily recommended the UNCITRAL model, and it undertook a clause-by-clause analysis of the model law and suggested certain modifications to make it suitable to the Indian context. On this basis, it recommended draft provision of cross-border insolvency for insertion in the code. In the January of 2020, our ministry constituted a cross-border insolvency rules and regulations committee, that is the CBIRC, to recommend subordinate legislation for draft provisions on cross-border. The CBIRC submitted its report in June 2020, and this report provides recommendation on draft rules, regulations, notifications, guidelines, and capacity building on cross-border. And it also suggested few more modifications on the ILC. Accordingly, government undertook massive public stakeholder consultations on both the ILC and the CBIRC report way back in 2018 and again in 2021. The cross-border insolvency-related work picked up again in 2022, where the Union Finance Minister in para 76 of her budget speech 22-23 has said, necessary amendments in the code will be carried out to enhance the efficacy of the resolution process and facilitate cross-border insolvency resolution. It is felt that enacting legislative provisions on cross-border is not only essential on emerging issues on cross-border as seen in the recent cases, but it will lead India to a much higher growth trajectory. With the geopolitical axis changing in the near future, we are really looking forward how the geopolitical scenario is going to be aligned and which way we are all moving towards. And I'm sure as all interministerial consultations are going on, but public comments have been received and were under active consideration of the ministry, we might see it in the near future. That's all I can say as of now. Thank you.
All right, so I'm going to ask you a different question. How would you define near future? How soon?
Silence from a government servant.
I know, and I expected the reply. I do understand. It's a difficult question to answer, and I also didn't expect a definite answer because it's a complex policy issue, and we all know that the implications of that will be enormous, and one has to fully comprehend that before one is able to sort of take it to the parliament, and the parliament is able to debate it and enact a law for us. I mean, normally I would have ended the panel session with a rapid fire, which I normally do, but this session itself was a rapid fire with just 35 minutes. But I'm going to take a liberty of asking a couple of quick questions from some of the panelists, not all. I don't have the time, unfortunately. I'm going to ask Mr. Dalmia, you one question, and just one line answer, please. Would you be fine with the legislation coming on how much haircuts that the bank should take? Do you think that the legislation should prescribe that in any manner, how much haircuts the bank should take, or should it be left to the commercial wisdom of the bank?
I think it should clearly be left to the commercial wisdom of the COC, because it's their skin in the game and they are taking all the risk.
All right. Okay, so Mr. Mehta, again for you, I mean, I know this is a difficult one. Again, at least from my perspective, it may not be for you. Do you think that you need regulated guidelines for the COC functioning, be it in the form of code or whatever, or do you think it is something which is left to be applied voluntarily by the banks to the COCs?
One thing that outright I'll say that yes, ethical conduct of COC is a must, and it need total understanding of how to conduct it in the best interest of all the stakeholders. Having said so, let me tell you 2-3 things. One very important thing is, if we codify this code of conduct, we would not have reached the level we have reached, because a lot of judgments and decisions have been taken by the COC, which got later on the jurisprudence support also in the way for value maximization. And in one of the case, like one of the panelists, he knows very well about it. One of the case where the highest value was offered, even more than 100% value was, I can even quote the Benani Cement case and all that. So 100% value, because COC could dare to take a decision of differing with the highest bid and getting a higher value, and the interest of everybody was maximized. Similar thing happened in the other cases also. I can position power was on other cases and similar cases. So what I mean to say is, if you codify everything, then people will say 1, 2, 3. I'll go for only this option. I'll not go for the another option. Right. What COC is doing, basically COC is stepping into the shoe of an entrepreneur. Right. They are replacing the entire board.
Sorry, Suliji, I mean, we're short of time, but thank you so much. I mean, I think we have your answer, that what you're saying is that there is a need to have guidance for COC, but codifying it may not really be the answer in that sense. That's what I answer. So, I mean, I think I'll leave it at that, because we were told there's 35 minutes reduced, an effort was made to reduce it to 30, but we didn't agree. We said we'll stick to 35 minutes, and we have stuck to 35 minutes. So thank you so much, Mr. Chairman. I would have loved to give you some closing comments as well, but unfortunately, we don't have the time. But I'm sure what we will do is, at least I'll try to do a synthesis note of what we have discussed, the comments that have fallen from the esteemed panel, and do a one-pager for you to consider as the takeaways from this session from the panel. And I apologize to the audience as well that we couldn't give you the time to ask any question that you might have. But please feel free to ask me or the other members of the panel as we step down on the sides. If you have any question, we'll be very happy to answer. But I have to apologize, we just didn't have the time. So thank you so much for your attention.
Yeah. Thank you, Mr. Batra, for this excellent session. You've been an excellent moderator, adhering to the time, very responsible moderator, in fact. Thank you. And may I request our chair to kindly present the mementos to everyone. So, may I, in fact, request Ms. Nandita Mishra to kindly present the mementos to all. Including the chair. Including the chair. So let's thank first our chair, Shri Sudhakar Shukla ji. Our panelist first, Shri Sunil Mehta. Thanking Shri Puneet Dalmia. Shri Swaminathan ji. And a big thank you to our moderator, Shri Sumant Batra ji. So meanwhile, as we close here with a group photograph, ladies and gentlemen, requesting you all to remain at your respective seats. We are moving straight into our next session. And herein, we are going to be understanding the important role of the independent directors in corporate governance, who in fact as mentors and guides and even watchdogs and conscious keepers of corporate governance. We once again, as I invite our speakers here, just requesting if we can have this session for half an hour. I invite first our chair and co-chair of the session, Shri Saurabh Chandra, ex-secretary, Government of India, who's the chair of the session. May I request you, sir, to please join us. And Ms. Anita Shah Akela, the joint secretary, Ministry of Corporate Affairs, the co-chair of the session. Our panelist, the moderator of the session, Dr. Neeraj Gupta, head of the School of Corporate Governance, IICA. And as we look into the role of the independent directors, we have the ex-MD of 3M India, Mr. Ajay Nanavati, as our panelist, and ex-chairman, Bank of Baroda, Mr. Anil Khandelwal. So with that, welcome once again to all our esteemed panelists of the session, and I request Dr. Neeraj Gupta, the moderator of the session, to take over from here. Thank you.
Ladies and gentlemen, my name is Neeraj Gupta. Thank you. And I welcome you all to this panel discussion on the subject of role of independent directors in Indian corporate governance. I'm very happy to introduce you all with the distinguished panel we have. Mr. Saurabh Chandra, the chairman of the panel, ex-secretary, Government of India, and also chairman of MCX. Sir is serving as an independent director to a number of boards, including SBI pension funds. I'm happy to introduce Ms. Anita Shah Akela, the Joint Secretary, Ministry of Corporate Affairs, a seasoned bureaucrat of Indian Audit and Administrative Services. To my right, I have with me Mr. Anil Khandelwal, ex-member Banks Board Bureau, the apex institution of the country for selection of key positions in the financial institutions, and had been serving as chairman Dena Bank as well as Bank of Baroda. To my extreme left, we have Mr. Ajay Nanavati. Sir had been instrumental in establishing 3M India, right as the first employee to the position of managing director, having served Singapore and USA both, and later joined the public sector, that is Syndicate Bank, as chairman. I understand in the interest of the time, we have 30 minutes. Now, in order to begin with the transaction, I would request the chair, Mr. Chandra, to address the group.
Thank you, Dr. Gupta. The role and contribution of independent directors has come in for intense scrutiny and criticism in the wake of a number of corporate governance failures in recent times. SEBI duly took note of it. It brought out a consultation paper on the 1st of March 2021, invited public comments. After going through them, it amended the LODR regulations in August. And the idea was to strengthen the position of independent directors. And they touched upon subjects like their appointment, reappointment, dismissal, related party transactions, definition of independent directors, etc. SEBI having done its job, the ball is now in the court of the boards and the independent directors to stand up and be counted. There's a very interesting article about 30 years ago in the Harvard Business Review. Why do good managers make bad ethical choices? It holds true today, and if you would apply it to the governance failures in India, a lot of it would be true for them. The first reason that he gave was that they don't really think they're doing anything illegal or unethical. Everybody's doing it. The second reason that he gave was that it is in the interest of the company. It is knockout competition. Third, they believed that they're unlikely to get caught. And even if they are going to get caught, the company will stand up, either condone it or delay it. And this is one of the reasons why you find that financial misdeeds are often detected many, many years later. And by that time, the horses are bolted. Now, what can be done? I think the most important thing is the board culture. And culture, as was defined, organization culture is about how things are done in the organization or on the boards. How are decisions taken? How are meetings conducted? The board has to function as a team. The structural changes have been brought about. It is now to work as a socially cohesive unit where the directors are willing to question assumptions and beliefs behind all important proposals. Questioning dissent cannot be taken as disloyalty or obstruction. There was a joint MD of ILFS called Mr. Saha, who wrote an email to Mr. Hari Shankaran saying that the independent directors should be obedient and non-intrusive. Now, if that is what you're looking for, then you're getting into what is called either the Abilene paradox or groupthink. When everybody thinks alike, nobody thinks much. How do you do it? See, there has to be mutual respect, trust, candor amongst the board members. That is the kind of culture that independent directors and the shareholder directors have to sit down and build. Structural conditions like rules, procedures, composition of committees, attendance, cognitive diversity, etc., a lot of boards had. Enron went belly up. Do you know who all were in its board? There was the Dean of Stanford, who was a professor of accounts there. There was a CEO of insurance company, an international bank, a hedge fund manager, a prominent Asian financier, and an economist who was the former head of the Forward Markets Commission of USA. They followed all the standard governance practices. But let us remember that structural changes are a necessary condition, an enabling condition. They are not a sufficient condition. For sufficiency, it is the board culture which will depend whether we follow the exemplary standards of governance that we are required to follow. Thank you.
Thank you, Chair. Thank you, Chair, for setting the tone of this panel. Board independence have taken such a pivotal role in the corporate governance norms of the country that it is considered to be indispensable. And it's the biggest duty of independent directors to stay independent, not just in the eyes of law, but also in terms of their opinion and contribution in the board. Let's slightly move to what Madam Anita Shah has a perspective. She represents the Regulatory Ministry of Corporate Affairs. Over to you, ma'am.
Thank you, respected chair, panelists, and my colleagues of the dais. The Companies Act 2013 has the shareholders' rights and democracy as a cornerstone. It has brought about sweeping changes to the corporate and governance environment in India. One of the areas which this act has brought into focus, a sharper focus, is the role of the independent directors. To my mind, the independent directors are the crucial interface between the promoters and the management on one hand, and the minority stakeholders, shareholders on the other. They are supposed to build, or they are expected to bring in outside-in views, enhancing the corporate governance standards. They're supposed to assist in implementing sound corporate governance practices, contribute to transparency, performance, and overall good governance. The roles and responsibilities of the independent directors have been codified for the first time in the Companies Act 2013, and this is due to the fast-changing business environment, corporate malpractices and failures, and governance lapses. There have been very clear indications on the requirement and the qualifications of the independent directors. The key responsibilities of the independent directors, which have been divided into strategies, risk management, internal financial control being one pillar, related party transactions being the second, ethical and compliance oversight being the third, and succession planning and executive remuneration being the fourth. Now, I will mainly look more at the effective discharge of the responsibilities that is expected from the independent director. There is a constraint on the amount of companies that an independent director can hold. The main reason behind this is they are expected to devote sufficient time and attention, do a lot of background work on the companies in which they are members, they are directors, and they have to also they must do an induction and a continuing education program to get to know more about the company, because it is expected from the independent directors, the wealth of knowledge that they bring from the, because they are selected from the outside place. So they are supposed to get a wealth of knowledge into the company based on the ecosystems outside. So, and then they have to also set the agenda, they have to give independent professional advice, and they should do a performance assessment of the company. Now, diversity, to my mind, is an effective, integral part of the effective board composition, and this should be a place where gender diversity also should be a part of it. And getting women director also has been codified here, but independent directors as women directors also would be of great use. To conclude, I would say that regulations are at best a starting point. You cannot legislate good behavior. Every company needs to decide the structure of the governance that best serves its objectives in terms of sustainable growth and value creation. Corporate governance is just not a compilation of norms and procedures. It is the way in which the companies conduct business. It is important to set the right tone at the top in terms of ethical leadership of the board. Independent directors as a group can play the role of change agents. They can foster all the energies of the board in the right direction. They have to foster a climate of trust, candor, integrity, and establish individual accountability, which would go a long way in meeting the good corporate governance requirements. And to tell you the truth, the independent directors from a legal standpoint is merely meeting the required criteria, but the independence in substance is actually a different ballgame altogether. This stems from professionalism, both at the corporate level in terms of how the company approaches the subject of the board composition and processes, and at an individual level in terms of how the independent director gears himself or herself up for effective board service. Having a better understanding of the roles and responsibilities as well as the risk and liabilities can help the independent directors add greater value to their organization, become more effective as an instrument of corporate governance mechanism. Moving forward, India will do well to increasingly brace for the global trends such as emergence of lead IDs, diversity in board composition, increasing shareholder activism, and a transition towards a stakeholder approach. Thank you.
Friends, the institution of independent directors is not so much old as we find traces in the West, specifically US and UK. In 1999, when Kumar Mangalam Bigla Committee first referred to this institution as something which can set new standards of corporate governance in India. And now, as Ms. Shah has very briefly touched upon multiple aspects, which indicates towards the regulatory framework which is ever evolving, placing onerous role on the shoulders of independent directors to contribute. Let us hear from a practitioner, Mr. Khandelwal, who had been a transformative leader across organizations. What he has to say, he has seen the table from both the sides, as an independent director as well as the leader of the board. Mr. Khandelwal, please.
Thank you, Dr. Gupta. I won't hesitate to take the role you have defined, and I would be a bit brutal as well, because when we meet in these kind of conventions, let us not get away with shoulds. The board should do this, independent directors should do that. There are a whole number of books, articles about it. What is it that independent directors, with all the wonderful qualifications, expertise, and designations, fail to perform? What is it? I will try to cover two dimensions of board effectiveness. A lot has been written on compliance, regulation. We have fairly comprehensive Companies Act. I think the real devil is the social system inside the board, the social dynamics inside the board. There are two kinds of asymmetries in the board. One, the asymmetry in knowledge between the management and the directors, and the asymmetry between the directors. Management wants to inform most of the time what it wants to inform. And therefore, one of the role of independent directors and the collective independent director is to seek as much information on an issue as possible, not looking at watch when meeting is getting over and lunch is late or not. It's extremely important to ask right questions. It's not time to tell you what could be the right questions. The second dimension of social system inside the board is lack of consensus. One director has an issue, very sensible issue, and his co-directors say, it's okay, why do you bother? I think things are okay, fine. I think this lack of consensus within the board is the real devil in the board. The second thing is that our boards are very operational. In some ways, as they say, they are clerks of works. Our boards are clerks of works. There's so much of agenda, so many things to be done, there's so much of compliance. I think it's time for directors to question that. Why should one go through in an oil industry a project report or 250 page? Or a project report or an advance proposal, a credit proposal of, let us say, 300 pages. I think the board should really decide what is important to them, what it wants to do, what agenda it wants to go through, rather than the boards are captured by the promoters. This capturing of board by promoters is the real issue, at least in the promoter-driven company. In some sense, I believe in public sector, there is some tokenism and there is embedded governance. But in the promoter-driven company, there is discretionary governance. This much governance we will practice till the regulator catches us. So I think it is the job of independent directors, one, to move from operational mindset of the board to strategic mindset. Now, what is a strategic mindset? The strategic mindset is, how do we make this company future-proof? How do we make company disruption-proof? How do we make company technology-ready? And let me also share with you, based on my experience, that the technology risk is the biggest risk today. And for God's sake, do not get persuaded by your internal chief digital officer what he tells you. Not that you don't trust him, but then he would tell you everything is wonderful. It's time to invite outside experts by the board. It's time to invite outside consultants from the board and understand as to how company can be disrupted. By whom? What kind of competition? I think this is very important that board starts using other experts. Our Companies Act provide for, I think, independent directors to engage consultants. How many boards are doing it? That is one. The second strategic issue, according to me, is the edifice of human capabilities in the organization, the edifice of critical skills in the organization. Just imagine, the other day I called on a colleague who is managing director of a large bank, and he was shocked. He said, Dr. Khandelwal, do you know, I don't have credit chief, in the sense that when present credit chief goes, I really can't lay my hands. Just imagine the risk. So this whole business of risk management is also capability risk, human resource risk, critical skills risk, succession risk. Somehow these are underrated things, and most of the time management does not put human resource risk as a risk to the board. The third is the leadership bench strength. We all talk, but I tell you, this is such an important dimension. In a large organization, do we have distributed leadership across? The operational leadership, the business leadership, the strategic leadership. How do we groom leaders? Where we groom them? Is it a Saturday, Sunday program or some comprehensive strategy? This is third. The fourth is ethical architecture of the company. How do you monitor the ethical architecture of the company? Do we wait for a scam? Do we wait for newspaper reports? So how do independent directors create discussion on ethical adequacy of the infrastructure? How do you monitor large value frauds? How do you ensure that your people carry reputation? Finally, I would like to make 3-4 points, a very small one, that there is too much spotlight on independent directors. There is too much, and there are no rewards for independent directors. Do we send independent directors abroad for training? We should. There should be budget allocated in company for giving them best of the international exposure. The second is limits on the board. I tell you, if any independent director says that with committees and the board he can manage more than 2 or 3 boards, I will be very doubtful. And therefore, the board should be limited to maximum 3 for independent director, but with enhanced compensation. And a lot needs to be done. If people raise issues, they resign, or they point deficit governance, it's sure that they won't be, their term will not be extended, or they will be blacklisted by the other. I think government should come to their rescue. The regulator should come to their rescue and nominate them on still better boards. It's very important to encourage dissent. It's very important that the government and the regulators come to the rescue of those who raise issues, those who raise dissent, because the message outside is that if you raise dissent, if you point out issues, you are, by the social system of promoters, you are isolated, and the word goes on, he's a troublemaker. I think we need in a growing society, troublemakers as many, if not in that sense troublemaker, but people who can raise question. I think we should move from a time when a board becomes an assembly of deaf and dumb school. We must have talking board, we must have listening board, we must have a learning board. With this, I will close my presentation. Thank you.
Talking, listening, and learning board is the catchline, sir, you have given us. Now, let me move to Mr. Ajay Nanavati. He had been leading 3M India, one of the Forbes 500 company. So let us hear his perspectives in terms of the role which independent directors contribute in a multinational, what kind of culture and what kind of listening and learning happens.
Thank you, Neeraj. Hello, everybody. You know, the disadvantage, sorry. Am I not? Yeah, sorry. The disadvantage of being the last speaker is that everything you wanted to say has already been said. So it's going to make my job pretty easy. But I just thought to share some perspectives based on my own personal experiences. I think, you know, we have to start, the topic today is about independent directors, but I truly believe that irrespective of whether you're an independent director or an executive director, the minute you are managing other people's money, you have a fiduciary responsibility to them. So we keep picking on independent directors, but and I will expand on that in a bit, but I think to me a director is a director is a director. You know, whether you're wearing an independent director hat or you're wearing an executive director hat, you have a fiduciary responsibility to your community of shareholders. In the Asian context, including India, typically we tend to have very, you don't have that breadth of external shareholders, largely very concentrated ownership, which you don't see so much in Western countries. And that's why you feel the need for independent directors to actually play a checks and balances role beyond merely just a director. If you are in a truly dispersed ownership model, which you see in the Anglo-Saxon world, that is sort of built into the system. But here, because we have this concentrated ownership, there is a tendency to look at independent directors as checks and balances. So to me, the whole process, we've talked about everything that should be done, but to me it starts with how you bring an independent director in. As the old saying goes, and pardon me for my crude language, garbage in, garbage out. You know, you've heard a lot of talk about how even the most eminent boards, with the most eminent rock star board members with impeccable credentials, still ran into significant problems and fiascos. So to me, how you identify, I frankly feel we spend more time trying to identify, interviewing, developing job descriptions for senior executives much more than you do for appointing an independent director. Typically you pick up the phone and look to a friend and say, somebody, you know, do you know somebody who can bring this? But I don't think we do enough of a job of that onboarding process, about that initial selection process. So I'm a big believer in bringing in complementary skill sets. All the boards that I'm involved in, we make it a point in advance, 2 years before the person is retiring, to identify what skill sets do we need on the board. We go through a robust sort of a gap analysis of competencies that are required to make this an effective board. So to me, the nub of the issue starts with the selection process, how you onboard, bring in people. So you need to be very clear that you want to get a diverse board, you want to get a challenging board, you want to bring a board that has experience. And when, you know, nowadays diversity is often talked about in the context of gender. And I often clarify, to me, diversity goes beyond gender. It goes into experience, ethnicity, background, experiences. So there are a whole broad set of criteria that need to be used to who you decide to invite to your board, because to me that makes a big difference. Because too often the independent directors who are bought into boards are beholden to the management that brought them in place. So it's like you know, the fox managing the chicken coop. You know, you scratch my back, I scratch your back. So I think this whole process, and I've spoken to other colleagues of mine who get invited, and it's the diligence process and the robustness that goes into selecting. There are search firms who actually make a living of identifying suitable directors and bringing them in. So to me, it starts with that whole process of really having clear expectations of your directors, what you ask of them, what skills do they bring to the table, how well they work together, how much they challenge each other. No director can know everything about everything, you know. So I think we have to recognize that we all have our limitations, and I think Anil touched upon this, about which I do on other boards, is bring in subject matter experts, domain experts, when you need them. I mean, for example, cybersecurity. I know very little about cybersecurity, which is now becoming the topic of discussion, or ESG for that matter, which is one of the hot topics on board meetings nowadays. So you have to bring in subject matter experts, domain experts who can come and teach you. You need to have an open mind, you need to be willing to learn, and you need to, it's a continuous process. It's not like a tick box that I've done it, and now हाँ मुझे सब पता है तो कोई सीखने की ज़रूरत नहीं है. You know, so I will leave it at that, and I can go on for this for hours, but it is a subject that I think starts really with the process that we use for bringing on, selecting, identifying, nominating, recruiting, interviewing external directors as you bring them onto the board, recognizing that you don't want to be surrounded by yes men, haji. You know, so I think one of the key skills for an independent director is what I call being dispassionately passionate. You have to be passionate about the company that you're associated with, but you have to be at the same time dispassionate, to be able to sit back and wear that dispassionate, passionate hat. And again, in my last closing comment is, you know, we talked a lot about the regulatory aspect of it. There are all kinds of regulations in place, but despite that, we've had all these fiascos. So it boils down to what I call niti versus niyat. You can have all the best of intentions, you can have all the laws in place, but if your intentions are not there, if the niti doesn't meet the niyat, everything else is foregone. Thank you.
Thank you, Mr. Nanavati. Taking cue from your focus on skill and diversity aspect, I'm taking a bit twist. Of course, we are appreciative of this fact that in terms of data, India is close to 12% of women representation on board, very soon going to be a member of 2020 club. I'm reaching out to Ms. Shah on this question. Still, there is much to be done and appreciative of as far as the question of having board diversity is concerned, the gender diversity per se. So what do you see like boards and companies need to do to be more appreciative of this so that we have more inclusive boards and diverse boards?
Thank you for the question. Definitely the steady elevation of diversity, equality, inclusion, which has now become the top of the corporate discourse, is a heartening development. In my view, gender, the reason why women are not coming up, or the existence of glass ceiling, is probably a myth. There is no dearth of talent. In fact, if you have women, more women, if you are not anti-women or you do not take women, then your talent pool really expands. For instance, government as a model employer has never ever distinguished against women. That's the reason I am sitting here, and a lot of my colleagues are. And what I have been able to understand talking to a number of people is that there is an issue of retention of women at junior and middle level. See, we have to understand that there are events which happen in a woman's life, that is marriage or childbirth. So what is required from the corporate setup is that there has to be an effective talent pipeline where the women should be able to rise at the junior and middle level. They have to prevent permanent attrition of women on account of events like marriage, childbirth, etc. Make it easier for them to navigate the professional career around these events. Second, also make it very easy for the experienced women professionals to return to work after these events have occurred. There has to be an enabling environment, and once you have a talent pool at the junior, middle level, they will automatically rise up to the director level and the board level also. Thank you.
Okay. Let's moving on the similar aspect of diversity now, this time having focus on skills, and as SABI regulations also ask companies and specifically NRCs to engage on analyzing the skill gaps available in the board. I'm going quick to the chair for his perspectives as to where does he find Indian companies and specifically NRCs working on this aspect, appreciative of the diverse set of skills to be there on the board.
You see, the LODR amendments which took place in August 2021, they talked about these gaps in skills and what NRCs are supposed to do. It's a very important point on which discussions have been held. But the point is, you can put the best of regulations in place. Finally, it boils down to the intent. What do you exactly want? Now, the gaps, one of them is, as we move towards digitalization, this gap, and increasingly cybersecurity is becoming a major concern everywhere. So you need somebody who's an expert in the digital economy. For example, in MCX, we have put a gentleman called Dr. Gerola, who is DG of NIC, and he's been a great asset. We need to look for such experts. Similarly, another gap that we usually find is HR. See, succession is something which is often overlooked, especially in promoter-driven companies. If, God forbid, the promoter leaves for some reason or the other, then you have a major issue. And there are often disputes within the family as to who will succeed. That's a very tightrope walk. Now, these are some of the things we can actually go on discussing for the rest of the afternoon, but we are running out of time, so I'll cut short here.
Thank you so much. Just a very quick question to Mr. Nanavati. As we have seen turbulent times during pandemic and have seen business continuity as a very big challenge, what is your take, very quick take on how independent directors can help companies to emerge resilient?
So I think, some time back I was on a similar panel and we asked, what is the absolute most important trait that you look for in an independent director? And the answer was spine, backbone. That to me was the number one trait, that is a key trait for an independent director. So I think, over the last 2 years, I've been on more Zoom calls than I want to think about. But I think the one thing about Zoom calls is what I really miss is that body language. You're sitting there in the room and you're reading the body language of your colleague director on the board. That gets lost in this Zoom era. And I've always felt that one of the key things is to be able to look your fellow director in the eye and see where he's coming from or where she's coming from, and sometimes you agree to disagree. One of the things that I'm very particular about is that the board minutes, which are supposed to be the only true reflection of truth as to what actually transpired, should actually capture any dissenting voices. And very rarely have I seen this in board minutes where a dissenting voice has been captured. I'm all for consensus. Don't misunderstand me. I'm not saying that you need to, everything needs to become a battle. But we need to be having that ability to capture any voices, multiple voices, in a diligent manner. So I think one of the big things that's happened over this last couple of years has been that the importance of capturing the minutes. Now you record, all the minutes are recorded on Zoom calls. Every board meeting is fully recorded. So there is a paper trail or a video trail. But I think it's really important to ensure that the agendas are properly structured and that the minutes are adequately captured.
Thank you, sir. There are many more issues we can touch upon. The challenges and opportunities as well are quite vast, and we can take hours to deliberate and collectively chart out a path which can further strengthen this institution. But in the interest of time, I'll have to close. Just one or two points which I would like to make. The panelists have made it as a point that intent needs to be good. What I can say as a positive side of the aspect, regulators are very high, setting the highest possible standards of, let me just finish this. Let me just finish this sentence. Regulators are quite high on setting highest possible standards and taking cue for it, because what is required is competence, capability, and also commitment and courage to contribute in the boards. The ministry has taken a big leap in taking the initiative of setting up independent directors data bank, which is just not the repository, but also contributing in terms of capacity building. So with this, I'm quite hopeful that this institution is going to evolve in a manner regulators want for a brighter future and highest possible standards of corporate governance in India. Sir, please. Yeah, please.
See, I'd drawn attention to the LODR amendments, where they said now you need a special resolution to appoint an independent director. The idea was that the minority shareholders, which would include institutions, would have a say in that. And what we have seen in the recent past, there are a number of independent directors and fairly high-profile ones, and the institutions have voted against them, and some of them have not got the job. I wouldn't like to take their names here, but it's all in public domain. But this remains an issue, because you need the support of the promoter to get that 75%. And therefore, see, we all have to operate within certain boundary conditions. Now, we are hemmed in by the law. And that being so, what best can we do within those boundary conditions?
Yeah, sure, please.
I'm sorry, I can you speak up? I'm sorry, I'm not hearing you clearly. No, thanks. Yeah, no, great question. I think it's not a question of, I guess there are some cultural nuances that play into this. But in reality, I think if there is clarity and transparency, I think one of the key attributes is transparency. You know, if you are transparent as to this is the profile, you know, the boards that I've been involved with, typically you have what we call a slate of candidates. You know, you're not presented with one candidate, you know, this is the person, take it or leave it. You know, you are normally presented with a slate of candidates, that these are the potential candidates. They have particularly unique skills, and you have a sort of a benchmark, you have the ability to, just like you would hire a senior executive in a corporation, you would have a slate of 2 or 3 candidates, and you'd say, okay, which is the one that best fits the need. Doesn't mean that the others are incompetent or are not suitable. It's just that for that particular role, if I'm looking for somebody who, as you said, HR or technology, how many Indian boards do you see with a CHRO on the board or a CTO on the board? There are a few, but the exception proves the rule. They're largely chartered accountants and lawyers, you know, and which is very different from what I've seen on the boards that I've been involved with globally. And the other thing that in India you don't see enough of is working directors, managing directors of other companies who are directors on a company. In the US, it's very common to have executive directors of working directors of other companies being directors on other companies. You very rarely see that in India. That's another solution in my mind. Again, there might be some regulatory aspects to it. Of course, the one being that how much time can that person put in this role, given that he's a full-time working director in another company. But in most of the companies that I've been associated with, we have full-time company executive directors who are directors on other companies, who bring real-life experience. I got to shut up because I'm running out of time.
Thank you, sir. We are running out of time, and before I close, I could not refrain myself. Mr. Khandelwal has touched upon social systems, and these are the days when boards are widely talking about ESG. So any powerful message, sir, you would like to give on companies to have more focus on E and S also, moving beyond just governance?
Here, I still find this whole ESG is very important, but is very esoteric as of now. Very esoteric. I think board has to, first of all, do what it can do best. Creating competitive advantage for their respective companies. This is the fundamental job. Manage their internal social system, that there is collective voice of the board which is taken very seriously by the promoters. Assert itself, and of course, the agenda like ESG and other, but I think if the ESG agenda is pushed too fast within the existing system, this itself can be a casualty. So I am for overall effectiveness of the board, and of course ESG is a very welcome thing. Thank you.
Thank you. Here I declare the close of this panel. Thank you so much. Thank you for being with us.
So thank you very much to our chairs and also to our moderator. May I request Ms. Anita Shah to kindly present the mementos. Our utmost thanks to our chair, Shri Saurabh Chandraji. Many thanks to Mr. Ajay Nanavati for giving very fair, candid and very impactful views of his. And Mr. Anil Khandelwal. Thank you, sir. And thanking our moderator, Dr. Neeraj Gupta. We'll close with a group photograph. So, group photograph नहीं पर कर लेते हैं? Yeah, front कर लेते. So we have 2 more technical sessions before we have the plenary session. And as we move into the next session, I'm just being little time sensitive and just utilizing the time to just surprise you of the other sessions also. So the technical session next we have is on the role of professionals in corporate governance and nation building. And the further is going to be, the next is going to be towards, we're looking into the mergers and acquisitions, the control regime in India, and promoting a more competitive structure in markets. The last will be the plenary session which we have, wherein that's going to be chaired by respected Secretary, Ministry of Corporate Affairs, is going to be joining us in the last session. And in this session, we have the heads of the professional institutions under the Ministry of Corporate Affairs as our eminent panelists. Let me first invite the chair of the session, Shri Inderjit Singh Dhariwal, Joint Secretary, Ministry of Corporate Affairs. Our panelist of the session, the moderator first, Ms. Mithilesh, Advisor, Cost Cost Audit Branch, Ministry of Corporate Affairs. CS Devendra V. Deshpande, President ICSI. CA Dr. Devashish Mishra, President ICI. And CMA P. Raju Iyer, President of the Cost Accountants of India. So I hand over the floor to our moderator, Ms. Mithilesh, to take it from here, and probably we can have first the opening remarks from our chair, and then we begin the discussions.
Good afternoon. I've been taught, if the person is big, less should be said. The post is higher, again, it doesn't require introduction. In president, it's such a superlative degree, it doesn't require any adjective. And we have today 3 presidents on this panel. I'm really elated to be on this panel that is going to discuss role of professionals in corporate governance and nation building. Professionals, as I think, are pillar to any structure of governance because they provide strength through their in-depth experience, understanding of complexities, and the capacity to evaluate, pragmatically evaluate the options in decision making. With these capacities, the professional steers or take corporate through to success. The professionals also works as an interface, a number of other dimensions those a corporate faces, including sectoral standards, sectoral regulators, and laws. This is why probably one of our mantras says, the governance, more of a governance, less of a government. And this I equate in this particular way that on the same page, like in balance sheet, on the other side, we have a corporate governance, which is a synonym to good governance, which has, and this is how I correlated, it is participative, inclusive. It stands for integrity and transparency. It looks forward, it promotes accountability and responsiveness. This is how the system of corporate governance and professional works. In this country where we want and we have a target for ourselves as a 5 trillion economy, we need to attract resources around the world that includes funds, professionals, and technology, and provide an ecosystem with stability and target new market economy or new business models, new business areas, and as well as knowledge-intensive methods that will provide the requisite strength to the corporate, that will ensure the success to individuals. All these units together will ensure this prosperous and strong nation that we are looking for. This is how the simplistic expression of the topic comes. But I definitely have 3 professionals to talk about, and I'm also eager to listen to them. And I hand over to our moderator, Ms. Mithilesh, advisor cost, my colleague, to coordinate the session. Thanks.
Thank you, sir. When we think of corporate governance, 3 institutes under the administrative control of Ministry of Corporate Affairs come to our mind. Institute of Chartered Accountants of India, Institute of Cost Accountants of India, and Institute of Company Secretaries of India. Today we have the head of all the 3 institutes. These 3 institutes are pillars of the corporate governance. They are working in sync with the government to promote corporate governance from a very long time. So we'll hear from them what are the initiatives they have taken for promoting the cause of good governance in corporate sector, and the future plans of their institute. And this is a common question to all the three institutes. They can take 5-6 minutes to explain this. Thank you. We can start with Mr. Iyer.
So, good afternoon, everyone. Really happy to be part of this panel, and it's really nice to discuss role of professionals in corporate governance and nation building. At the Institute of Company Secretaries of India, it is my proud privilege when I'm sharing the dais with three presidents of three distinguished professions of our country, and I'm really proud that all the three presidents are members of Institute of Company Secretaries of India. So it is a proud moment for ICSI, wherein all the three presidents are member of our institute. When it comes to corporate governance, it is all about accountability, it is all about transparency, it is all about disclosure. And Institute of Company Secretaries of India is a torch bearer when it comes to corporate governance. We are the one who make professionals who are leaders in corporate governance when it comes to developing capacity building also in respect of PMQ courses like post membership courses. We are the one who have started this corporate governance diploma for our members so that they can get that capacity built and they can disseminate this information about capacity building. Since 1995, this corporate governance word actually came into picture, and since 2001, it became a mandatory requirement, and later on, with this LODR, it has not only become a mandatory requirement, but it has become a feature. So it is not the law which describes that this is a corporate governance, but it is the thought process of the corporates which actually describe the corporate governance. When we talk about governance, it is all about transparency and doing the things in a standardized manner. Your Institute of Company Secretaries of India has come out with different secretarial standards when it comes to holding of different kinds of meetings, may it be stakeholders, may it be board of directors. We were listening to the earlier session also in respect of independent directors. So in all these situations, I think corporate governance will play a very, very important role, and company secretary or the Institute of Company Secretary always plays an important role when we talk about secretarial standards. So we have devised secretarial standard that got the recognition of Companies Act 2013 also. The same were accepted by Malaysian Association of Company Secretaries, so it is a globally accepted standards, as well as we have come out with Panchayat Code. Panchayat Code is something which we have devised for the different Gram Panchayats and how they conduct their meetings. So from corporates to non-corporates, from government to non-government, from local to global, we all have considered in this secretarial standards, and we have been doing this particular development on day-to-day basis when it comes to corporate governance. Second initiative which we have already taken is in respect of corporate governance awards, which we started in 2001, and CSR awards, which we started in 2016. I think these two awards to different corporates will definitely enhance their vision towards better corporate governance and better CSR, because ESG is something which is going to come in a big way in years to come, and the companies which are having higher index on ESG will be valued more. So I think compliance is a cost, but when we talk about governance is value. So whenever we have a good governed company, they will definitely have a better value when it comes to the value proposition of these companies. The institute has also come out with different codes, which is anti-bribery code also we have devised, code of conduct for non-corporate entities we have devised, so that, see, it is not about companies only which are subject to corporate governance, but all these panchayats, gram panchayats, or for that matter municipal corporations, even government meetings, they are also subject to certain kinds of corporate governance, and our institute is helping in each of these manners. In respect of futuristic approach is concerned, we are looking at different avenues for our profession when it comes to alternate dispute resolutions, wherein arbitration and mediation, these are the core areas wherein all the three institutes will play a very, very important role. But as company secretaries, I think we have a different edge over others, because we are not basically into accounting perspective of it. We are into legal and compliance perspective of it. So arbitration and mediation, these are the two important areas which we are looking at this point of time. And also in respect of academics, your Institute of Company Secretaries of India is doing a lot of efforts to connect with different IIMs and different educational institutes so that we can impart knowledge about compliance and governance to the students. And once the students are developed, then the entire community, next generation will get developed, and these people are going to be the entrepreneurs. So once they become entrepreneurs, they know that is what is the good governance practices. Soon we will be releasing one first volume of good governance practices in next week, and that will be released to all the corporates as well as general public. So these are the things which we are doing it for corporate governance, and once we have a good governed companies, definitely their value will increase and that will add up in nation building. That is what I think. So these are my opening remarks from the IECS side. Thank you very much.
Thank you, Mr. Thank you. Now, Mr. Iyer, you please throw light on the initiatives taken by the Institute and the way forward.
Thank you.
Please.
Good afternoon to everyone, respected our chief guest and moderator, Madam Nicholas, and my co-presidents and delegates. As we know that today, very important day as far as corporate governance and other areas are concerned. And corporate governance ensures the transparency, which is leading to economic and balanced growth, which in turn protect the interests of all the stakeholders. So as a professional, it is our responsibility to ensure that the right approach is made for corporate governance, where the directors and board is able to get the required support from the professionals. And good governance can be achieved by the use of systems that ensures consistency and good practices. Most importantly, it is the system which is having the highest level for the organization. We are aware that the availability of the professionals in the country is a backbone, and where the globalization is taking place, the professionals are the backbone of the corporate, and where the corporate should be able to get the right system, right practices, so that they'll be able to progress and grow for the economy and the industry and the nation. So which the professionals should be able to provide the required support. And our institute is able to train the professionals, and wherein they are able to get the required skill and cost and management efficiency, and how the use of the resources effectively. Optimal utilization of resources is more important for the conservation of resources and economic development, which our members are able to ensure it. As a cost and management professionals, we are always helping the industry and the nations by offering our solutions for the sustainability of the business growth. And after the pandemic, we have brought two important guidance notes, and wherein the board performance and how the tools and what all the things required for the post-COVID, post-pandemic importance, which has been received well by the industry and other authorities. So which is very useful for this. And our guidance note has been used by the International Federation of Accountants, IFAC, and CAPA and SAFA, and wherein they have published same thing in their websites as a resource material. And the same thing has been published in the Institute of Directors also in their July 2020 issue. Being the largest body of the cost and management accountants, it is our responsibility to bring various technical guides and technical support. One of the areas where we are taking up as per the requirement is that where the internal audit and present system can lead to performance appraisal of the corporates. Where today environment, if you take the vouching and verification and those things are not there, and the whole accounting and auditing scenario has completely changed. So in this scenario, how the professional should be able to ensure that the auditing and accounting scenario leads to performance appraisal of the management for the sustainable growth of the industry, economy, and the nation. So those guidance note we are bringing, which will be available to public. And already we have released the exposure draft, where we require all of you to give us your opinion so that it can be a better updated and upgraded document. We, as a profession, and ensure that the independent directors are adequately getting all the information on cost management, and wherever the cost audit mechanism is applicable, our members are able to submit a report where the performance separation and whatever required by the management is able to establish, and it is very well used by the independent directors and board for enhancing their operational profitability performance. And as a professional, we are, our cost management accountants, value enabler, value creator, value reporter, so that how to add the value to corporate is being done by cost and management accountants. And to enable the youth to get trained, we are having various courses, short-term courses as well as long-term courses. We have entered into MOU with the various state governments also. Kerala, Uttar Pradesh government, last week we entered the MOU with the Uttar Pradesh government, Maharashtra and all, where the skill development is taking place for various lakhs of students who will be able to be employable and skill development. So they'll be able to have their own entrepreneurship also, so that they'll be able to contribute for the economy and the nation and the society. So these are the people where we are able to reach the unreached, and maximum support we will be providing to the various institutes of the government. Whatever the schemes of the government, whether it's Atmanirbhar Bharat, Amrit Mahotsav, Smart City, GST, whatever it is, our institute is doing with all our 114 chapters and 11 overseas centers also. We have conducted large programs with our London overseas center also, where we are able to reach the whole global community of cost and management accountants also. We have entered into MOU with various universities and educational institutions, so that we are able to reach the students at various places and various regions and various areas to develop the youth to skilled employable opportunity. And we are progressing very well, and we are able to reach the unreached with the support of various authorities and the government. And it is, as a professional, it is our responsibility for us to contribute for the economy, nation, and all that. The global progress is powered by nations. National progress is powered by economy. Economy is powered by competition. Competition is powered by resource investment and innovation. Innovation and creativity is powered by management stewardship. Employee productivity. Employee productivity, quality of the product and quality of the services. Quality of the product and quality of the service is powered by employee productivity. Employee productivity is powered by employee motivation. Employee motivation is powered by quality management stewardship. Management stewardship is powered by quality leaders. Quality leaders are powered by we, the professionals, and you, and who will contribute for the economy and the nation. Thank you very much for the opportunity. We'll go ahead. Thank you. Wish you well.
The President of the Institute of Cost Accountants of India, CMA Iyer, the President of the Institute of Company Secretaries, Mr. C.S. Deshpande, Mr. Dhariwal, Madam Mithilesh, and to all of you, a very good afternoon. I start speaking with a smiling face and feeling very relaxed because the lady who is sitting next to me, Madam Mithilesh, happens to be a chartered accountant. You see, it's such a great pleasure sitting next to a chartered accountant and speaking. Today, when the Honorable Finance Minister visited our stall in the morning, I told her that, Madam, I'm not going to speak very much about accounting standards, auditing standards, about which we have been known since 1949, since the Institute have been set up. I told her we take great pride in being the second largest accounting body in the world, but I said that let me tell you something which you do for the nation. We do a financial and tax literacy drive across the country. 166 branches, 5 regional councils, they go spread all over the country, teaching people, housewives, elderly, about the rudiments of finance, rudiments of taxation. And we take great pride in doing that. You see, so that is how, we are trying to see that how much we contribute to the nation building.
But as an institute, we also take great pride in being innovative, being forward-looking, and being modern. I have in front of me the Vice President of the Institute, Aniket Talati, who is in his 30s, one of the younger members in the council. And he always tells me that technology is the future. Technology is changing. He says, let us take technology as an enabler and not a disruptor. And every time he says that, and the whole council says that, I agree. But at the institute, what we have is, we have a 91-year-old past president of the institute, A.C. Chakravarti from Calcutta, who says that the future of the profession is technology, technology, and only technology. A 91-year-old chartered accountant says that. And at the institute, what we are doing is, we know artificial intelligence is going to hit us in a very big manner. We are looking at what to do, how to develop artificial intelligence. Blockchain is another area in which the institute is working very, very hard. Cyber security was talked about, data analytics, we are doing a lot of work on that because we are trying to see that there is going to be huge change from the view of digitization, and the institute must be ready for it. So we are doing everything possible. Now, we have a lot of practitioners who are small and medium. Now, how to reach out to them and give them the best of technology? What we are developing is audit tools. And we are proposing to give them free of cost and provide training to them so that they are, aware of the latest that is happening vis-a-vis the technology, the latest that is happening in the audit. We are, and I was telling madam, the FM madam, with great pride that we are the proud host of the World Congress of Accountants. Now, the World Congress of Accountants is called the Olympics of Accountants, held once in 4 years. It's being held since 1904, and India is hosting it for the first time in Mumbai from November 18 to 21st. But, when we were developing the theme of that Congress, and we were brainstorming, 2 words came up. And it was a unanimous view of the whole organizing committee that these 2 words must find a place in the theme of the Congress. 2 words, building trust, and trust was one of the words. Enabling sustainability. Sustainability was the second word. The feeling across is, what is a profession without trust of the stakeholders? What is a profession without the trust of the nation? So this is what we thought, and to us in the institute, the trust of the nation, trust of the stakeholders is so very important. The second aspect is sustainability. We know what is coming is non-financial reporting. We will have to report or provide assurance on the non-financial side. And we are getting ready for this. We have developed and enjoying the trust of the nation. Thank you very much.
Though we have questions and speakers have energy and capacity to speak, but considering the time overruns in past sessions, we are sacrificing. So we conclude the session here with thanks to 3 eminent presidents. It's really a privilege. I probably think we are never will be sitting again in the similar situation where 3 presidents are around me. I'm truly fortunate. And I'm also thankful to all of you to giving a number of claps in between. Definitely those were for the presidents, but yes, still I take my share. Thanks.
Thank you, and may I request Mr. Dhariwal to kindly present the mementos, our expression of thanks and gratitude to our speakers, thanking C.S. Devendra V. Deshpande ji.
thanking CA Dr. Devashish Mitra, and thanking CMAP Raju Iyer. May I request all of you to please step forward for a group photograph. आगे से ले लेते हैं सर, आगे से, हाँ जी. Thank you, and we'll just take a minute to set the stage for the next session. That's the last technical session, and then we have an important plenary session posted. This is the topic, merger control regime in India. As we know that the Indian merger control regime came into effect on the 1st of June 2011, and towards that CCI has played a very important role, a role of a facilitator of the India's merger and acquisition activities. So the session chair is the chairperson CCI, Shri Ashok Kumar Gupta ji, and then we have our esteemed panelists as we take our discussions in this session. Just allow us a few minutes to set the stage, and then I request our speakers to take center stage.
हाँ सब हो गया, बस इनको ही सही रख, सीधा सीधा रख दो बस, नहीं ये फोल्डर खोल.
Ladies and gentlemen, may we request you to kindly take your seats. As I said that after this session, we have an important session, the plenary session. And we are going to be concluding for the day at 5:15 because there's an important meeting of most of our dignitaries and officials in the ministry. So 5:15 we are going to be closing. This session we intend to finish by 4:35. So just a request to the session chair and the moderator, 4:35 as we can close the session. Our session chair joining us, Shri Ashok Kumar Gupta, chairperson CCI. The moderator of the session, Ms. Jyoti Jinkar Bhannot, respected Secretary CCI, Shri Manish Mohan Govil, Advisor CCI, Shri Shardul Shroff, the Executive Chairman of Shardul Amarchand Mangaldas and Company, Shri Pavan Kumar Vijay, Founder Corporate Professionals, Shri Vijay Shekhar Sharma, the Industry Representative joining us. If I can just request people who are in front of the stage. So may I just request, a very humble request, we have our dignitaries here, we are ready to start with the session. If we can request you to kindly move into the pre-function area for any networking and further interaction, please. And just once again request, this also comes from our Joint Secretary. 4:35 we close the session before we have the next important plenary session at the end. With that, I hand over to our Chair, Shri Ashok Kumar Gupta ji, for his opening remarks. Or we can straight away move into the panel discussion. I think that will be... Yeah, we can have the concluding remarks by the...
Yeah, with your permission,
can I just...
Honorable Session Chair, eminent panelists, and distinguished audience.
Welcome to this session on competition law, merger control regime in India, a framework which has been in place now over a decade. Any efficient regulatory framework must meet the expectations of stakeholders and should dynamically respond to the evolving underlying environment. The merger control regime is mandated to facilitate inorganic growth opportunities even while protecting competitive market structures. In this session, we shall discuss and deliberate on the evolving role of CCI in mergers and acquisitions. We are privileged to have as the session chair, Shri Ashok Kumar Gupta, Chairperson CCI, under whose leadership several key initiatives have been undertaken by CCI. We also have distinguished panelists, Mr. Shardul Shroff, Executive Chairman Shardul Amarchand Mangaldas, Mr. Vijay Shekhar Sharma, Founder Paytm, Mr. Pawan Kumar Vijay, Founder Corporate Professionals Group, and Mr. Manish Mohan Govil, Advisor Combination Division. Before moving on to the panelists, may I now request Session Chair Shri Ashok Kumar Gupta for his keynote address and opening remarks.
Eminent panelists, distinguished participants, friends from media, ladies and gentlemen, a very good afternoon to all of you. It gives me immense pleasure to be a part of this event being organized by MCA under Azadi Ka Amrit Mahotsav, an initiative of Government of India to celebrate and commemorate 75 years of progressive India and the glorious history of its people, culture and achievements. I welcome you all to the panel discussion on merger control regime in India, promoting competitive structures in markets. Many in the audience may know the history of the new competition law. In October 1999, the Government of India instituted a high-level committee under the chairmanship of Mr. S.V.S. Raghavan to advise a modern competition law for the country in line with international developments and to suggest a legislative framework for enacting a new law or suitable amendments to the MRTP Act 1969. With the changing and evolving nature of business, markets and economy, there was a necessity to replace the erstwhile law with a new competition law. One of the important objectives of the new competition law was to establish an effective and efficient merger review framework for ex-ante review of combinations in order to prevent harm to the consumers from anti-competitive transactions. The Competition Act introduced merger control regime which came into effect from 2011. In a short span of over a decade, CCI has evolved itself as a robust market regulator through its constant endeavors in engaging with various stakeholders and the international antitrust community to develop a robust merger assessment framework. As per the scheme of regulation of combinations contained in the Competition Act 2002, India has a mandatory merger notification regime and the parties cannot consummate any part of any notifiable acquisition, merger or amalgamation until approval is received from the Commission. It is also our constant endeavor to provide certainty, reduce compliance requirements, make filings simpler, aligning and pioneering international best practices. On merger control, we are mindful that mergers and acquisitions are crucial instruments for investment flows, creating economic synergies and helping create scale economies for firms crucial for competing in today's globalized economic order. Therefore, it is the endeavor of the Commission to clear such cases in a time-bound manner, and the Commission has been taking steps to ensure timely approval. The average time for approval of combination cases has come down to 17 working days. In over 900 combinations reviewed so far, remedies were ordered only in 22 cases. These were in cases where the inquiry demonstrated harm to competition based on cogent material. Our trust-based green channel system, the first of its kind in the world, came into effect in August 2019 and has been widely accepted and appreciated by the stakeholders. Till now, more than 55 notices have been filed under Green Channel route that now account for over 25% of filings. Friends, businesses grow inorganically, that is by acquiring businesses. When large businesses merge or acquire, they may create disruptions in the market. No doubt, such transactions may benefit from economies of scale and may lead to efficiencies in delivery of outputs. However, some mergers may result in anti-competitive harm to consumers, reduce and foreclose competition. Merger review of such combinations ensures that such likely adverse effect on competition is timely remedied and that the markets remain competitive. Absence of such review may lead to concentrations in the market and may entail huge cost in unscrambling the egg. Post-COVID, we are also witnessing increasing digital transformation in the country. The digital sector has revolutionized the way goods and services will be delivered in future, even post-COVID. However, the digital sector brings with it new disputes and risks which traditional theories of harm may not be able to recognize and encapsulate. The presence of network effects, high levels of concentration, artificial intelligence and data-induced challenges that give digital gatekeepers the ability to control and influence digital markets and allied fields have thrown up new challenges for the antitrust authorities. Undeniably, a balanced approach to merger control in the digital sector is crucial, keeping in mind the efficiencies that they bring in the market. Thus, assessment of combinations necessitates revisiting and recalibrating the approaches, including developing new theories of harm which are able to capture the exact competition concerns in order to make appropriate and targeted remedial measures. As India looks to the future with an ambitious goal of a 5 trillion economy, we will have to meet the demands of business and industry. CCI will have to bear in mind the requirements of a diverse economy such as ours and strive to strike a balance between enforcement and advocacy, dovetailing the two functions. We firmly believe that our constant engagement with stakeholders and our balanced approach to regulation will result in a pro-market regulatory system that expeditiously facilitates synergetic transactions, and combinations that have anti-competitive potential alone are subject to detailed review. The stakeholders also need to be fully aware of the regulatory framework and their responsibilities and obligations as contained in the Act and regulations. This is critical to ensure a culture of compliance. Our constant engagement with stakeholders also helps us to understand the market realities and challenges in the Indian context, and their feedback helps us in improving our practices and processes. Friends, merger review is a niche area, a highly specialized field of business, economics and law. Mergers and acquisitions are negotiated by the businesses and corporates. The economists predict the outcome of such transactions, and the legal and financial professionals are involved in preparing transaction documents, carry out due diligence, and take regulatory approvals. We are extremely happy to have with us eminent speakers for today's panel discussion from fields of business, economics, finance, and law, having varied experience. I am sure the diverse experiences of the panelists will provide a 360-degree view of the regulatory framework, both in form and in substance. With this, let me once again welcome and thank all the panelists and participants. Looking forward to a productive session full of useful insights for all stakeholders. Thank you very much.
Thank you, sir, for setting the tone for the session. So let me now begin with Mr. Shardul Shroff, who has a vast experience in the arena of mergers and acquisitions, to shed some light on how the merger and acquisition landscape has evolved over the years in India, what are the recent merger and amalgamation trends. Specifically, given your involvement and association with CCI over the years, we would like to hear from you whether introduction of merger regime in India has been able to achieve the avowed goals.
Respected Mr. Gupta, Ms. Jyoti Bhanot, and my panel colleagues. The question posed by Madam Jyoti is to be divided into three parts. How has M&A changed over the years? How have you seen CCI evolve? And has it achieved its avowed goals? So I have to respond to all these three aspects and give a cogent response. Let me first deal with the trends in M&A. The whole concept of M&A and the tax neutrality under the Income Tax Act for amalgamations or demergers are based on technical requirements of the Income Tax Act, and they drive the whole process, especially that of mergers and amalgamations or reconstruction. The logical driver of mergers and acquisitions is the need to grow in capacity and to strengthen the company in its position as a competitor. So this is about transformation and growth, and at times to move out of the core business of an enterprise. You have, for example, just seen how Adani has moved into cement. That is an example how a core business of ports and airports has seen the movement into cement. Current trends clearly show that private equity and venture capital deals are on a surge. This is a major shift in India, and M&A activity, which is needing external capital, have really opened the floodgates, as it were, of private equity and venture capital deals. And the volume that we witness is essentially in this space and in the space of e-commerce and in the space of startups. The issue that also drives M&A are the threefold needs of the nation: renewable energy, the agenda for electric vehicles so as to reduce pollution, and simultaneously the introduction of a zero-emission norm so that we comply with the environmental promises that the nation has made. So the framework effectively is set by these principles, and then how do you see it on the ground pushing action? There is an enormous momentum in deal making, and despite COVID, there has been a resilience in the market and in the people's confidence of making investment. The year ended 2021 saw the conclusion of 806 deals aggregating to US dollars 48.9 billion. Deal making experienced a whopping increase of 143% in terms of deal volume and an increase of 28% in terms of value in comparison to 2020, so in just 1 year. This momentum in deal making has continued in the first quarter of 2022. In the period January to March 2022, India has already clocked 608 deals valued at US dollars 13.3 billion, and this is a significant 49% increase in terms of volume and 9% increase in terms of value as against the M&A activity in the same period in the previous year. Where are the trends, or what are we really seeing? I think the push continues to be IT and IT-enabled services, telecom and digital commerce, including e-commerce, and startups. These are clearly the flavor of the nation and the flavor of the world, as it were, into making investments into India. Private equity deals are stealing the show, and there is an enormous growth in the investments that have happened. It is growing at a compounded annual growth rate of 19% from a base of US dollars 8.4 billion in 2010 to US dollars 47.6 billion in 2020. The cumulative value of PE and venture capital investments between 2011 and 2020 totaled US dollars 232.4 billion, which is more than twice the value recorded in the previous deals. The breakup which we see in the deals is essentially between startups and e-commerce. The ratio is almost 31% for startups and 34% for e-commerce. We have seen in this year Google making an investment of about US dollars 700 million in Bharti Airtel, and therefore the evidence on the ground suggests that the data revolution and the communication revolution are working side by side, and there is heightened M&A activity so as to cause the delivery of data across territories, whether in India or outside India. Let me now turn to the second question that was asked. How have you seen CCI evolve? I think when one looks at the regime of 1969, way back when section 20 to 26 were part of that law, the threshold of looking into the regulatory space was a very low figure of 100 crores. And a dominant undertaking essentially was 25% threshold of the market. The focus in that law, as far as monopolies was concerned, because the law clearly was Monopolies and Restrictive Trade Practices Act, it was not so much about competition, was how do you really augment capital and capital equipment, because that was the explanation of substantial expansion. The government in this particular case had kept itself the right to examine whether a merger or acquisition was likely to lead to the concentration of economic power to the common detriment or likely to be prejudicial to public interest in any manner. The MRTP Commission, operating under the MRTP Act, had a mere advisory role and could only provide inputs to the central government that the central government, if it deemed necessary, would refer any merger or acquisition to MRTP for further investigations. But an order of divestment or a remedy, as we know under the Competition Act, could only be done by the MRTP Commission. Then you have the waterfall event of the change and the deletion of the sections concerning the filings and the regulatory space over mergers and combinations and acquisitions. As was mentioned by the learned chairman, the year 1999 saw the establishment or the setting up of the Raghavan Committee as a precursor to develop what should be the raison d'etre of the new Competition Act after the MRTP Act had effectively failed, because it was not really regulating and there was an absence of law. The 2000 committee report resulted in the making of the Competition Act of 2002. I'll just hurry up, don't worry. Originally, it was voluntary filings, then it shifted to mandatory filings. The way the CCI has enhanced its position from 2011 to 2022 has been remarkable, and it has really functioned both as a regulator and supporting the ease of doing business. It has even facilitated the takeover of stressed assets, as we saw in the case of Air India. It has adopted the best practices of other regulations, and the institution of pre-filing consultations is also something which is extremely welcome. And lastly, if I may say, the most important change which has been made in the last 5 years is essentially the green channel route, with the learned chairman has mentioned, it has facilitated fast-track movement of applications, and I think the industry has a lot to thank the CCI in this case. Thank you so much.
Thank you, sir. So taking a cue from what you mentioned about the flavor of the times, the startups, let me now turn to Mr. Vijay for his, Mr. Shekhar for his perspective of startups and interface with competition law.
Thank you, ma'am, and thank you, sir. Thank you for having me here in this esteemed panel and in this gathering. As an industry, as a startup, as a technology entrepreneur, for me, we as India's technology entrepreneurs face unseen competition, if you will, who is coming from more or less foreign countries, because those countries have built the technologies much before we are even attempting to build the technology. Open market, access to market. Our country's open market policy, access to market, is publicly available to everyone under different kind of investment percentages, making it one of the most vibrant market, nowhere seen for the size and opportunity available to every country's companies. If you notice, India is the only country of the size of economy where you can have companies from West, companies from East, and companies from India fight together for a customer. So this is incidentally one of the, I would say, the winner takes like a editor choice award of that customers like and the business was good. A long moment for me. Now, Competition Commission not only has a role in ex-ante merger and acquisitions, but also in approving different investments, because these investments come from conglomerate or investors who have diverse interests or multiple investments already in the country. One of the continued challenge for us entrepreneurs have been to raise capital in highly competitive market. And maybe you've seen it that even though initial public offerings, public listing has been a flavor in last 6-9 months, but before that India had more or less no access to capital for young entrepreneurs in India from Indian investors, if you will, especially because we are risk-averse country, especially on investments and young startups and risky businesses. These are risky businesses for investment, so there was expected less capital available domestically, and we all had to go internationally. So you talking about not only a challenge ex-ante merger, you also are talking about challenges ex-ante investments, if you will. More or less, huge capital in a single sector can block many other new startups to even get access to the capital. When you go internationally, when you are flying to Tokyo to see an investor, or when you're flying San Francisco or New York or London to meet an investor, you are asked about these questions. Who else is funded how much, and how will you look after yourself? And that becomes one of the decision-making point instead of a good service that you are offering or a business plan that you may have in your hand. It is, in fact, one of the known open secret in the industry that a huge capital round from a big investor is a ticket to survival and challenge to the peers in the industry. Talk about mergers and acquisitions, and interestingly, like Gupta sir talked about it, Chairman sir talked about it, that now customers are inevitably on computing devices, mobile phones. The access to the law and order of this country not only belongs to the physical law and order, it is also something in the cyber world. And in the cyber world, there is no way to control large conglomerates, large big tech, which are global menace, if you will. And they inevitably, their behavior comes to more or less blocking access to the customer's choice whenever you've seen a dispute coming in a public eye. Because one or other way, they are able to create a significant customer-loved monopoly. I'm going to use the word customer-loved because customers actually love their platforms and systems, and there is nearly no other platform that could ever come because of the network effect that it has created. So in these scenarios, it is even more challenging for CCI to able to decide and discover what could be the market impact of this M&A request that is there. I must admire CCI's attempt of green channel like we discussed and voluntary disclosures that CCI expects. But I personally believe that companies which are filing for CCI approvals should probably be far more transparent, should probably be far more forthcoming in the motivations of this M&A, in the reasons of this M&A, because sometimes these M&As are done to even close that line item of business. That, okay, no more competition, less competition, more cartelization, or more, let's say, margin or profit or sustenance of the market.
So, Mr. Vijay, because of paucity of time, sorry, I'll have to interrupt, but taking another from what you said, on the issue of transparency, I think it is very well relatable to the issue of corporate governance. And we have Mr. Pavan Vijay, who has been very closely associated with corporate governance. So, Mr. Vijay, do you think now, in today's milieu, the board of directors are sensitive to the issue of competition compliance in their decision making?
My answer is no. And before giving this, we have to understand what is corporate governance and competition. You know, the Satyam Vad Dharmam Char is the basic concept of corporate governance. So you have to speak truth and abide by the law. You should have a transparency, disclosure, accountability and integrity. That is a basic part. And corporate governance is not only for the shareholder. Corporate governance is for the all stakeholders. That include minority shareholder, that include supplier of goods, supplier of money, that's a vendor, creditor, employee, public, and the consumer. And the competition law comes when the consumer is there. So we have to just understand that all these people are the stakeholders. And when we talk about the corporate governance, then applicable of all laws is also very important. That includes competition law. Present position is that board is not aware. The big companies are aware, but not the all companies. As a professional, I am telling you, we are doing due diligence. Recently, we have started seeing the due diligence from the competition angle. Otherwise, neither board is aware, nor the independent directors are aware. And the reason is, I have some solution. One is that independent directors course should contain, because we have a classes, we have a compulsory exam, that particular thing, and we should promote corporate governance. And then the directors, this corporate governance appreciation certification course is also there where we can add. Professionals are also not doing so. Through the 3 institutions, you must promote that they should include in the due diligence process the governance and this competition law part, that what is the impact and whether there's a adverse impact on the governance, and there should be format which you can provide. These are the following things which you can do.
Thank you for very useful feedback, and I'm sure we would certainly incorporate that in our advocacy initiatives. So having heard the corporate, the lawyers, and the professional, may I now turn to Mr. Manish Govil, who is advisor combination for the perspective of the regulator on what is being discussed.
Yeah, thank you so much. A lot has been covered in the chairman's opening remark, and he has very beautifully brought about how we have balanced our twin objectives of facilitation and enforcement in the realm of a merger review regime which we have established. So at the outset, I say that this balance between enforcement and facilitation is inbuilt in our Competition Act itself. Our thresholds are pretty high as compared to the other parts, international parts also. And the ministry has given a de minimis exemption so that we do not over-regulate transactions which are not supposed to be over-regulated. The Commission has also come out with the Schedule 1, which exempts transactions which are not likely to cause appreciable adverse effect on competition. These are generally which are investment solely for investment, or which are in ordinary course of business. So we have that architecture. But coming to the practice, also we follow a very, very balanced approach when we do our assessment for merger analysis in the Commission. So as you see, most of the combinations or most of the transactions which are filed with the Commission are cleared very quickly. We have not given, as Chairperson has said, we have not given remedies in many of the cases. Only 22 cases we have given remedies. and they have been cleared expeditiously. Where there are concerns, we do a very robust economic analysis of the merger, and then we come out with remedies. Recently, we have changed our regulations also. We have allowed parties to offer the remedies upfront. This has led to expeditious implementation of remedies which are proportionate and which are targeted remedies. We have not as yet blocked any case, so it's a win-win situation for both the industry as well as for the commission, as well as for the markets, because the industry is able to consummate its transaction, and on the other hand, the markets remain competitive. It has also facilitated entry of new players in the market, especially in sectors such as cement and also industrial gases, and also in the digital sector, digital field. We are going ahead. We are talking to the stakeholders. We are trying to build in new remedies. We are even experimenting with behavioral remedies, and some of these are a very, very forward-looking initiatives which we are taking in our assessment realm. So that's all I would like to say.
Thank you, Manish. So again, due to paucity of time, as we are entering Amrit Kal, maybe I'll request Mr. Shroff to lay the roadmap that what, according to you, should be the reforms that CCI should focus on. Very quickly, sir, in 2 minutes.
I think Mr. Govil has correctly addressed that the situation on the ground is such that the CCI is really playing a role in the ease of doing business. It's not just about regulation, but some aspects like, for example, issues in terms of the other remedies which Mr. Govil has mentioned, whether they are behavioral or structural remedies. When you see from the beginning, it was all about divestment, but the whole process has changed. And in the case of Metso, as I'm told, there was a unique remedy of creating an irrevocable license which really divested the problem. They have a very strong regime on gun jumping, and it's a zero-strike policy. So there is no question of giving a leniency in the case of gun jumping, and I think that is one of the most valuable pieces of the part of the practice which has been created by the CCI. There is, however, some analysis which is needed in the private equity deals, especially in the context of the question of control and the ability to direct. I think I need to mention two things, that there was a prior SEBI case in Subcom which got resolved at the level of the Supreme Court without a final order. But what has happened is, in the latest case of SR Steel Limited versus ArcelorMittal, the Supreme Court has embedded the decision of Subcom as part of the law. Therefore, the question of control is effectively a matter which is res judicata, which is res integra, where the courts have actually now debated and or deliberated and put down the contours of control in the context of Indian law. It's not only with reference to the Competition Act or with reference to the SEBI Act. It's a broad definition which I feel should be looked at by the CCI, because I think it's an important decision, and to go against that decision, to try and differentiate that decision, will itself be a significant problem. I think the approach of CCI has been excellent in the sense it has been collaborative, it has developed as a mature regulator. The other aspect which I would suggest is that frequently asked questions, guidances, guidelines, which are part of the mature jurisdictions of the world, are something which should be resorted to, because it will give consistency of interpretation and reliance on past precedent. This is something which is critical, because the industry should not have a feeling that there's a variation which has happened which we don't know why it has happened. So this is one area where I would suggest some kind of action. And lastly, sir, the issue in terms of pre-filing consultations. This also should be part of a regulated regime. It should either be a regulation or a guideline procedure, because a lot depends on, the planning depends on a lot of the pre-filing consultation. initially it was only related to whether or not to file, but now more substantive issues are coming in the space of pre-filing consultation. But the complex transactions which are there, when you look at the right to give up the negotiation at a later date, these are matters which require careful handling, and I would strongly suggest, sir, that if this can be made a part of regulation or a guideline, that will go a long way. Thank you so much, sir.
Thank you so much for your valuable suggestions. So, may I request Chairperson to conclude?
I thank panelists for giving their insights on the journey of CCI regarding merger control regime in India, and for providing useful suggestions to make it more robust. And one of the suggestions which has come forward is about FAQs and guidelines. I think this is going to be our focus area, and we are working on it to provide certainty. And as and when we pass any order, I think every order basically comes out with some sort of jurisprudence, and that will be converted to the FAQ for future guidance. There seems to be a consensus that ex-ante regulations of combinations have been an important regulatory development in the last 10 years in ensuring that the market structure remain competitive. With the fast pace, growth and increasing digitization of the economy, the relevance of a dynamic merger control regime is likely to become more pronounced. At CCI, we are committed to constantly refine our processes and approach in sync with the demands of the changing economic landscape. It should be our collective endeavor to build a trust-based regulatory ecosystem. In fact, we are going to reduce further compliance burden on the industry. We will come out with more reforms, but that all depends on the trust and the transparency which industry reposes on the CCI. In fact, we would like to be guided by the industry totally. Whatever you fill in the form, please fill it with full honesty, with full sincerity, so that we can take it on face value as such and go ahead, because we know that mergers and acquisitions are very important. We stand in a way in between acquirer and the target. We would like to give approval at the earliest so that you can consummate and move forward. So it becomes extremely important that you come for the pre-filing consultation. We can point out the deficiencies. You can fill up those deficiencies in those forms and submit the form in complete shape. I think still I am finding that some people hesitate in coming from the PFC. They try to hide the information. I think that does not augur well for a trust-based system. Green Channel we have brought precisely for the reason 25% of the filings are being cleared under this Green Channel. And I believe that most of the industry people, they want that merger and acquisition should be cleared at the earliest. So PFC is one step in that direction, and true and full disclosure in the form is another requirement. So, I mean, in this pursuit, I see an increasing responsibility reposed on the board also, because it's a part of the good governance. If you do due diligence as per the Form 1, Form 2, and see that everything is in compliance with the competition law, then I think there should not be any difficulty in giving approval for the merger and acquisition. So it should become a part of the good governance norms, doing due diligence at your level before filing. That's all. Thank you very much.
Thank you, sir. And it was indeed a privilege to be part of this panel and today's program. Thank you.
Yeah, thank you.
Thank you.
In the interest of time, we will not be able to take the question. If we can take it off stage. Thank you. May I request Ms. Bhawan to kindly present the memento. Thanking all our panelists, Shri Manish Mohan Govil ji. Our expression of thanks to Shri Shardul Shroff. Thanking Shri Pavan Kumar Vijay. And thanking the founder of 197 and Paytm, Shri Vijay Shekhar Sharma ji. And may I request Shri Manoj Pandey ji, I think he's... May I request Shri Manoj Pandey ji, Joint Secretary, to kindly present the mementos to our chair and moderator. Thanking first Shri Ashok Kumar Gupta ji. And thanking Ms. Jyoti Jindgar Bhanot. आगे आके सर हाँ जी वेलकम So, ladies and gentlemen, this is the last session and the plenary session, and in the very spirit of continuously reforming and transforming to perform better, the topic which we have for this last session is reform measures in corporate governance so far and the way forward. Joining us, the Honorable Chair of the session, Shri Rajesh Verma ji, respected Secretary, Ministry of Corporate Affairs. Our panelist for the session, Shri Ashok Kumar Gupta, Chairman CCI, Dr. Ajay Bhushan Prasad Pandey, Chairman NFRA, Shri Ravi Mittal, Chairman IBBI, and Shri Praveen Kumar, Director General and CEO IICA. So, ladies and gentlemen, this session stands extremely important for we now, after all the discussions which we've had the entire day, as we look into the reform measures in corporate governance till now, and then looking into the future course of actions to be taken for more refined and more reformed measures in corporate governance. We have our eminent speakers who are going to be presenting their views. May I first request Shri Praveen Kumar, Director General and CEO of IICA, for his views and perspective.
Respected Chairman, fellow panelists, and distinguished guests here. I don't want, since the time is short, I don't want to dwell on what reforms have occurred on corporate governance so far. And I would like to focus on what I envisage as what the future of corporate governance reforms will be. I'll place this in three buckets. The reforms will be in three buckets. The one bucket will be evolution of Indian specific corporate governance. Second will be corporate governance oriented towards the society and the nation as such, instead of limited to the firms and its shareholders. And third will be more self-regulated corporate governance coupled with greater advocacy. I mean, these are three buckets. If I take it one by one, the first will be, see, our corporate governance has evolved based on the Anglo-Saxon model of governance. Perhaps problems are occurring because our Indian culture systems are not suited to that Anglo-Saxon model, and so we'll need to evolve a governance model which is more suitable to the Indian social values, norms, culture, structures. For example, normally if you see any board meeting or any shareholder meeting, is the dominant shareholder, the promoter, whose will prevails. Normally it's the minority shareholder is on most occasions, especially in a promoter-led company, is steamrolled. So what happens that, for example, this question of independent directors, even independent directors become nominees of the promoter shareholder, I mean, who are aligned to it, or at least loyal to it, or beholden to it, to the promoter shareholder. Perhaps a system may come where the independent directors may be appointed by independent regulator. I mean, the way it is going, it may happen in future. The way, and same thing may happen with the statutory auditors. Seeing so many scams have been now occurred where auditors have not been able to play the role which they are supposed to play. So these two things may come in future over time if the self-regulation part doesn't work. And seeing that most of our businesses many businesses are family businesses, so some evolution needs to occur to how to regulate the transition of family businesses into a professional one. Some people have done it on their own, but generally family businesses keep on running as family businesses without transforming into professional businesses. That may be the other part of the changes which may occur. Third major problem is that we have a very weak enforcement of corporate enforcement regulations. While the laws are there, enforcement is relatively poor. Corporate governance should be light touch, but firm. I mean, it should be like a iron hand in velvet glove, so that we don't want to interfere, but whatever we have prescribed, as the Honorable Minister was also speaking in the morning, that should be implemented strictly. So enforcement will become a stronger perhaps. One area perhaps we'll be needing is more on the, as I said, startups are coming up. Startups may be requiring a different orientation, nuance in corporate governance, especially with the founders. We have already seen some incidents of founders being chucked out later by recently BharatPay occurred, earlier Housing.com occurred. So something may come in where founders control and succession planning may become one of the dimensions in the corporate governance. And seventh change which will occur in this bucket, which is that role of the technology. Rapid technology change has both the opportunity and risks, because we can use AI and blockchain tools for better data analytics, forecasting, transparency. In the previous session, someone mentioned about asymmetry between the independent directors and the board members. Technology may reduce this asymmetry with all information being made available to the independent directors also. But the risk is technological ignorance by the board may prevent them, the independent directors, to have a more inability to direct and oversees the management. And the various IT risks will be there, like privacy breaches, leading to significant investor loss. These things may happen. Now coming to the second bucket, which I said, where we will go beyond the company and look more at the society and the nation. And profit and bottom line won't become the last word in the corporate governance. Already ESG and business and human rights have become common in the world, but still there's a little precedence in India. This will come here. The business responsibility and sustainability reporting design is an attempt towards that, but is still to be adopted in letter and spirit both, and more is a tick marking kind of thing that is being done. And especially when people come to know that international fund flow, major investments will be directed by the extent of ESG occurring in any company, board may soon realize that these are very important, more important perhaps than the bottom line. The third bucket, which I like to say, will move from the rules-based approach to principles-based approach. So the principles of corporate governance will be internalized by the companies over time, and they should not indulge in a checkbox that whether this is legal or not. They should rather say that whether this is the right thing to do or not. It should come from inside. That spirit may come in over time, and while the law will be there on corporate governance, the regulators will try to control everything, but moral commitment to good corporate governance will need to be brought in, and here the role of advocacy will come in, so that we need to have a good advocacy with the advantage of corporate governance, that in the long run it is advantageous to both. The studies are there which shows that good corporate governance leads to a better bottom line over long time. Short term you may try to have a sharp practices and make a profit 1 year, 2 years, but in the long run is the better corporate governance leads to better financial variables like ROC, better risk return trade-off, higher valuation of shares. All these things are reflected there. And now coming to the pitch, ISCA can play a role in the advocacy part very strongly. We have developed a strong competency in all areas of corporate governance, into independent direction, market regulation, ESG, CSR. We are even launching an ESR course of 9 months for the corporates. So this resource can be fruitfully employed over the period, the Amrit Kal period. Rather, for this AKAM, we had organized a nationwide essay competition among the youth, that what future of corporate governance will see in 2047. So the results will be declaring on 12th, which is the iconic day for ISCA, and the 3 winners will be coming and speaking on the same topic. I hope that will be and the secretary will be there in that meeting where they will speak. I hope that will act as an input for your future plans and corporate governance. Thank you.
For your insightful views, and we now request Shri Ravi Mittal, the chairman of IBBI.
Good afternoon, thank you. I know time is short, and so I'll just speak 3 small points. Since I am working in IBBI, I'll talk about distressed assets. In India, we are a developing economy, and we every time hear politicians, bureaucrats saying that private sector should come forward and make investments. And it is only when private sector comes forward that we will achieve the growth rate that we want to achieve. But you know, if private sector has to make investments, they have to take risk. And if they have to take risk, there will be failures. If they don't take risk, or if there are no failures, then there will be no growth. So the first point that I want to make is that we have to start accepting risk, accepting failures, and in fact start celebrating failures. We have to start recognizing that people will make mistakes, and they need to be permitted to start afresh. So this should be part of our ethos. I don't know whether this can be part of the law, but this definitely should be part of our ethos. If you look at Western countries, when people feel that they have become insolvent or they are becoming insolvent, they go to the court, declare themselves as insolvent, and then start afresh. In India also, we want to do this, but we have not been able to do this. So I think the first point that I want to make is that we should permit people to fail, celebrate their failures, and let them start afresh. There should be no stigma attached to failures. That is the first point I want to make. The second point I want to make is about the twilight zone. You know, companies run efficiently, and there is a period when the company's management comes to know that something is going wrong. This something going wrong could be because of the management failure, could be because of internal reasons, or could also be because of external reasons. We have a very efficient judiciary, and we have heard that in states mining has been stopped. Due to environmental reasons, projects have been stopped. So you know, these are reasons for which the company, the management may not be really responsible. But what I want to say is that the management realizes at a point that something is wrong and they need to make amends. Now, if you look at banks, Reserve Bank has made guidelines as to what should happen when the bank should approach the NCLT under the IBC process. There is a strict timelines. Banks do not always adhere to those timelines, but there is a guidelines. But for the companies, there is no guideline. So what happens is that the companies try to protect themselves or hide their failures as much as is possible. If you talk to independent directors, even they don't come to know that something is wrong in the company. So this twilight zone, I think we need to look at these twilight zones, make some rules, make some guidelines as to what a company should do if it comes into the twilight zone, when the company should approach for resolution, for amalgamation, for whatever, so that the resolution is not delayed. The third point that I want to make is that we need to differentiate between the company and the management. Normally, it is very difficult to distinguish between the company and the management, and because of this reason, the management tries to delay processes as much as is possible. Now, one thing about the IBC is that whenever a company comes into IBC or comes to NCLT, the previous management is changed and the company goes into the hands of a resolution professional. That is, we differentiate between the management and the company. Now, we should inculcate this in the company law. We need to inculcate this in our ethos so that whenever the management realizes that something is going wrong and that it will not be possible for them to manage the company in an efficient manner, they should immediately withdraw themselves and go for resolution. I am not saying go to the IBC process, that is also one of the methods, but they should immediately try to resolve the issue so that the company survives. It is very important for the company to survive, because the company survives, it continues to add to our GDP, it continues to provide employment to the labor, it continues to give taxes, and so on and so forth. Therefore, we need to develop an ethos, a system, maybe through laws, to ensure that the company survives. Survival of the company is more important than the survival of the management. This we need to ensure through our management things. The last point that I want to make is what Praveenji just said, that independent directors are generally seen in companies as close to the management or close to the owners. Now, if we want corporate governance in the true sense, we need to have real independent directors. So we need to somehow specify that independent directors will need to be independent. One way could be that independent directors could be appointed not by the company, not by the shareholders, not by the board, but by someone else, a regulator, not by the government also, could be appointed by someone else. or some guidelines could be prescribed to ensure that friends, relatives, or people who have retired from that company do not become independent directors. You know, when I was telling this to someone, they said that even in government, all of you retired government officers become regulators. I mean, that should also not be allowed. So I agree. Perhaps we should do it here also. And but you know, companies should not should really have independent directors. Thank you very much.
Thank you, sir, for your perspective, and once again, very valuable suggestions. And now requesting Dr. Ajay Bhushan Prasad Pandey, Chairman, NFRA.
Good afternoon. In fact, the topic today is for this panel discussion is reform measures in corporate governance, and so far and the way forward. And since morning, and in fact, I will refer to our finance minister's speech. I mean, it was a complete overview of what all has been done during the last several years, and then the series of reforms which have been particularly done in the areas of corporate governance. And you know, and we can see the impact today. So what I would like to emphasize here is that at the bottom of this corporate governance, you know, there is a very essential element of you know, the reporting, because unless and until there are the quality of financial reporting is good, then only one can have the good corporate governance, because the governance will come out of the reporting. Unless until you have information, then only you will be able to govern that. So that is why it was very, very necessary to have you know, the good reporting system. And here I would like to mention that you see, you know, during the last 8 years, you know, the adoption of you know, the international standards, you know, the IFRS and you know, those standards, and in a gradual manner we, you know, adopted them for the different class of the companies, and finally 2017-18, you know, this has been adopted for a certain class of company. Now this, if you see, is a very, very major reform. Why? You know, today the economy is global. I mean, you can't live in isolation. So just imagine any investor from anywhere in the world, and including the domestic investor, if he's going to put his money, he would like to know that, you know, the money that where he's putting, you know, I mean, at least it has a transparent system of reporting the financial result, financial statements, and also then the corporate governance. In fact, Praveen, my fellow panelists mentioned that many times the independent directors, they do not know that what is happening in the company, right? So there could be, and also sometimes if they know, then maybe they are conflicted or close to conflict, so they are not able to exercise their judgment. But the question is, if you don't have a reporting, then even if you are not conflicted, or even if you are independent, you will not be able to function very, very effectively. So that is why it is very necessary that we have a system, and that is why, you know, the system of monitoring, and first of all, the laying down of the standards, and that is where I must say that the, you know, ICAI role, I mean, even in this new system, I mean, the way both NFRA and the ICAI have adopted this complementary approach, you know, they are complementing each other. And that is how, you know, the system is maturing. And today we are arriving at standards which is acceptable to the ecosystem, to the Indian, you know, the companies, and as well as the global companies, because those big companies, the listed companies, and then companies with certain parameters, they have to follow the international standards. So that is where we have reached. You know, yesterday I was doing some study, and I came across a very, very important, you know, the data point. It's very interesting. You know, the FDI, you know, till about 15, 16, 16, 17, it used to be in the range of $40 billion US, $45 billion US. In this year, the report has come, it has gone to $83 billion US. So just imagine then the few years from 40 to $45 billion US. In 1 year, in 3-4 years time span, we have reached the level of 83 billion US dollars. But what is more important, it's not that, it has doubled in three years. What is more important, that our global share, the share in the global FDI used to be till 2018 2.2%. So in the whole world, with the 100, let's say the unit of FDI was there, our share was 2.2%. And that 2.2% share was there since almost 2009-10. And in 2019 onwards, there was a kind of an inflection point, and it started rising. And then the last year it was reported 6.6%. So three times increase in the global share in the FDI. What does it point out? And I must mention here that many countries, because you see, getting a such phenomenal increase in global share will come at the cost of some other country. And just imagine that some countries have to lose those shares, and that's how we will get those shares. So this is what has happened. And then the only country which has achieved the 3 times during this period is China. All other countries, including United States, Japan, every other country, many countries have actually declined, because their decline was our gain. So I was just, thinking that what all has been done. And then, I have been associated with the finance ministry for several years. So then I was trying to take a stock. Of course, the certain major reforms were done in the finance ministry, like, the corporate tax reforms, 2019. The GST came in 2017. The IBC also came during this period. Then, the Companies Act, the various amendments, decriminalization. Then, the many process reforms, such as, the small reforms, because, these deltas actually make a big reforms. Like, for example, having the system that the meetings could be conducted on video conferencing. So many such reforms came in. And then ultimately we can see the result. Even the CCI, for example, in fact, all of us are here. And if you see each of what we have done during the last, 5-6 years, and we can see the impact. And this impact, I would say, that this is the single factor, because what has happened is that this actually shows that how much world is trusting us. Our reporting system, our, the bankruptcy system, then, the entire corporate governance. So all those things are very, very important. And that is where I think, we need to continue this path, because there are many more things are to be done. For example, NFRA is in a very, very initial stage of, we are just 3 years old system. But then still, the adoption of the accounting standards, the standards of audit, the way, we are conducting review. And then, of course, we have the opportunity, because sometimes, we can say that, look, we are behind. But being behind actually could be very advantageous. I'll give you an example, because, then we can leapfrog. Like, in the telecom, I always used to say that, look, telecom, we did not have the landline phone. But all of a sudden, we leapfrogged, and then everybody had a wireless phone. Similarly, in Aadhaar, when I was working, we did not have an ID. The country of 130 crore people did not have, very 1 or 2%, 3%, 5% people had an ID. But all of a sudden, we leapfrogged, used technology, and then, all of us have, biometric-based digital identity. Similarly here, now that, we are the latecomer, we can take advantage of what all has happened in the world, and then assimilate all those best global practices. And then, we can actually, reach to the level and go even beyond that. So that is something like, the PCAOB, it was established in 2003. Then are we going to take 19 years to reach there? No. Our job should be that, in next 2-3 years, we should be able to reach to that level and go beyond that. And of course, we will set up our systems, we will use the technology, and we will do that. So I think this is the point that I was trying to mention, that we must continue with this corporate, the reforms, whether it is in the process, in the IBC, or it is in the reporting, or it is developing those institutions, which, Ravi just now mentioned, and, Praveen, so, or the competition commission. So all those are very, very essential component, and then we need to, go forward. Thank you.
Thank you, sir. May I now request Shri Ashok Kumar Gupta, Chairman CCI, for his views.
Good afternoon. See, what is corporate governance, good corporate governance? It is based on sound management principles. And sound management principles means compliance with the various laws of the land. So that enables the company also to take prudent decisions. But what is more important, internally we can have good corporate governance, they can take sound and prudent decisions. But they can only flourish if the external environment also is conducive. If the external environment is not competitive, if there are firms which are cartelizing, if there are firms which are creating entry barriers, if there are firms which are abusing dominance, then howsoever good corporate governance is there, company cannot flourish. New players cannot enter. Startups cannot come. So the role of CCI, Competition Commission of India, in that manner assumes a lot of importance. We frown upon cartelization. We frown upon abuse of dominance. In the short run, the companies may think that through cartelization they may gain. Through abuse of dominance they may gain, but it doesn't happen. Why it doesn't happen? Because they stop innovating. They stop cutting down cost. They start acting independent of market forces. And ultimately, their corporate governance also goes down. So I feel that competition law and corporate governance, there is a lot of synergy between the two. They are two sides of the same coin. And the relationship is bidirectional and they reinforce each other. Competition Commission of India, we do market corrections. We create an environment. We ensure that there are new entrants. They should come. They should give competition to the existing incumbents also. So that ultimately, consumer should be the beneficiary. Otherwise, a few firms can take control of the entire sector. And these firms ultimately, though they may survive initially in the domestic market, but think about global situation, they will not be able to compete globally. So, a number of firms which have, I think, helped in growth of economy, they have not been able to compete globally precisely because of the reason that they have not brought efficiency in their working. Merger and acquisition is a very potent instrument for scaling up and bringing efficiency. If our firms have to ultimately have global footprint, they have to ensure that they take advantage of the merger and acquisitions, but at the same time, they cannot destroy the competitive environment of the country also. So our firms need to think globally how they can become national player, international player. And for that, good corporate governance is extremely important. They have to have competition compliance in their corporate governance itself. I think this due diligence they should do in the beginning itself. Yes, are we competition compliant? And then only they can take prudent decision which will help them domestically as well as internationally. Thank you very much.
So, ladies and gentlemen, we heard from our panelists very progressive views and their suggestions on effective corporate governance in the greater interest of the businesses, society and nation. And now I request our respected Secretary, Ministry of Corporate Affairs, Shri Rajesh Verma ji, for the concluding remarks.
Good afternoon. I'm really thankful to all my esteemed colleagues here who have given their valuable suggestions and guidance on the topic reform measures in corporate governance so far and way forward. And over the technical sessions today we had, I'm sure, a lot of valuable suggestions would have emerged. During this entire week, we will be discussing at various forums, and all the organizations of the ministry, they are organizing these interactions, sessions all over the week, during the entire week from 6th, from yesterday till the next Sunday, that is 12th of June. So I'm sure we will, after we get all these suggestions, we will be also analyzing those suggestions, and as guided by the Honorable Minister in the morning session today, for the Amrit Kal, the corporate governance has to actually, we have to take it to a different level if we have to really emerge as a global leader in the field of corporate governance. There are many facets to this entire, it's such a vast topic, difficult to actually encapsulate in a very short time also. So maybe we touch up on some salient points. One of the salient points is like still the economy, in the economy we see the more of the businesses, we have mostly family run businesses, and proprietorships and partnerships still dominate the this mode of businesses in this country. While we have hardly 15 lakh active companies, the number of MSMEs in the proprietorship and partnership mode are almost 2 crores. So the even more in fact. So it is we have to really move to an organized and structured form of corporate governance. We have made provisions like proprietorships can move to one-person companies, OPCs. The partnership can move to LLP. The LLP Act was framed in 2008. Similarly, we have to take cognizance of what the global best practices are happening and the other structures of the corporate governance which are emerging. Like you must have heard of SPACs coming, the concept of variable capital companies also. And so we have to, if we have to really move to the global standards, global levels, then we have to see the trends and keep abreast with those trends and also take measures to evolve these structures. The role of ministry and the regulators to actually provide a framework for evolution of such structures. And the other point is like technology will be a game changer. It is already proved. And in future, in the Amrit Kal period, next 25 years, we can't even actually envision also what level it will reach. It is, and the way it is progressing exponentially, it is changing the whole gamut of activities around us are changing. So we have to actually now respond to this changing scenario in a very, very active, proactive manner rather than a reactive manner. So that is another challenge. Right now we are moving from version 2 to version 3 of MCA 21, which was the first mission mode project of e-governance. Now, while we are implementing version 3, when we actually started planning 2-3 years back, and that time we thought the kind of AI, ML, and these kind of tools which we thought is quite futuristic, I would say that while we are in the process of implementing, the world has gone still further. So now we have to really catch up. And so that is another challenge. And now all the agencies, all the regulators, we have the, it is not possible to monitor or even to have a light touch regulation without without the use of most advanced e-governance tools. Almost 1 crore filings we have on the MCA 21. I mean, it is not possible, humanly not possible to actually see. So you need a lot of supercomputing to actually do data analytics and do the kind of surveillance and monitoring, etc., which is required for a robust corporate governance. Even that is also very important. Apart from that, a lot of other regulators, I mean, there are other regulators who are while discharging their functions, are also using this data. So there will be a need for some sort of a data integration, and so that the databases of all the regulators, they start talking to each other, and there is a robust network of the database. We had started some exercise, single source of truth, so that not only it will help in better regulation, it will also help in reducing the compliance burden and enhancing ease of doing business. Because same company has to file so many returns, so many forms with different regulators, and maybe some of the fields are very common, and that's what we found out also. Many fields are common, but still he has to keep on filing and all. So why we have to promote ease of doing business. We cannot burden our companies to with so much of compliance burden. That is something. So that is also one of the focus areas of the government. Like morning also it was pointed out in various speeches also, like decriminalization of laws which has happened. That is an ongoing area, and will continue to be the focus of the government, to have ease of doing business and ease of living for the lawful corporate citizens. Then there are then we have to keep abreast of the trends which are happening, like ESG framework. ESG framework we have adopted. BRSR already there for 1,000 companies. SAB has from this year mandated, but that is something which will be very important for investment, attracting investment. So that is something which would need to evolve, continue to evolve over a period of time. The CSR activities have also, like we have seen in the morning, 1.2 lakh crore already in last 5-6 years. So and almost 25,000 companies and almost 20,000 crores, more than that, every year is the, so it's a very substantial, so robust mechanism for that is evolving and will continue to evolve. In fact, last 6-7 years, ever since the new company law came into being, and after that the IBC and other laws have come, we have seen growth of many professionals, many professions. And even among the existing professions like chartered accountant, company secretaries, and cost accountant, the growth is tremendous, and the potential is also tremendous. I mean, you are having chapters not only within the country but outside also, and we have evolved very strong professions, and where we are not only giving advisory services to our companies within the country, but even outside also. And that is another, because of our unique demographic advantage which we have, we can really provide these services all across the globe. That is another growth opportunity, tremendous growth opportunity we have. Other professions also come in the meantime. Resolution professionals, new professionals, valuation professionals, they have come. Of course, valuation also offers a challenge. You have, it is not really a regulated profession so far. So that is another challenging area, that how to really regulate valuation professional in under one umbrella. umbrella regulation. So that is another challenge. Of course, insolvency law is still evolving. It's only 5-6 years since it has come into this thing. Many areas which we are working and will continue to work on that. CCI chairman has hinted about the competition laws. There also the challenges of new age technology, new forms of cartelization, and new forms of abuse of dominance which are coming. These are challenges we have to, in order to provide ecosystem, our laws will have to evolve and get refined so that we meet the evolving challenges. So there are many areas, in fact, since the time is very short, so, but I'm sure this week, iconic week, we are busy in our affairs on a day-to-day basis, but this week has come as a very good opportunity for us to actually look back on our achievements over the last 75 years and also look ahead 25 years and see where we have to take corporate governance. Thank you all for participating in this event.
Thank you, sir. And now, as the gracious host of the iconic day celebrations of MCA, and as the chair of this session, may I request you to kindly present the mementos to our esteemed speakers. Thanking Shri Ashok Kumar Gupta ji. Appreciation and gratitude to Dr. Ajay Bhushan Prasad Pandey. Thanking Shri Ravi Mittal. And thank you to Shri Praveen Kumar. And so with the group photograph, we close the session as well as close for the day. जैसे भी सर आगे बेटर रहेगा वैसे. So with this, ladies and gentlemen, a big thank you to all of you also for your active participation. We conclude the day. We have arrangements for high tea outside. Please have your high tea. And I'm sure throughout this week, the various institutions are organizing their respective programs. So the work towards bringing in good corporate governance and realizing our India at 100 vision continues with all the departments and the institutions. Thank you again. Please join us for high tea.